ಅದೇ ಪೋಸ್ಟಿಂಗ್ ಬೇಕು ಅಂತ ಕೇಳ್ತೀನಿ ನಾನು. ಪೋಸ್ಟಿಂಗ್ ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ. Sir, last April, ఇది రాష్ట్రానికి రాష్ట్రంలో
First my friend.
Hello, very over sir. You connect it to the mobile. The light side there, light is there. The instrument light to the microphone, sir.
The mentionings from video. Memos from the left side, please. You filed application. Yes. Challenging the. Ah. Yes.
Not for permission to withdraw the money deposited with the petitioner before the court.
Ah.
The application and copies also served on the complaint advocate.
Withdrawal of the amount. Next week. Yes.
This case is arising out of the DB Act, my lord. So FLW already been issued. The petitioners are mother-in-law and father-in-law of the respondent number 2, my lord. Tomorrow it may be listed, my lord.
Monday.
Much obliged.
Last time ಇರಿ ಅಂತ ಹೇಳಿದ್ದು ಮತ್ತು ಅದೇ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಿದ್ದೀರಿ. ಮೆಮೊ ಇದೆ, 1 ನಿಮಿಷ ಇರಿ.
I represent the petitioner in this matter. The FLW was issued by the trial court against petitioner. The respondent is the mother. DV.
Monday.
Mother has filed a case against her.
Yes. What is the offense? Next week. Yes, mentioning. Any mentioning, please. Yes.
For the petition.
Yes.
Petition. This is arising for the PCI, where my application for discharge was not allowed. This way taken time to file application. With discharge.
Yes. Any mentioning?
Lordship, serial number 38 appearing for the respondent, my lord.
Yes.
My senior has some personal inconvenience today, my lord. I pray for short accommodation. 38, my lord.
The counsel for the petitioner prays for time. This shows that the petitioner doesn't have urgency on IA 1/22. Hence, list this matter after 3 weeks. Any early posting would be only after bringing today's observation to the notice of the court. Yes.
My lord, may I make on submission, my lord?
Serial number 13. Make the mention in the matter reaches. Yes. Make the mention in the matter reaches. Yes.
Serial number 39, my lord. Another matter. We are appearing for the petitioner, my lord. I pray for short accommodation in this matter, my lord.
How come you appear for the petitioner in both the matter?
My lordship, serial number 38 appearing for respondent, 39 appearing for petitioner. My lord.
The respondent say you cannot seek time there. There is an IA for interim order. IA for interim order. You cannot. 38 tagiri. 38 order na 39 game. 39 order tagiri. Learn counsel for the petitioner place for time. With a matter of 3 weeks as paid. Any early posting would be only after bringing today's order to the notice of the court. Yes. Yes.
My lord, serial number 24, my lord. 24 and 24.1.
Serial number? At the request of the learned counsel for the petitioner, a week's time as paid is granted as finally. Yes.
Serial number 23, my lord.
23. Yes.
Please for one week
Same
time.
order. Yes.
Stand in the serial number 20 notes.
20. Yes. Same order. 1 week finally. Yes.
My lord, serial number 24 and 24.1.
25.
Yes. Same order. 1 week finally. Yes. Call the cases.
Complaints office objection. First time, serial 1, Petitioner Kumar S.
This is for the petitioner, my lord.
1 and 2, 1 week.
I appeal for the petitioner's counsel.
Yes.
There is urgency, and the office objections can be rectified in 2 seconds. One office objection is now very like now pending on the file and K by mistake has been added.
ನೀವು ಬಹುಶಃ ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ಆಪಾಟಿ ಜಗಳ ಮಾಡಿರ್ಬೇಕು ಕೆಳಗಡೆ.
And that is only one office objection. The other one is in the IA for stay.
Do one thing, let him comply the office objection, get the matter listed tomorrow itself, no
Please,
problem.
the urgency, if I may take only 30 seconds, the urgency is the learned sessions judge at the instance of the accused alters the charge, which is not permissible. Offenses under section 5 and 6 of the 4 and 6 of the POCSO Act and 376 has been deleted. Now, after deletion, the charges are diluted and charges, altered charge for sections 10 and 11 have been freed, which carries a maximum sentence of 3 years. On the basis of altered charge, they have quickly moved for bail and it is posted tomorrow. So the accused would be granted bail. Accused is the father, mother is the complainant. Charges are very serious.
Who is the petitioner here?
Petitioner is the complainant. She has challenged the order of the learned special judge, altering the charge, which is not permissible at the instance of the
You
accused.
get the matter listed tomorrow, comply the office objection today.
Could your lordships give a date? He will comply it right away because they can be complied here itself.
Complaints has to be done in the
Please,
registry.
that would be done.
Comply the office objection,
Yes.
let the matter come tomorrow.
Please, your
Yes.
lordship, kindly.
At the request of the learned senior counsel appearing for the petitioner, submit that needful would be office objection to be complied during the course of the day. If the office objections are complied during the course of the day, list this matter on 7/7. Yes.
Grateful.
Second time office objection. Serial number 3, Ravindra PS.
Appear 1 week.
Serial number 4, Kabir SN.
3, 4, 5 finally 1 week.
Serial number 3rd and serial number 6, Anup Bharadwaj.
None appear. As a last chance, 4 days time is granted to comply office objection, making it clear that in case the office objection in their entirety are not complied within the 4 days from today, the court may proceed to pass appropriate order, including dismissal of the petition for non-compliance of office objection. In case the office objections are not complied with, the registry to list this matter on 12/7. Yes.
Serial number 7, Lakshmi Narayan Shetty. LR. Serial number 8, K. Ravi Shankar. Serial number 9, Shrikanta KS.
Next time.
300 rupees per day cost, maximum 7 days. How many days you want?
What is time? Within Monday, I will come there.
The counsel for the petitioner once again prays for time in this matter, where sufficient time has already been granted. As such, imposing a cost of rupees 500 payable by the petitioner to the Legal Services Committee of this court within 2 days from today, and filing a complaints memo along with receipt in the registry within the said time. As a final last opportunity, 4 days time as paid is granted. In case the office objections are not complied, list this matter on 12/7. Yes.
Serial number 10, Parmeshwarappa city.
I compared on 30th June, my lord. And I paid the amount before the reissue, my lord. I could not file the memo before this honorable court.
When did you pay the cost?
30th June.
You have not filed the memo with receipt in the registry.
I could not file the memo, my lord.
Personal inconvenience ಬರ್ತದೇನ್ರಿ ಅದಕ್ಕೆ?
I completed all the
ಏನೋ ಒಂದು ಕಾರಣ ಹೇಳಿ ಬಿಡಬೇಡಿ.
office
ನನ್ನ ಬೇಜವಾಬ್ದಾರಿಯಿಂದ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಹೇಳಿ ಪ್ರಾಮಾಣಿಕತೆಯಿಂದ. ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಏನು? ಇಲ್ಲಿಗೆ ಬಂದಿರ್ತೀರಿ, ದುಡ್ಡು ಕಟ್ಟಿರ್ತೀರಿ, 2 ಸೆಂಟೆನ್ಸ್ ಗೀಚೆ ಅದನ್ನು ನಿಮಗೆ ಇಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಕ್ಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್. ಬಹಳಷ್ಟು ಪದಗಳು ಬಹಳಷ್ಟು ಉತ್ತಮ ಅರ್ಥಗಳನ್ನು ಹೊಂದಿರುತ್ತೆ. ಅವನ್ನೆಲ್ಲ ತೀರಾಭಾರ ಸಾರ ಸಗಟಾಗಿ ಅತ್ಯಂತ ಮೀನಿಂಗ್ಲೆಸ್ ಆಗಿ ಬಳಸಬಾರ್ದು. Still, there are outstanding office objections. You have not completed office objection in total.
Complete all the 30th I will complete all the 30th June.
The counsel for the petitioner physically present and submits that due to his personal inconvenience, he could not file memo of paying the cost in the registry. Though in fact, though he has paid the cost on 30/6/2022 itself. He further submits that on the very same day he has complied all of his objections. Perusal of the order sheet would go to show that 2 more of his objections are yet to be complied with, which of his objections were raised at the first instance much prior to 30/6/2022. As such, in spite of granting sufficient time and imposing cost, the petitioner has failed to comply the office objection in toto. The petition stands dismissed for non-compliance.
Serial number 11, Manjunath V, Somshekhar KM.
No objection, no color, my lord. The minor office objections, I paid the cost also. Shekhar K. I have filed our color. Cost also paid. I will file the memo along with deal will not before registry. The minor office objections were not.
Now, when have you paid cost?
Not yesterday.
You are supposed to pay cost much earlier, right?
17/3/2020.
Yes.
But earlier council, I have filed our color, my lord.
Office objection still not complied.
File ನನಗೆ after filing ವಕಾಲತ್ my lord, I have not received in way of
That cannot be,
excuse.
that cannot be a valid excuse at all. ಇಲ್ಲಿ ಎಲ್ಲ ಒಂದು ನೋಷನ್ ಏನಿದೆ ಅಂದ್ರೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ವಕಾಲತ್ ಹಾಕಿಬಿಟ್ಟಿವೆ ಅಂತ ಹೇಳಿದ್ರೆ ಪ್ರೀವಿಯಸ್ ಇರ್ರೆಗ್ಯುಲಾರಿಟಿಗೂ ನಮಗೂ ಸಂಬಂಧವೇ ಇಲ್ಲ, ನಾವು ಅದಕ್ಕೆ ಆನ್ಸರಬಲ್ ಅಲ್ಲ, ಅಕೌಂಟಬಲ್ ಅಲ್ಲ ಅನ್ನೋ ನೋಷನ್ ಅಲ್ಲಿ ಇರ್ತೀರಿ.
ಟೈಮ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಸೆಮಿಸ್ಟರ್ 21/4 ನಾನು ವಕಾಲತ್ ಹಾಕಿದೆ, ಅಷ್ಟೊಂದು ಟೈಮ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. 73 ನಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೆ. I have filed Wakalat on 21. The minor
So, ಈಗ dismiss ಮಾಡಬಹುದು. You have no objection for dismissal of the petition for non-compliance.
already is minor compliance.
ಆ ಮೈನರ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗಳನ್ನೇ ಇವತ್ತಿನವರೆಗೆ ಮಾಡಲಿಲ್ವೇ? 2.5 ವರ್ಷ, 2.5 years. ಪಕ್ಕ 30 months. Prayer to be proper. Petitioner name to be mentioned. 30 ತಿಂಗಳು. Our opportunity. The counsel for the petitioner submits that he has paid the cost. ಯಾವಾಗ ಕಟ್ಟಿದ್ದೀರಿ?
Deposit.
Cost only on cost which was ordered on 17/3/2022, only on 5/7/2022. Thus, there is an enormous delay in payment of the cost. Admittedly, the complaints of office objection to comply which the time was extended by imposing the cost has also not been complied with. Hence, though this petition could have been dismissed for non-compliance of office objection, however, considering the submission that the present council has submitted is no objection Wakalat recently, imposing an additional cost of rupees 1,500 payable by the petitioner to the Legal Services Committee of this court during the course of the day, and complying office objection within 3 days from today as an ultimate chance. 3 days time from today is granted to comply office objection. The compliance of office objection would be only after payment of the cost imposed today and filing a complaints memo along with receipt in the registry to that effect. In case the office objections are not complied in toto, list this matter on 12/7.
Orders matters number 12. Anil Ghosh.
It's ready. I just need to file the process. I file it now. Process is ready. I'll just file it now. Process memo is ready. I'll file it in the counter memo.
Counsel for the petitioner submits that they would do needful during the course of the day. In case the needful done, registry to proceed further in the matter.
Number 13, A. Kumarvel.
An appeal for petitioner, hence the matter could not.
Number 14, Shawaz Pasha. Petitioner Nur Muhammad for respondent.
Retirement memo ಕೊಡಿ. None appear in this matter. Petitioner called out, he has remained absent. An abundant caution. Issue emergent court notice to the petitioner. It is null by.
So number 15.
Same order.
Hearing on irrelevant application, serial number 16. K. Venkatramana, GT Girish.
What is it? Will be here, my lord. Kindly pass over. Please pass over. Party is perfect. ಕೆಳಗಡೆ ಇದೆ.
Request of the learned counsel for the petitioner, matter is passed.
Serial number 17. Rajshekhar PG, Dhananjay CM, correspondent.
Appearing for the petition, Your Lordship. I pray for short accommodation, Your Lordship, 4 weeks' time. Because petitioner has been admitted to the hospital. He is in ICU. Due to high BP, he got a brain hemorrhage. He's been admitted to the hospital, Your Lordship.
So you never want to put a peaceful end to your litigation.
Your Lordship, this is the thing. It is in the YouTube. Everything it is there, Your Lordship. Petitioner has been admitted to the hospital because of the brain hemorrhage. He got admitted in the ICU.
I beg to appear for respondent, my lord.
Yes, please. What is your submission in the matter?
I also came to know that he has suffered ailment and he is in hospital, my lord. So I will leave it to my lord.
The counsel from both sides present. Learned counsel for the petitioner. Submits that the petitioner suffering from serious health ailment, including brain hemorrhage, and is admitted to hospital. Praise for 3 weeks' time. The time as prayed is granted. Before proceeding further, it is required to see the previous order sheet, including the one dated 4/7/2020. Yes.
Number 18. Bharat Kumar, India. Anjane AB, correspondent.
Yes, Swami. Need to file an objection to the limitation application. Keep it ready. Party is not is on the way to sign the objection statement. Kindly 5 minutes also of the matter. Please. Because of 641 days delays.
ನೀವು ನಿಮ್ಮ ಪಾರ್ಟಿ ಬರಲಿಕ್ಕೆ ಕೋರ್ಟ್ ಕಾಯ್ಬೇಕು.
4-5 ದಿನದಿಂದ ಅವರು ಅಮರಾವತಿ ಅಲ್ಲಿ ಆಂಧ್ರ ಪ್ರದೇಶ ಅಮರಾವತಿ ಹೈಕೋರ್ಟ್ ಲೇಟ್ ನೈಟ್ ರಿಟರ್ನ್ ಆಗಿದ್ದಾರೆ. ಸುಮ್ಮನೆ ವಿ ಆರ್ ವೈಟಿಂಗ್ ಫಾರ್ 4 days to sign that he is coming. So late night he returned from Amravati.
Since the petition respondent has not filed that objection to IA-1/21, it is taken that
I will file everything
is not filed. Lift the matter. Yes.
Serial number 19. Nagraj Hegde, Ravi Shankar KP, correspondent.
Yeah.
Yes. Only request. Already we have taken more sufficient time. Come Lord, yes, come up, Lord, check, post-dated check, it is dated 12/7/2020. Say, loan, my Lord, obtained by, it will be honored, my Lord. Then, my Lord, you will pay the amount in 1 week thereafter. It is only sufficient, Lord. I am not able to.
In case the check expected by you either is not given to you, or even if it is given to you, or if already has been given to you, if the same is a dishonor, then how would you fulfill the condition?
Yes, my Lord, I have already specifically advised my client. Only one final, my Lord, application will be filed up. That to, my Lord, the assurance statement, it will be honored. It's a bearer check, my Lord, office bearer check, it will be honored.
So these kind of conditional aspect you cannot mention in the application.
It is the only option, my Lord.
Sir, your client may say so. As a counsel, you are not supposed to mention it.
Yes, my Lord, already.
Client says 100 things because they are not aware of the legal aspect.
Please.
How can you to comply the direction, make your undertaking a conditional one? It is for your advantage, your benefit, the interim order of stay has been granted.
Please. It's one of the ground. Final 2 weeks time may be granted, my Lord.
Maximum 6 days at the cost of ₹2,000 per day. I am making certain observations also in my today's order.
Before 15th, my Lord. 15th of this.
₹2,000 per day, 6 days. All the time, what you are prayed were all granted to you. On the last occasion, imposing ₹500 per day, it was asked you how long you want. You sought for 2 weeks. 2 weeks time was granted to you.
Not.
Repeatedly, this extension application you are filing.
Before 15th, my Lord. 15th. It will be.
Today is 6th. 15th means ₹18,000.
10,000.
You cannot bargain.
Only
If you
request.
are say paying 10,000, it is 5 days only.
Already, my Lord, I have paid the, my Lord, 500 rupees cost.
Exactly, sir. ಅಷ್ಟಾದ್ರೂ ಬುದ್ಧಿ ಬರಲಿಲ್ವೇ? ನನಗೆ ಅದು ಆಶ್ಚರ್ಯ ಆಗ್ತಾ ಇದೆ. ಸರ್, ಅಲ್ಲಿ ಹಿಂದಿನ ಪೊಲೀಸರಿಗೆ ನಾನು ಆಲ್ರೆಡಿ ಫೈನ್ ಕಟ್ಟಿದ್ದೇನೆ. ಬೆಳಗ್ಗೆ ಹೊರಟಾಗಲೇ ಹೆಲ್ಮೆಟ್ ಇಲ್ಲ,
ಜಂಪಿಂಗ್ ಟ್ರಾಫಿಕ್ ಸಿಗ್ನಲ್ ಅಂದ್ರು ಫೈನ್ ಕಟ್ಟಿದ್ದೇನೆ, ಈಗ ಮತ್ತೇನ್ ಕೊಡ್ಬೇಕು ಸರ್ ಫೈನ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಯಾರಾದ್ರೂ ಒಬ್ಬ ಟೂ ವೀಲರ್ನೋ ಅಥವಾ ಮೋಟರ್ ರೈಡರ್ ಹೇಳಿದ್ರೆ ಎಷ್ಟು ಬಾಲಿಶ ಅನ್ಸುತ್ತೋ ಅದು ಅವನ ರೀಸನಿಂಗು. ಇದು ಹಾಗೆ ಆಗ್ತದೆ. ಆಲ್ರೆಡಿ ನಾನು 500 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ ಅಂತ ಹೇಳಿದ್ರೆ
500 ರೂಪಾಯಿ just my submission.
ಆ ಸಬ್ಮಿಷನ್ ಆಸ್ ಅನ್ ಅಡ್ವೊಕೇಟ್ ತಾವು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ವಕೀಲ್ರಿ. ಐ ಮೇಕಿಂಗ್ ಎ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಎ ಲಿಟಿಗೇಂಟ್ who is not aware of the legal aspects and a learned counsel. ಆ ಕ್ಲೈಂಟ್ ನಿಮ್ಮ ಹತ್ರ ಹೇಳೋದು ಸರಿ ಇರ್ತದೆ, ಸರ್ ಆಲ್ರೆಡಿ 7,500 ರೂಪಾಯಿ ಕಟ್ಟಿ ಬಿಟ್ಟಿದ್ದೀನಿ ಸರ್, ಏನಾದ್ರು ಮಾಡಿ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡಿಸಿ ಸರ್, ಫೈನಿಂಗ್ ಏನ್ ಬೇಡ, ಹಾಗೆ ನಂಗೆ ಟೈಮ್ ಕೊಡಿಸ್ರಿ ಅಂತ ನಿಮ್ಮವರೆಗೆ ಅವನ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬರೋದು ಕರೆಕ್ಟ್. ನೀವು ಅದನ್ನ ಅಲ್ಲೇ ಫಿಲ್ಟರ್ ಮಾಡಬೇಕು. ಅಯ್ಯ ಇದು ನೀನ್ ಹೇಳಲಿಕ್ಕೆ ಚೆನ್ನಾಗೆ, ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಗೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ದಂಡ ಹಾಕಿದ್ರು ನಿನ್ಗೆ ಬುದ್ಧಿ ಬರಲಿಲ್ಲ ಅಥವಾ ನೀನ್ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಕೊಳ್ಳಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ನನಗೆ ಮುಜುಗರ ಆಗುತ್ತೆ. ಅಂತದ್ರಲ್ಲಿ ಟೈಮ್ ಕೊಡ್ತಾರೆ ಬಿಡ್ತಾರೆ ಗ್ಯಾರಂಟಿ ಇಲ್ಲ. ಟೈಮ್ ಕೊಟ್ಟರು ಅವ್ರು ಏನೆಲ್ಲ ಕಂಡೀಷನ್ ಹಾಕೋದು ಏನ್ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲಪ್ಪ. ಐ ಮೇ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಎ ಚಾನ್ಸ್ ಅಂತ ಅಷ್ಟನ್ನೇ ನೀವು ಹೇಳ್ಬಹುದೇ ಹೊರತು ನೀವು ಅವ್ನು ಹೇಳಿದ್ರೆ ಯಥಾವತ್ ಹೇಳಿದ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಂಗೆ ವಕೀಲರ ಬಗ್ಗೆ ಸೋಜಿಗ ಅನ್ಸುತ್ತೆ. ₹2,000 ದಂಡ ಹಾಕೋದಂತೂ ಗ್ಯಾರಂಟಿ ಪರ್ ಡೇ. ಎಷ್ಟು ದಿವಸ ಬೇಕು ನೀವು ಲೆಕ್ಕ ಹಾಕೊಳ್ಳಿ. ನನ್ನ ಪ್ರಕಾರ 6 ದಿವಸ ಮ್ಯಾಕ್ಸಿಮಮ್ ಕೊಟ್ಟರೆ ನೀವೇನಾದ್ರೂ ವ್ಯವಸ್ಥೆ ಮಾಡೋದು ಒಳ್ಳೇದು. ಯಾಕಂದ್ರೆ ₹12,000 ದಂಡ ಮತ್ತೆ ಕಟ್ಟಬೇಕಾಗ್ತದೆ. ನೀವು ಹೇಳ್ದಂಗೆ ಇನ್ನು 10 ದಿವಸ ಕೊಡ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ₹20,000 ದಂಡನೇ ಆಗ್ತದೆ. ಯೋಚನೆ ಮಾಡಿ. ನಾನು ಅದಷ್ಟನ್ನು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರೆಸ್ತೇನೆ. ಇಷ್ಟೆಲ್ಲ ಆಫರ್ಗಳನ್ನ ನಾನು ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಕೊಟ್ಟೆ, ಅವರು ಈ ಆಪ್ಷನ್ ಚೂಸ್ ಮಾಡಿದ್ರು ಅನ್ನೋದನ್ನು ನಾನು ಬರೆಸ್ತೇನೆ.
Already advised him a lot.
ಹೌದು, ಅವರಿಗೆ
You have to be prepared for the consequences. I already advised him.
I am not finding any fault with you. I am only concerning more than you about your client.
I already advised him whatever. My one submission not since not is when the date of 12th on or before 15th, 15th up to 15th not the time may be only.
Learned counsel for the petitioner physically present, learned counsel for the respondent not present. The respondents have not filed their objection. The respondent has not filed his objection to IA-15/2022. There is the IA-5/22 filed under section so of seeking once again the extension of time to comply the terms of interim order dated 22/3/2022. Here is the application or the submission of the counsel for the petition. The counsel for the petitioner reiterates the contents of the application and the affidavit. Application affidavit had query. You have not even got an affidavit filed by the party. Yes, you are verifying affidavit. Application affidavit. Before proceeding further, the observation is made and order passed on 26/5/2022. We kindly be gone through. Next line. The petitioner has challenged the confirmation of his conviction for the offence punishable under section 138 of the NI Act, wherein he has been imposed a fine of ₹50,10,000. Next line. Allowing the interlocutor application filed by him seeking suspension of sentence, this court
has passed a conditional order on 22/3/2022 and directed the petitioner to deposit 50% of the fine amount within 4 weeks from the said date. And subject to the same, the sentence imposed in the revision petition was stayed. Thereafter, the petitioner filed IA 3/22 seeking extension of the time to complete the terms of the interim order. Accordingly, the said IA came to be allowed on 22/4/2022. 2 weeks time as paid was granted. In spite of getting such a long time to complete the terms of the interim order, the petitioner repeated one more similar application through IA 4/2022, seeking 2 more weeks time to complete the direction. In that regard, the court passed a detailed order on 26/5/2022 and offered the petitioner to select the number of days he wants to complete the terms of the interim stay order. However, subject to he paying a cost of ₹500 per day. The petitioner chose 2 weeks time to complete. Accordingly, imposing a cost at the rate of ₹500 per day, 2 weeks time as paid was granted. Now the petitioner has come up with third successive application in the form of IA 5/22 seeking once again further extension of time by another 2 weeks. Another 2 weeks. Except narrating that what has transpired earlier, the petitioner has not shown any specific reason deserving him any extension of time. His only contention is that he is expecting a check for a sum of 15,000, 15 lakh to be encashed on 12/7/2022, and that after the said date, he would be in a position to deposit the 50% of the amount as ordered.
Not 50%, 15 lakh. That has been modified.
It is after the realization of the said check, he would be in a condition to complete the terms of the interim order dated 22/3/2022. Interestingly, even in the application also, the petitioner has not undertaken that at any cost he would complete the terms of the interim order dated 22/3/2022 within the said time, but had made his submission of complying the terms of the order dated 22/3/2022 also a contingent one, subject to a contingent one which is subject to the realization of the alleged post-dated check dated 12/7/2022. Which means the petitioner himself is not quite sure that at least on the said date, he would be able to comply the direction. Furthermore, apart from honestly seeking for an extension of time, he has attempted to find fault with an action at least have taken place by the complainant in the trial court in ensuring the issuance of non-bailable warrant. He has attempted to find fault with the trial court, stating that in the absence of a specific order vacating the interim order dated 22/3/2022, the trial court ought not to have proceeded further. in issuing FLW and NBW. When the very order subpara dated 22/3/2022 was conditional, that is, the stay of the operation of the order on sentence was subject to the condition now. The petitioner depositing 50% of the fine amount within 4 weeks. The non-compliance of the said term would automatically deprive the petitioner of enjoying the benefit of the said interim order was not understood properly by the petitioner. Considering all the above aspects, the court told to the learned counsel for the petitioner that as a special case, the court may, as an ultimate opportunity, grant 6 days time. That too subject to payment of a cost of ₹2,000 per day. Still, the learned counsel for the petitioner insists that he requires time up to 15/7/2022. In the above circumstance, though this court could have rejected the application and made it clear that the order dated 22/3/22 would not inure to the benefit of the petitioner. However, to give an ultimate opportunity to the petitioner, the time as played is granted, but subject to the payment of a cost at the rate of ₹2,000 per day. Accordingly, imposing a total cost of ₹20,000 payable by the petitioner to the Legal Services Committee of this court within 3 days from today and filing a complaints memo along with receipt and production the necessary documents before the trial court about the complaints of payment of the cost imposed, IA 5 or 22 is allowed in part, and the time up to 15/7/2022 is granted to comply the terms of the order dated 22/3/2022. It is made clear that non-payment of the cost and the non-compliance of the terms subject to which the order dated 22/3/2022 is made in toto, would automatically deprive the petitioner from enjoying the benefit of the order dated 22/3/2022, and the said order stands vacated on its own without any further order by this.
22/4/2022, the order has been modified, and my lord, he is permitted to deposit only 15 lakh instead of 50% of the fine amount. It has to be clarified. Otherwise, 50% will be insisted. On 22/4/2022, the order has been modified, and subject to depositing 15 lakh instead of 50%. That's modified. 22/4/2022.
It has not been modified specifically.
Instead of 50%,
some observation. That is all. Ali order dated 22/3/2022, and the further order dated 22/4/2022. Al ಎರಡು ಡೇಟ್ಗಳನ್ನು ಒಟ್ಟಿಗೆ ಹಾಕಿ. order dated, terms of the order dated 22/3/2022 and further observed, which was further observed on 22/4/2022.
Admission matters, seal number 20, 21 adjourned, seal number 22, PR Bagraj, K. Chandramohan for respondent.
Each time can be granted for reporting settlement already. In this matter, my lord.
Yes.
Already I informed my member friend for amicable settlement, my lord. Even my client is also agreed to pay that amount. 4 lakhs is a check amount, my lord. Already I advised my party to settle the dispute, my lord. He has also agreed, but he wants 1 week time to make the payment. There already 4 lakhs is the conviction amount. So out of that, already 2,05,000 is already paid as per the order of the Sarva court. Remaining 2,05,000 is there. So, inform my party.
Why don't you proceed with the merits of the case right now? This alleged settlement was already canvassed by you on the previous date. Therefore, it's not a fresh submission. It is a stale submission.
Only for making payment, not other thing. Let's my record my submission. Already inform my.
Your settlement itself can say that within 1 week you would make payment to him. ಮೆರಿಟ್ ಮೇಲೆ ಮಾಡಿ ಇಲ್ಲರೆ ಸೆಟಲ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಎಲ್ಲದನ್ನು ಕೊಟ್ಟಾಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೇ ಸಬ್ಮಿಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತಲೇ ಮಾಡಿದ್ರಿ. ಹಾಗಾಗಿ ಈಗ ನೀವು ಮಾಡೋ ಸಬ್ಮಿಷನ್ ಹೊಸದಲ್ಲ, ಇದು ಇಟ್ಸ್ ಓಲ್ಡ್ ಸಬ್ಮಿಷನ್ which was already made.
Make a submission.
Ready?
Monday, we will file a giant note. Don't want to. We keep the parties present on Monday, and file a giant note to the test.
There are counsel from both sides present. While reiterating their submission made on 23/6/2022, they submit that parties have already settled the matter and that they are filing a compromise petition under Section 147 NI Act, for which they require 3 days time. It was also brought to the notice of both the parties that as per Damodar S. Prabhu's case, the matter may also attract the payment of the grading cost upon the petitioner. List the matter on 11/7/2022 on the top of the list for either to report settlement or to proceed further in the matter on its merit.
Yes.
Seal number 23 adjourned. Seal number 24, Ashok N. Nayak, Devraju R for R1, SCG for R2, connected.
Statement.
And petitioner in criminal revision petition 853/18 is the victim petition filed for arrangement of I think punishment. The victim sustained injury under section 326 IPC. Life imprisonment is there, but only 2 years imprisonment has been imposed. And against a conviction judgment, accused also prepared appeal. And one of the victim also they prepared appeal, but both appeals are dismissed. Anyway, I filed a criminal appeal again, but it was a technical reason means the second appeal is not material. I got permission of the honorable court to get it converted to criminal revision petition, and this case is before the honorable court. Anyway, the life imprisonment is there. Okay, I admit case will be admitted as one part of the victim. I'm ready for argument also.
For the petitioner in criminal revision petition
6/20/2017, that is petition of accused.
Respondent state alone or present. Whereas counsel for the revision petitioner in criminal revision petition 853/2018 is not present. List the matter. The last week of this month, on which they subject to availability of the time, both parties address their argument on the main matter. Yes.
Seal number 25 adjourned. Seal number 26, N. Gautam Raghunath, KP Yashoda, SCGP for respondent.
I praise 6 times, Your Lordship. The trial court passed an order of proclamation. I filed an application for set aside order of proclamation, Your Lordship. Praise 6 times, Your Lordship.
Sir, you are not audible, sir.
I praise 6 times to. And for the petitioner, Your
For the
Lordship.
petitioner appearing through video conference, praise for time.
Praise 6 times to take.
The petitioner, even after getting the matter listed, consider a three working people himself is no paying for time, showing no reasons. This itself go to show that the petitioner has got no urgency and yet three working people. It also go to show that it also shows that the petitioner has not appropriately utilized the precious time of the court and has deprived another eligible matter from being listed today. As such, the cost of ₹500 is imposed upon the petitioner, payable by him within a day from today to the Legal Services Committee of this court and filing a complaint along with receipt to that effect in the registry. Any earlier posting will be only after bringing today's observation to the notice of the court. Yes.
Number 27, E.R. Pankajamani, S. Vishweshwaraya for respondent.
The trial court passed a proclamation order, Your Lordship. Hence, I praise time, Your Lordship.
मैं खूबसूरत ऑडियो सरी ला है
Still number 26 and Gautam Raghunath.
ಅದಲ್ರಿ ಅದಾಗಿದ್ದಲ್ರಿ ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಕೈಲಿ ಕೊಟ್ಟಿರೋದು ಹೇಳ್ತೀರ.
Still number 27, E.R. Pankajamani, S. Vishweshwaraya for respondent.
For revision petition here.
I pay for responding.
How long you take to address your argument, both sides?
Your Lordship.
How long you take to address your argument on the main matter itself?
And half an hour for me.
Half an hour. Then take a chance in the afternoon.
Your Lordship, we had on next Monday.
The counsel from both sides present.
Your Lordship, in the trial court, they'll be splitting the matter and that should be stayed at least. Next day,
We are not
finished. Next day is finished in the law.
Not taken any step.
No, if that the undertaking it is.
Both sides present. Reach this matter in the last week of the month. That's great. Yes.
Still number 28, A. Madhusudan Rao, R.B. Sadashivappa for respondent.
Hear and dispose of the matter in the week after next, finally. The counsel from both sides present. Since the trial court and session court records have been received, the main matter, if time permits, main matter itself can be heard and disposed of. This is the matter in the week after next.
Number 29, Kulkarni, Abdul Rashid, Roshan MC for respondent.
Responded to this. Now I could not secure anything. Let the matter may be gone.
I'll go on with the matter.
So you had given him an offer and he had accepted the offer.
But there was no,
Petitioner could not arrange for the money in time, my lord. That's it. It's
Now-
right.
now, my lords, the point is, my lords, the complainant in the trial court, my lords, is not accepting for the offer also, my lords. Due to the duration of the time which was taken by the petitioner, now he wants the complete fine amount, including that, my lords. Let him go with the merits.
There are counsel from both sides present. Both sides make submission that their respective parties have put an end to the negotiation for settlement as such. There's no possibility of settlement between the parties. If the matter is required to be proceeded further. If the matter in the week after next.
Lokesha MY.
Date will be fixed.
No, this is 2019 matter, 21 matter. It may take some time.
Seal number 30, Lokesha MY, Raghu MN for respondent.
For the petitioner.
Also for the petition alone, present and appear for respondent, hence the matter could not be proceeded.
Number 31, Muralidhar HM, BF Kumar for respondent.
Last time that it took time because the check amount is 1,60,000. Again to pay that check amount, my lord, but my party was not agreeable. But my party says that, my lord, if 2,50,000 is paid, because 3 lakhs is the punishment is awarded. So if 2,50,000 is paid, my lord, that she is agreeable for settlement. But the transaction is of the year 2005. So taking into consideration that she is demanding only 2 lakhs.
Petitioner advocate Hindu Coxie.
Muralidhar HM. Number 31.
Also for the petitioner, neither present physically nor through video conference. The counsel for the respondent alone present and submits that the settlement between the parties could not be arrived at. As such, the matter is required to be proceeded further. Next week or week after next.
Any.
The matter in the week after next. The cost ಬಂದಿದೆ ಏನ್ರಿ ಇದು ಇಲ್ವಾ ಬಂದಿಲ್ಲ ಹಾಗಾದ್ರೆ week after next ತೆಗಿರಿ call for PCR and ACR on urgent basis. List the matter immediately after receipt of PCR and ACR.
Seal number 32, Shankrapa S, SCGP for R1. Special counsel for R2, Jagdish.
The petitioner.
Yes, please.
Lodge, this is a suo motu complaint registered by the Yalandur police on 19/4/2018. Alleging that the petitioner has obtained a caste certificate dated 12/8/2013. The petitioner got married on 29/11/2012, my lord. One Vishwanath, who belongs to PSC community. Pertaining to that, she obtained a caste certificate, which was then been on inquiry. She joined the bank on 1/1/2015, my lord. Subsequently, she worked there for till 19/4/2016. She resigned. Her caste certificate was cancelled on 3/7/2018. The alleged offences on section 198/420 IPC read with 319 of SC and ST Act. Lordship may kindly peruse on to page 46, my lords. That is the caste certificate which is issued by the Tahsildar.
Is not the caste certificate. 46 is the statement of the accused. Your application.
The charge sheet, page 46.
46 is the last page of your application under section 227.
Document, page 46.
Page 46 is not the document. It appears that there is no document.
Yes, verified, my lord.
No, that document has got nothing to do. The fact remains that you obtained a caste certificate.
Please.
Showing you as scheduled caste.
Lords,
Showing you as a scheduled caste.
clearly, yes, my lords. My lords, I have to bring into your lordship says one aspect is that the village accountant, the revenue inspector, and the Tahsildar issued the caste certificate. And based on inquiry, they will issue the caste certificate, my lords. They have a statement which has been in page 50, my lords. My lords, may permit, I'll read it out. Read out, my lords. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸ
Whether the report of a revenue inspector or a certification by a Tahsildar would change the cost of a person against the principles laid down by law? That is the simple question involved here.
Please.
It's not in dispute that the Tahsildar has issued a certificate. Tahsildar might have issued a certificate. Tahsildar has issued certificate even with respect to your children also. But the question is, you are not entitled and eligible for such a caste certificate. You ought not to have applied for such a caste certificate. You obtained such a caste certificate, thus depriving the other eligible candidate from applying for the said post.
My lords,
When you are not entitled to any of the benefit of the scheduled caste, you being of an alleged upper caste lady, you have misused the process.
Lords, I have a submission to make, my lords. I have applied through online, my lords. There's an online application. Through an online application with all declaration, I have applied, my lords. Knowing to that fact, the Tahsildar issued the caste certificate, my lords.
Yes.
And based on inquiry from the Tahsildar, revenue inspector, and the village accountant, my lords.
Yes.
Copy of the online certificate has not been marked as a charge sheet, my lords, in which I have declared to what caste I belong previously. If I want to bring into your lordship's notice is that one important aspect that the village accountant and the revenue inspector goes to the house of the petitioner and they inquire. Get to know that she belongs to the particular caste.
It's not in dispute that say your birth was in a Lingayat family.
Please. I am not.
It's not in dispute.
No,
It's an
no.
admitted fact.
Yeah, admitted fact.
It is an admitted fact that you married a scheduled caste person.
Please.
It is an admitted fact that you applied for a position in a public sector enterprises based upon the caste certificate.
Please.
It is not in dispute that you got appointed.
But my lords, I only have there is a delay of from 2013. I obtained the caste certificate, my lords. I was employed on 2015, my lords. I resigned I gave a resignation on 19/4/2016, my lords. Subsequently, on 19/4/2018, a suo motu complaint will be registered.
Whether you resigning from the job would exonerate you from the alleged offense.
No, I resigned, my lords. On 19/4/2016, I have resigned from the employ. Got an employment in the Canara Bank as a clerk.
Canara Bank or Syndicate Bank?
Syndicate Bank, sorry, my lord. It's Canara Bank. Now it is Canara Bank, but it is Syndicate Bank as a clerk. My lord. So, one more submission. Yes. Post my resignation, that is on 19/4/2016. Post my resignation on 3/7/2018, my caste certificate gets cancelled.
But all of them were subsequent to your employment, right?
Please.
The fact remains that for obtaining an employment, you have made use of the caste certificate.
No.
You got an employment. You have declared that you belong to SC.
I declared.
Subsequently, you might have resigned or appointment cancelled or caste certificate cancelled. Everything was subsequent events. Yes.
But my lords, there is one submission without any malice involved. My lords, the petitioner did not have any malice to create such an obligatory thing to get employment. My lords. Did not have such intention. Because only for creating an employment, she has not done it.
Please be seated.
This honorable court on criminal petition number 8857 of 2018 passed an order, my lordship, pertaining to the same.
Same petitioner?
No, pertaining to the same issue, my lordship.
What it has observed?
It is observed for the file for quashing of the order, my lord. Pertaining to that, the petitioner and the quash, they have filed for quashing of the order pertaining that. One, the lady who belongs to a Brahmin community gets married to one of the scheduled caste community, and she applies for a caste certificate. Subsequently, she obtains a job, and then she'll be exhausted from her job, my lord. Later on, it has been observed by this honorable court, and then the petition has been quashed, my lord. On the order of the Supreme Court in any Hura versus Chandraj Jaipal Singh in 1972, 1 SEC 771, dated 2/2/1972, based on this judgment.
This is the relevant portion of the judgment.
Yes, please, Mr. CGP.
That's the only contention raised by the learned counsel for the petitioner is that nobody speaks about her earlier caste minutes. That's all the charge sheet witnesses speaks about earlier caste of the complainant, accused. And there is no dispute with regard to that. And the learned session judge also makes an observation with regard to that case. That the case of the prosecution is that though the accused belongs to Lingayat caste, thereafter on the ground that she married to a man belonging to scheduled caste, by producing the ration card, Aadhaar card, and other documents of her husband, she obtained a false caste certificate. And she joined the services of syndicate. The Supreme Court in its recent judgment reported in 2006 1 SEC case 344. It is discussed in para 10 of the session data. Which says the person, though she belongs to a higher caste, just because that she married to a man who belongs to scheduled caste, she cannot claim that she belongs to a scheduled caste and obtain a false certificate and see. That is the recent judgment on the Supreme Court. The other contention is that now raised by the petitioner is that she is innocent, ignorant of all these consequences. Therefore, she has to be discharged on this ground. The learned session judge.
Yes.
After para 13 of the session judge order, the learned session judge has considered all these aspects. Innocent, ignorance, everything is considered. All these grounds were answered by the learned session judge. And prima facie holds that there are material to proceed against the accused for the charged offences. Therefore, at this stage, the learned session judge is not expected to go into the detailed aspects of the case at the time of hearing of the charges. The time of deciding a discharge application. May read the para 13 of the session judge order. Para 13 of the session judge order, page 17 of the paper. Ignorance and innocence pleaded by the accused at the time of filing of the discharge application. Para 13. Basing on this principle of law, now I would like to discuss the facts of this case that the accused admittedly is a postgraduate lady. She completed MCOM degree, therefore she cannot be considered as an ordinary prudent woman. She is a master degree graduate and well versed with the knowledge. Therefore, presumption will also be arises in favor of the accused that she knows the law of this land. Therefore, she cannot claim that she was not aware of the law. That as she belongs to the higher community, Lingayat community, by marrying one with Vishwanath who belongs to scheduled caste community, she acquires the caste of scheduled caste community. Further, at this stage, on the basis of material and documents produced by the prosecution, it clearly goes to show that the accused has obtained the said caste certificate by submitting the documents of her husband, who obviously belongs to scheduled caste community. Therefore, the intention of the accused cannot be gathered from the documents on record. The said intention is to be proved by the accused during the course of trial by putting her defense before the prosecution.
Please be seated. Then petitioner has challenged the rejection of her application filed under section 227 and 229 of CRPC. In special case number 143 of the 2019 in the court of so BVT, Session Judges Court. Which was for the offences punishable under sections 198, 420 of IPC and under section 319 of SCST Act. The summary of the case of the prosecution, the trial court, was that the accused belonged to belonging to Lingayat community, Sri Vishwanath, who was belonging to scheduled caste. After her marriage, based upon the residential document, ration card and Aadhaar card of her husband, she could succeed in obtaining a caste certificate in her name, showing herself also as belonging to Adi Karnataka community, which is a scheduled caste. She applied for the institution of banking personnel selection appointing authority by claiming reservation and a scheduled caste quota. She was selected for the job and joined then Syndicate Bank, bracket present Canara Bank, Gundlupet branch on 1/1/2015. Thereafter, her caste certificate was sent for verification to the Social Welfare Department. On 18/4/2016, the district committee found that the accused, knowing fully well that she belongs to Lingayat community, had suppressed the said fact and obtained a caste certificate showing her to be of scheduled caste. Hence, the said committee cancelled the said certificate issued in her favor. It is on the said basis, the Directorate of the Civil Rights Enforcement Police have registered a case against the accused to the respondent, first respondent police, who after completion of investigation have filed charge sheet for the alleged offence. The respondents are represented by respondent 1 is represented by Laran HCGP, respondent number 2 is represented by its special counsel. For the submission of Laran counsel for the petitioner and the Laran HCGP on admission. Special counsel corresponding number 2 has remained absent. The only point that arises for my consideration is whether the matter is of admission for its hearing. Next line. Learned counsel for the petitioner submits that he would not. It is an admitted fact that the petitioner by birth was belonging to Hindu Lingayat community and that she married Sri Vishwanath on 29/11/2012, who was belonging to scheduled caste. He also submits that it is not in dispute that she got employment with the then Syndicate Bank and joined for her job on 1/1/2015 at a scheduled caste quota. However, his main contention is that the caste certificate showing the petitioner as belonging to scheduled caste was given after due verification by the concerned authorities and obtained the report of the village accountant and revenue inspector. Thus, when after due inquiry such a certificate was given, no fault can be found with the petitioner. He also submits that the application for caste certificate was made online and that there was no malice part of the petitioner throughout. He further submits that before institution of the present criminal case, petitioner has already resigned from her job on 19/4/2016 itself. He further submits that in a similar circumstance, the coordinate bench of this court has quashed the criminal proceeding by allowing the petition in criminal petition number 8857/2018 by its order dated 19/4/2022. Next line. For contra, HCGP correspondent number 1 in his argument submits that all the charge sheet witnesses have given their statements in support of the prosecution. Admittedly, the petitioner by birth was belonging to Hindu Lingayat community and that her employment was under reservation quota for the scheduled caste. Her subsequent resignation from the job would not exonerate her from the offences committed by her. It is an admitted fact that the petitioner was belonging to Hindu Lingayat community by birth and that she married to one Sri Vishwanath who was belonging to scheduled caste community. It is also not in dispute that subsequent to her marriage, she could be able to obtain a caste certificate from the competent authority showing her to be belonging to scheduled caste community. It is an admitted fact that she applied under the said category for employment with the institution of banking personnel selection and could be able to obtain a job with then Syndicate Bank, bracket now Canara Bank, and served in the said institution for more than a year till her alleged resignation from the job, which was on 19/4/2016. It is in the light of the above admitted fact, the matter has to be looked into. Next slide. The offense alleged, the main offense alleged against the petitioner is the one punishable under section 198 and 420 of IPC. Section 198 mentions, deals with the offense using as a true a certificate known to be false. Section 420 is with respect to cheating and dishonestly inducing delivery of a property. In the instant case, the allegation made against the petitioner by the complainant police is that knowing fully well that marriage would not change her caste from Hindu Lingayat to scheduled caste, the petitioner could be able to succeed in obtaining a caste certificate as though she was belonging to scheduled caste, and making use of the same, she could be able to secure a job in a central government undertaking, banking institution. The alleged caste, the caste certificate which the petitioner is said to have made use of for obtaining the job in the bank, no doubt those stated to have been issued by the competent authority, that is the jurisdiction Tahsildar. However, mere issuance of a caste certificate by the competent authority would not exonerate the applicant for the caste certificate from the alleged offences. When the applicant, knowing fully well that by birth she was belonging to a particular community, without disclosing the same, but only reveals the cost of her husband and could be able to secure a caste certificate in such an event, the alleged issuance of caste certificate would not exonerate her from her alleged crime. In the instant case, the very allegation of the prosecution is that because by making use of the documents pertaining to her husband, he belongs to scheduled caste, the petitioner could be able to secure a caste certificate in her favor. It is further the case of the prosecution that it is making use of the said certificate, she could be able to secure a job in a central government undertaking, banking institution. No doubt in a similar circumstance, the coordinate bench of this court in Savitri's case, bracket Supra, al mele in reference ಹೇಳಿದ್ದೇನೆ coordinate bench and ಪೂರ್ತಿ ಕಾಸ್ಟೇಟ್ ಆಗಿದೆ ಪೂರ್ತಿ ಹೆಸರು. In Savitri's case, this court quashed the criminal proceeding initiated against the petitioner therein. However, the same was on the pretext that as on the date of she obtaining the caste certificate and securing the job, the judgment of the Honorable Apex Court in N.E. Horo versus Jahanara Jaipal Singh, 1972, 1 ACC 771, was in force. However, in the instant case, the facts differ. Admittedly, she could secure the job in the nationalized bank and joined to the duties only on 1/1/2015, by which time the judgment of the Honorable Apex Court in Meera Kanwaria versus Sunita and others, reported in 2006, 1 ACC 344, was in force. In the said judgment, the Honorable Apex Court was pleased to observe that a person who is a high caste Hindu and not subjected to any social or educational backwardness in his life, by reason of marriage alone, cannot ipso facto become a member of the scheduled caste or the scheduled tribe. In the absence of any strict proof, he cannot be allowed to defeat the very provisions made by the state for reserving certain seats for disadvantaged people. Incidentally, even in Savitri's case also, the coordinate bench has referred to the judgment of Honorable Apex Court in Valsamma Paul versus Cochin University and others, reported in 1996, 3 ACC 545, wherein the Honorable Apex Court was pleased to observe that the reservation for women under section 15(4) of the section or article 15(4) of the Constitution of India is not available if the member of the SC/ST person marries the member of the SC/ST. In spite of the same, in Savitri's case, N.E. Haro's case (Supra) was relied upon. However, in view of the fact that as on the date of passing, as on the date of filing of the complaint in the present case, which was on 19/4/2018, the judgment of Honorable Apex Court in Meera Kanwaria was in vague, and Meera Kanwaria was in doubt. The judgment in Savitri's case is not cannot be the benefit of order passed in Savitri's case cannot be extended to the present petition. It is also the contention of the petitioner that she had no malice. As a subjecting her to a trial would be a futile exercise. Next line. The question of next line. The admittedly, the petitioner is said to be a M.Com postgraduate, being highly educated. It cannot be taken that she was ignorant of the law and the possession of the law as on the date of she applying for the caste certificate and also obtaining a job in the nationalized bank. Furthermore, the malice behind an alleged offense can be ascertained only in a full-fledged trial. As such, for considering the application filed by her under section 227 and 239 of the RPC, the trial court, the session judges court has rightly looked only for the availability of the ground for proceeding further in the matter and to see whether the complaint charge sheet filed was groundless. Since in the light of the observation made above, the special court has rightly held that there was no sufficient ground to allow the application. On the contrary, the charge sheet filed cannot be called as groundless or lacking of sufficient grounds. I do not find any perversity, illegality, or error or interfering in the said order. Accordingly, the question stands dismissed as devoid of grounds for admission.
IA 1 of 2021 first day.
Of the disposal of the main petition itself, IA 1/21 stands disposed, becomes infracture. Registered to transmit a copy of this order to the concerned sessions court where the matter is to be pending forthwith. Yes.
Bill number 33, Dhanalakshmi K. Vijay Krishna Bhatt, correspondent.
Subsequently, parties have settled their dispute. Has also been paid.
That he should come and say.
Aಲ್ಲಿಂದ ಒಂದು ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಕಾಂಪ್ರಮೈಸ್ ಅಂತ ಹೇಳಿ ಕಳಿಸಿದ್ದಾರೆ.
ಅವರಿಗೆ ನೀವು ಜಸ್ಟ್ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಒಂದು ಮೆಸೇಜ್ ಕಳಿಸಿ. It appears my client is intending to move the trial court for issuance of conviction warrant ಅಂತ ಕೂಡಲೇ ಬರ್ತಾರೆ ನಿಮಗೆ. 147 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಣ, ಮ್ಯಾಟರ್ ಬೇಗ ಕ್ಲೋಸ್ ಮಾಡಿಸೋಣ.
ಮಾಡಿದ್ದಾರೆ.
The counsel for the petitioner not present. The counsel for the respondent who is physically present submits that parties have settled the matter and the filing joint application under section 147 NI Act for which it requires a 3 days accommodation. While granting the time as paid, the court reminded both parties that the parties may also consider the liability to pay the graded cost as per Damodar Prabhu's case. List the matter on volume 7, either to report settlement or to proceed further in the matter.
34, BC Venkatesh Lingaraj, correspondent.
Additional memo ಇದೆ ಅಲ್ಲಿದೆ. 34 ನಲ್ಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ಲಿ IA 1 for suspension along with memo.
Please, Your Lord. But originally, in this matter, the learned magistrate had passed an order directing the petitioner in this case to pay a sum of rupees 1,10,344, which was the fine amount which was levied.
Not all those submissions may not be necessary. No, only point is,
Please.
both of you should come and file a compromise application. That's what is to be done.
Please. In fact, my lords, while annexure C at page 47, during the pendency.
ಅದ್ರ ಬಗ್ಗೆ ಅಬ್ಸರ್ವೇಷನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿ ಆಗಿದೆ ಹಾಗಾಗಿ ಕೋರ್ಟ್ ಮರೆತಿರುತ್ತೆ ಮತ್ತೆ ಅದನ್ನೇ
On the last occasion, it was my colleague who appeared.
147 application ಹಾಕಿದ್ರೆ ಉಂಟು.
You may be granted 3 days time, my lords.
Learned counsel for the petitioner alone presents and submits that since the parties have already settled the matter, they will file a joint application to section 147. NI. 3 days time as grade is granted. However, bringing to the notice of both sides about the liability, if any, to pay graded cost as per Damodaras Prabhu's case. This is the matter on 13/7.
Deeply obliged.
Number 25, Nataraju SG, Harish NR. Amount is 4 lakhs.
% of the fine amount in the trial court, 50,000 rupees, personal bond, 2 surety, emergent notice, process within a day, PCR, ACR. Suspension is of trial court judgment only, trial court sentence only. Yes.
36, Complaint Manjula Devi, Ramappa.
Complainant's petition, my lord. The trial court, my lord, has convicted the accuser for payment of the check amount, my lord. The accuser filed appeal before the appellate court, my lord. The appellate court has allowed the appeal and remanded the matter there. They are stating that, my lord, they are not given opportunity to read evidence. Even though, my lord, in 330 statement, he has stated he has no evidence to read, my lord. Thereafter, my lord, the matter was posted for argument. Then, my lord, he filed a 311 application for reading evidence, reopening of the case for reading evidence. That was rejected, my lord. And he has not challenged that the order passed by the trial court, my lord. And then arguments were heard and he
is submitted. Thereafter, we find the appeal minute on the final disposal of the case.
The counsel for the petitioner present. The registry has placed IA 1/22 for consideration. The perusal of the said IA go to show that IA 1/22 contains two applications with a single affidavit. Prayer made in two applications are two different prayers. The registry to notice the same and do the needful in the matter. List the matter. Knowledge it. 7. Yes.
Some other cases out of this.
8-7 as prayed. Yes.
37, Eugene Prabhu Bharat.
I humble submission before the Lordship in connected with the Lordship has passed the order. Same order.
ನಾನು ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ಒಂದು ದಿವಸವೂ ಟೈಮ್ ಕೊಡ್ತಾ ಇಲ್ಲ. %50% of the fine amount in the trial court, 1 lakh rupee. Personal bond, 2 surety, emergent notice, TCR, SCR, etc. But the judgment confining to the present petitioner only. Yes.
Proceeding number 38, Hegde Ramakrishna S. Prasanna Kumar P. Correspondent.
I'll file objection not to the course this week, not to the IA. Two occasions not have taken time.
The counsel from both sides present. The counsel for respondent pray for a short accommodation to file his objection to IA 1/22. Finally, 10 days time as paid is granted. Yes.
Agenda number 40, KB Naveen Kumar, SCG for R1, R2 J Manjula served.
In this case, I am appearing for petitioner, my lord.
The counsel for the petitioner is appearing through video conference. Respondent number 1 is physically present. According to registry, notice to respondent number 2 is served. Respondent number 2 is called out. Has remained absent. Considering the nature of allegation made against the accused and the alleged offences against him, I am of the view that respondent number 2, who is said to be the alleged victim, be represented by a counsel to place her version in the matter. Accordingly, the counsel Srimati K. Marchan is appointed as amicus curiae for respondent number 2 within the law case. The counsel for the petitioner to furnish an entire set of memorandum of revision petition along with its annexure to the said 11 amicus curiae. Further registry is also directed to furnish the copies, etc. You furnish the copies to amicus curiae. I have appointed an amicus curiae for respondent number 2.
Yes, my lord. Tomorrow I will furnish the.
Which the matter on 12/3 12/7.
12/7, my lord.
12/7.
Number 41, Girish B. Baldare, SCGP for respondent.
This case, I have to secure some charge sheet, my lordship. I seek 1 week containment. Pertaining to the application filed for discharge came to dismiss.
Amicus curiae appointment. Respondent number 2 ವಕಾಲತ್ ಹಾಕಿಲ್ಲಲ್ಲ.
Petitioner who is physically present prays for short accommodation since the petitioner himself is not evincing interest on IA 2/22 for an interim order. This matter of 4 weeks. Any earlier question would be only after bringing today's observation to the notice of the court.
Yes. Number 42, R. Channakeshava.
The trial got the petitioner on 28 to 18 Lordship. After on 25, 22, appeal is dismissed. Lordship. The check amount is 33 lakh 92,025 Lordship. Respondent is a financial company. Lordship. The process of compromise also. In this case, we have received the amount from the respondent number 1 through RTGS Lordship to the extent of 12 lakh. 12 lakh. We have taken the check, we have misused the check. Lordship. In this case, we are in the process of compromise also.
What is entered into compromise?
No, we will try to compromise the case. Lordship. Sentence may be suspended for the time being. I will pay.
No, if you are attempting for compromise, I will order for notice. Let them come. You can settle the matter.
Yes. No, Lordship. In this sentence, otherwise they will take the sentence suspension. I will deposit the amount. Lordship. The check amount is heavy.
So the alleged statement regarding the compromise or settlement only to please court.
No. I am not doing any cases. Lordship. That I am not doing. This case is a finance company. Lordship. We admit we have received the amount to the extent of 12 lakh.
% of the fine amount, 2 weeks trial court, 2 lakh rupee personal bond, 2 sureties, emergency notice, PCR, SCR.
Number 43, Shankar Nayan Bhatt N, SPP for respondent.
Is a permanent resident of Kunigal.
He is a permanent resident of Amrutur town, my lord.
Kunigal Taluk.
Yes.
The counsel for the petitioner present. For this submission, Lord HCGP takes notice for responding. Submits his oral objection to IA1/22. Filed IA1/22. Filed under section so. Considering the fact that the petitioner said to have been on bail throughout during the trial as well during the period of appeal, and that he was appearing before the court regularly and appears to have not violated the terms of bail, I am of the view that conditionally IA1/22 be allowed accordingly. IA1/22 is allowed and the petitioner product in the happy conditions do confined to the petitioner. According to the petitioner, the fine amount to be deposited in the trial court, fine amount to be paid in the trial court. It's entirely 30,000 rupees person one, 2 sureties, PCR, HCR. It is.
Other arguments, serial number 44. And Venkatesh, prayers of our respondent.
Lord. Petitioner has responded this revision petition against the concerned findings of the court's below law. So the such fact of the case is this, Lord. The accused is the relative of this petitioner wife. In order to carry on the business,
Fascinating beauty parlor.
In order to carry on the business of fascination beauty parlor, she availed the loan of ₹3 lakhs on 5/1/2007. To her agent, that is her maternal auntie. It is also not in dispute. That is the case of this petitioner. On receipt of the amount, she has issued the cash receipt, that is Exhibit P1. Thereafter, this respondent has issued the notice, demanding notice to pay that amount. Then she issued the notice, this check along with the covering letter on 5/9/2008. 5/9/2008. Thereafter, the check was presented. The check was dishonored. Then this petitioner had, this respondent has issued the legal notice. The notice has been served 15/10/2008. The notice was served to the accused, but the accused had not given any reply to that notice. Then the petitioner, this respondent has filed the petition that's want CRPC that complaint. After conclusion of the trial, the court has passed an order where it directed this accused to pay a sum of ₹4 lakhs, 3,40,000. The check amount is 3,94,500. So court has ordered to pay 4,40,000 rupees. Again, that the petitioner before this court has filed a revision of that appeal. The appeal also before the trial court, this petitioner, the respondent has produced as many as 10 documents, which have been marked as Exhibit P1 to P10. The Exhibit P1 is the cash receipt, Exhibit P2 and P3/4 is the check. In that she has, in the cross examination, the accused has admitted her signature and also admit her signature. So far as the Exhibit P1 is concerned, she has admitted in the cross examination that the covering letter has been pertaining to her company, that is the proprietor Fascination Beauty Parlor, and also the signature on the letterhead also she has admitted that this is the signature belongs to her. Sir, her only that
denial is that the averments which has been, the contents which have been made in that, she has not admitted. Thereafter, she has given the exhibit D1 that she has lodged a complaint. For that, the police has not taken action because for after these things, this respondent has sought this information under RTA. The jurisdictional police, that is the Alsur Gate police station, has issued the endorsement stating that no such complaint has been received by the police. That is the exhibit P10. During pendency of this appeal, the petitioner before this court has filed an additional application under section 391 and produced as many as 10 documents which have been marked as in the trial court. She has produced that 15 document exhibit D1 to D15. Before the appellate court, again they have additional 10 documents they have produced. Those documents have been marked as exhibit P16 to P25. After considering the document placed on record, the courts below has been passed that order, wherein the only ground asserted before this honorable court is that as on the date of the transaction, she was minor and she was not in state, in that means in Bangalore, she was in abroad, that Germany.
Additional documents were marked where?
Before the first appellate court as exhibit P16 to 25. Before trial court, exhibit D1 to D15. And also the first appellate court has given a reference regarding the document, page 36 of the page 36. Page 36.
Yes, 36 is the judgment of the trial court. Right?
Yes, the judgment of the trial court, first appellate court. Trial court first appellate court anta ide. Adralli para that first appellate court internal page 8, 12 line from the top. The accused examined further before the appellate court during the pendency of this appeal and has produced other documents, exhibit 16 to 24. The accused produced the account opening form at exhibit D16. It clearly discloses that her bank account was opened with the Corporation Bank as proprietor of Mrs. Fascination Beauty Parlor. The defense of the accused is that only that she was working as an employee and the monthly salary of
Exhibit D16 to D25 were marked, you said, in the appellate court.
Yes, Lord.
Show me a reference to that effect, please.
Lord, in the appellate court order, this internal page 8 in the appellate court order.
ಅದ್ರಲ್ಲಿ ಡಿ 16 25 ಮಾರ್ಕ್ ಆಗಿದೆ ಅಂತ ಇದೆಯೇನ್ರಿ?
ಇದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲೇ ಇದೆ. 16 25 ಮಾರ್ಕ್ ಆಗಿದೆ, 24 ಅಂತ ಹೇಳಿ ಆ ಪೇಜ್ 8 ಅಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಓದಿ, ಆ ಸೆಂಟೆನ್ಸ್ ಇನ್ನೊಮ್ಮೆ ಓದಿ.
The accused examined further before this appellate court. 12th line from the top.
ಹೌದು, ಓದಿ ಮುಂದೆ.
The accused examined further before this appellate court during the pendency of this appeal and he has produced other documents, exhibit P16 to P24.
Accused P series ಮಾಡ್ತಾನೆ ಮಾರ್ಕು. ಮತ್ತೆ
ಅದು ಇದು
ನಾನು ಅವಾಗಿಂದ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು. ಎಕ್ಸಿಬಿಟ್ D16 to D25 ಮಾರ್ಕ್ ಆಗಿದೆ ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ.
ಹೌದು.
ಇಲ್ಲಿ ಓದ್ತಾ ಇರ್ತೀವಿ ಎಕ್ಸಿಬಿಟ್ P16 to P24.
Next the accused produced the account. Accused produced the account opening form at exhibit D16.
ಇರಬಹುದು.
Exhibit D16
ಇರಬಹುದು. ಆದ್ರೆ ಒಟ್ಟು ಅಪರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಏನ್ ಮಾರ್ಕ್ ಮಾಡಿದಾನೆ ಅಂತ ಒಂದು ಹೇಳಿರ್ತಾರೆ ಅಲ್ವೇ? ಇದು ಎಲಾಬರೇಷನ್ ಆಫ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡಾಕ್ಯುಮೆಂಟ್, ಅನಾಲಿಸಿಸ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್, ಎಕ್ಸಿಬಿಟ್ D16. ನಾನು ನಿಮಗೆ ಹೇಳಿದ್ದು ಅಕ್ಯೂಸ್ಡ್ ಕಡೆಯಿಂದ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಷ್ಟು ಮಾರ್ಕ್ ಆಯ್ತು ಅನ್ನೋದನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ತೋರಿಸಿ. ಯಾಕೆಂದ್ರೆ ನೀವು ಜಜ್ಮೆಂಟ್ ಪೂರ್ತಿ
ಓದಿದೆ, ಬಟ್ ಅದು
ಪೇಜ್ 6 ತೆಗಿರಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 9 ನೋಡಿ.
ಇದೆ ನಾನು ಎಕ್ಸಿಬಿಟ್ ಪಿ ಅನ್ನೋದು ಪಿ ಅಂತ ಇದು ಮಾಡ್ತೀನಿ,
ಜಸ್ಟಿಫೈ ಮಾಡೋದು ಬೇಡ, ನೋಡಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ 5 ತೆಗಿರಿ, ಪ್ಯಾರಾ 9 ನೋಡಿ.
During the course of this appeal, the accused preferred an application under section 391 of CPC seeking permission to lead additional evidence, and the same was allowed and the exhibit ಅಲ್ಲಿ wrong ಆಗಿ ಮಾಡಿದ್ದಾರೆ, ಇದು ಕರೆಕ್ಟ್. Exhibit D16 to 25 ಅಂತ ಹೇಳಿ.
ಬಂತೆ ಈಗ ಹೇಳಿ.
To lead additional evidence and the same was allowed and she was permitted to lead further evidence. The accused examined further and she has produced the documents as Exhibit 16 to. ನೋಡಿ this case law. The date of transaction 5/1/2007. The amount, date of payment of that amount is on 5/1/2007. And also it is not the case of this respondent that she has personally received that amount. This is the case of this respondent that through her agent, she received that amount. For that, she has acknowledged and issued the cash receipt, that is the Exhibit P1. Exhibit P1. Exhibit P1 is on her that Fascination Beauty Parlor letterhead, and the signature is also, she has in the cross examination, she admitted that the signature belongs to her. Only she is there.
Proceeding further in an argument, keeping the defense of the accused in the background. Your contention, your case you are telling, since the trial is over, the appeal is over, now it is the revision.
Revision.
Yeah. And you have heard the elaborate argument of the other side also. So keeping the defense of the accused in the background, how you still say that the impugned judgment is sustained?
No, the impugned judgment is sustained on 3 grounds. First one is that my learned friend, that petitioner has addressed the argument on sentimental basis that she is residing in Mathikere. This her maternal auntie was in Gandhi Nagar anta, Indra Nagar anta. There are several people, including male or female, they are traveling every day in hundreds of kilometers for the persuasion of the education as well as the job. Illinda Mathikere inda Indra Nagar, hardly it is a 10 to 15 kilometers. So, pardon me.
Vidyaranyapura to Indra Nagara.
Mathikere adadmele Vidyaranyapura, that is adjacent. Alle rakadane barutte.
ಅಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಏಜೆಂಟ್ ಮತ್ತಿಕೆರೆ ಏನ್ ಪ್ರೈಸ್ ಇದೆ ವಿದ್ಯಾರಣ್ಯಪುರ
ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ hardly 10 to 15 kilometers. ಈಗ ಜನಗಳು including male or female or whatever it may be, they are traveling in hundreds of kilometers from every day for pursuing their education agirli ಅಥವಾ job ಗೆ. In such circumstances, traveling from that Vidyaranyapura to that Indra Nagar, it cannot be termed as an impossible task. So yakandre vehicles ಗಳಿದೆ, plus as on the date of she was working on 5/1/2007, she was the age of about 27 years. ಯಾಕಂದ್ರೆ ಅವರು the last occasion
ನಾನು ನಿಮ್ಮನ್ನ ಹೇಳ್ತಾ ಇತ್ತು, ಅವರ ಡಿಫೆನ್ಸ್ ಅನ್ನ ನೀವು ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ನಲ್ಲಿ ಇಟ್ಕೊಂಡು ಹೇಳಿ ಅಂತ ನಾನು ಹೇಳ್ತಿರೋದು ಅದನ್ನೇ. ನೀವು ಡಿಫೆನ್ಸ್ ಅನ್ನೋದು ಡಿ ಆಲ್ಫಾಬೆಟ್ ಹತ್ರ ಹೋಗ್ತೀರಿ, ಮುಂದಿನ ಕಂಪ್ಲೀಟ್ ಉಳಿದಿರೋದು ಮರ್ತು ನಿಮ್ ಕೇಸ್ ಅಷ್ಟನ್ನೇ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ಸೊ ಈಗ ಅವರು ಅದನ್ನೇ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಹೋಗೋದಕ್ಕಾಗುತ್ತಾ?
ಅವರದ್ದಿರೋದು 2007 ಇನ್ನದಲ್ಲ, 1994-96. ಅವಾಗ ಆಕೆ ಸಣ್ಣ ಹುಡುಗಿ. ಆ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಅವಳು ವಿದ್ಯಾರಣ್ಯಪುರದಿಂದ ಇಂದಿರಾ ನಗರಕ್ಕೆ ಒಬ್ಬಳೆ ಹೋಗಿ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ನ ಅಷ್ಟು ಟೆಂಡರ್ ಏಜಿನ ಹುಡುಗಿ ಅವಳು ಅದನ್ನ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಡೆಸ್ತಿದ್ಲು ಅನ್ನೋದೇ ನಂಬಲಿಕ್ಕೆ ಅಸಾಧ್ಯ. ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನೀವು ನಡೆಸ್ತಾ ಇದ್ದದ್ದು. You being a bank officer, you are running that beauty parlor joined by your wife. ಈಗ ನಿಮ್ಮ ಹೆಂಡತಿ ಅಕ್ಕನ ಮಗಳು, ಆಕೆ ಅಪರೂಪಕ್ಕೆ ನಮ್ಮ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ಗೆ ಬರ್ತಿದ್ಲು. ನಂತರದಲ್ಲಿ ಆಕೆ ಸ್ವಲ್ಪ ದೊಡ್ಡವಳಾದ ನಂತರ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಲ್ಲಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೀವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರಿ. ನೀವಿಬ್ಬರು ಗಂಡ ಹೆಂಡತಿ ಬ್ಯಾಂಕ್ ಅಫಿಷಿಯಲ್ಸ್, ಹಾಗಾಗಿ ಅವಳನ್ನ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಲ್ಲಿ ಕೂರಿಸ್ತಾ ಇದ್ರಿ. ಅವಳಿಗೆ ತಿಂಗಳಿಗೆ 5,000 ರೂಪಾಯಿ ಸಂಬಳ ಕೊಡ್ತಾ ಇದ್ರಿ. ಹಾಗಾಗಿ ಹೆಸರನ್ನ ನೀವು ಅವಳು ತೋರಿಸಿದ್ರು ಕೂಡ ನೀವು ಬ್ಯಾಂಕ್ ಅಫಿಷಿಯಲ್ಸ್ ಅಂತ ಎಂಟೈರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲದದ್ದು ಪೇಪರ್ಸ್ ಎಲ್ಲದೂ ಇದ್ದದ್ದು ನಿಮ್ಮ ಕೈಯಲ್ಲಿಯೇ. ಹಾಗಾಗಿ ಲೆಟರ್ ಹೆಡ್ಗಳು ಇತ್ಯಾದಿ ರಬ್ಬರ್ ಸ್ಟಾಂಪ್ ಲೆಟರ್ ಹೆಡ್ ಪ್ರತಿಯೊಂದು ಇದ್ದದ್ದು ನೀವು ಗಂಡ ಹೆಂಡತಿ ಕೈಯಲ್ಲಿಯೇ. ಆಮೇಲೆ ನೀವು ಗಂಡ ಹೆಂಡತಿ ನಡುವೆ ಜಗಳ ಬಂದಿದ್ರಿಂದಾಗಿ ಆ ಹೆಂಡತಿ ಮೇಲೆ ಸಿಟ್ಟನ್ನು ತೀರಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಬೇರೆ ಯಾರು ಸಿಗ್ಲಿಲ್ಲ. ಈ ಹುಡುಗಿ ಹೆಂಡತಿ ಅಕ್ಕನ ಮಗಳು ಹೆಂಡತಿ ಜೊತೆಗೆ ಇದ್ಲು. ಅವಳು ಹೇಳಿದ ಕೇಳ್ತಾ ಇದ್ದು ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಡೆಸ್ತಾ ಇದ್ಲು ಅಂತ. ನೀವು ಹೆಂಡತಿಗೆ ಕೊಡಲು ಇಚ್ಛಿಸಿದ ಅನಾನುಕೂಲತೆ ಕಿರುಕುಳವನ್ನ ಈ ಹುಡುಗಿಯ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ. ಅದು ಅವರ ಡಿಫೆನ್ಸು. ಅದನ್ನ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ನೀವು ನಿಮ್ಮ ಕೇಸ್ ಏನಂತ ಹೇಳಿ.
This with regard to that transaction, I admitted that both the respondent as well as his wife were the employees in the State Government of India. During their employment, they are not unable to carry on any business as a parallel business as per the banking regulations. So the entire business has been transferred to the name of not this petitioner, this wife, transferred in the name of his maternal auntie, that is the our petty respondent wife na sister Maglu. So she was taken care. She herself was doing everything as a proprietor, and all the transactions that doing in her name only, all the transactions including bank statement, bank letterhead, ಮತ್ತೆ ಅಲ್ಲಿ open ಮಾಡಿದಂತ form number 16, whatever is there, that in that also she has shown that she is only the proprietor of that fascination beauty parlor. I agree that there was a differences between me and my wife. That was in the month of October 2007. This transaction was taken place on 5/1/2007. At that time, both were. Then subsequently, even the DW2, that maternal auntie, has also given the evidence in the complaint. In the complaint, the petty complainant, this accused, has taken the defense that husband and wife, they are carrying on this business. In the cross-examination, the DW2 has clearly stated that I am not carrying on any business. My husband was carrying on the business. Even in the cross-examination, when she was subjected for cross-examination, in the cross-examination, the DW2 has admitted that cross-examination was held on 17/9/2010. DW2's cross-examination. Yes. ಪಾರ್ಟಿ ಸವಾಲು ಸೋಣಿಸೋದ್ರಿಂದ ನಾನು ಬ್ಯಾಂಕಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ, ನನಗೆ ಆರೋಪಿಯು ನೆಕ್ಸ್ಟ್ ನೋಡಿ ಅದರಲ್ಲಿ ನನ್ನ ಯಜಮಾನರಾದ ಫಿರ್ಯಾದುದಾರರು ಮಿಸ್ಸಸ್ ಫ್ಯಾಸಿನೇಷನ್ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಡೆಸುತ್ತಿದ್ದಾರೆ ಎಂದು ತೋರಿಸಲು ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನನ್ನ ಯಜಮಾನರು SBI ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಅವರು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ಬೆಳಗ್ಗೆ ಹೋಗಿ ರಾತ್ರಿ ಬರುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ 1ರ ಪ್ರಕಾರ ದೂರನ್ನು ಸಲ್ಲಿಸಿ ಪೊಲೀಸರಿಗೆ ನಾನು ಮತ್ತು ಆರೋಪಿ ಠಾಣೆಗೆ ಹೋಗಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. ಆರೋಪಿಗೆ ಸೇರಿದ ಚೆಕ್ಗಳು ನನ್ನ ಪರ್ಸ್ನಲ್ಲಿ ಇದ್ದವು ಎಂದು ತೋರಿಸಲು ದಾಖಲೆಗಳನ್ನು ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಪೊಲೀಸರು 2008ರಲ್ಲಿ ಈವರೆಗೂ ಈ ದೂರಿನ ಸಂಬಂಧ ನನ್ನನ್ನು ಕರೆಸಿ ವಿಚಾರಿಸಿರುವುದಿಲ್ಲ. ಅದೇ ರೀತಿ ಆರೋಪಿಯನ್ನು ಪೊಲೀಸರು ಕರೆಸಿ ವಿಚಾರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ಇನ್ ನೆಕ್ಸ್ಟ್ ಲಾ, ಆರೋಪಿಯು 1996ರಿಂದ 2007ರವರೆಗೂ ನಮ್ಮ ಮನೆಯ ಕೆಳಗಡೆ ನಡೆಯುತ್ತಿದ್ದ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಸದರಿ ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ನ ಹೆಸರು ಫ್ಯಾಸಿನೇಷನ್. ಆಕೆಗೆ ತಿಂಗಳಿಗೆ 5,000 ರು ಸಂಬಳ ಕೊಡುತ್ತಿರುವುದು ಎಂದು ತೋರಿಸಲು ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಸೇಮ್, ನಾನು ಹಾಜರುಪಡಿಸಿದ ನಿಶಾನೆ D4ರಿಂದ D15 ದಾಖಲೆಗಳು ನನ್ನ ಮತ್ತು ನನ್ನ ಯಜಮಾನರಾದ ಫಿರ್ಯಾದುದಾರರ ನಡುವೆ ಕೌಟುಂಬಿಕ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಡೆದಿದ್ದ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ದಾಖಲೆಗಳಲ್ಲಿ ಈ ಕೇಸಿನ ಚೆಕ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಏನೂ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. So the dispute between this respondent and his wife was started in the month of October 2007. So till that time, both the respondent as well as his wife were staying together. staying together. The exhibit D16, it is the bank account opening form that clearly shows that in that petitioner herself has mentioned that she is the proprietor of that fascination beauty parlor. D16. So in that the first appellate court has also observed that exhibit D16 is the bank account opening form. In that this petitioner has mentioned that she is the proprietor of the fascination beauty parlor. And she has not produced any document before this court that before the trial court or first appellate court that she was drawing the salary of that 5,000 rupees which was paid by her maternal aunt. In the complaint brought, in the defense, the petitioner before this court has taken the specific contention that this respondent and his wife were carrying on the business. So DW2 herself has deposed before the court that she is not involved in that. That DW2. She has examined on behalf of that accused. Accused has made alleging that the complainant and his wife are jointly carrying on the business.
That particular portion where she has alleged that they
Yes, Lord, I will wait. For the examination chief of that EW1, second paragraph. Examination chief of the DW1, paragraph 3.
1 minute. Examination chief of DW1.
Paragraph 3.
1 minute. ಸಿಗಲ್ಲ ಅದು.
Shall I read?
ನೀವು ಓದಿರೋ ಕೇಸನ್ನು ಮುಂದೆ ಹೋಗುತ್ತೆ ಅವ್ರು ಹುಡುಕಲ್ಲ. ಐದನೇ ಸರ್ತಿ ಬರ್ತಾ ಇದೆ ಕೇಸ್. ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ನಲ್ಲೇ ಫ್ಲಾಗ್ ಹಾಕಿ ಇಡಿ ಅಂತೇನೆ. ಅವಾಗ ಸರಿ ಇದೆ ಇಲ್ವೋ ಅಂತ ನೋಡಿ ಫ್ಲಾಗ್ ಹಾಕಲ್ಲ. ಈ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ. ಓದಿ.
Para 3 of that evidence affidavit. That I state that I was working in Mrs. Fascination Beauty Parlor situated at number 2577 second cross HL second stage, Indira Nagar, Bangalore 56008 as on a monthly salary of ₹5,000, and the said beauty parlor was run by the complainant and the complainant's wife, Srimati Mrs. Lakshayani Jayanti is my aunt, and the said beauty parlor was running and managed by both the complainant and his wife. Evidence of
yes.
Third paragraph that affidavit, evidence affidavit. So DW2 in her evidence, she is categorically stated that only the respondent was carrying on the business. Para 3 of that evidence affidavit. She has alleged that both the defense evidence of the DW2, she has categorically stated that the DW2's evidence affidavit, Lord. Yes. Para 4 and 5, Lord. Graduate from Andhra University, that Paras 5, Lord. That I state that my husband was running a beauty parlor in the name and style of Mrs. Fascination Beauty Parlor situated at so and so. And the said beauty parlor was run by the complainant for both men and women, and I was only assisting my husband and my niece. Only at my request was assisting us, as my self and husband were bank employees, and we do not have the authority to run the said beauty parlor or have any transaction relating to the business of the beauty parlor, as our bank rules do not permit us to do any sort of business. In the cross examination, she has admitted that my husband during his working time, morning hodre sayankala mane barta idru. The cross examination which was held on 17/9/2010, she has categorically admitted that ನಮ್ಮ ಯಜಮಾನರು SBI ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು, ಅವರು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ಬೆಳಗ್ಗೆ ಹೋಗಿ ರಾತ್ರಿ ಬರುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ.
Yes.
Yes, the transaction has been taken place on 5/1/2007. the petitioner before this honorable court has received the amount from, has a hand loan from the respondent for the business, and only to escape from the legal responsibility, she has taken this various defense. And also that she has taken that specific contention that she was a minor as on the date of availing loan or from the date of transaction. As per the SSLC marks card, her date of birth is 16/4/1980. On 5/1/2007, 5/1/2007, she was the age about 27 years. 27 years. So because they are the employees, she only solely looking after the affairs of that fascination beauty parlor. In order to improve that business, she has taken the loan, hand loan, because where she is a relative of his wife. He had given this money. So instead of refunding that amount, she has taken this various defense. After considering all those things, the courts below have been concurrently held that she is liable to pay that amount. Hence, the petition filed by this petitioner is not sustainable under law, and the same is liable to be.
Any reply?
Only one decision I am going to blame law.
What for?
With regard to this 139, no. Just I will read.
What it say? What principle?
That 2006 Criminal Law Journal. Really, caption B legal negotiable instrument as sponsored, dishonor of checks, legally enforceable debt, failure of accused in giving reply to the legal notice issued by the complainant is one of the strong circumstances to draw an inference that the accused borrowed the amount from complainant and check was issued towards the part payment of the legally enforceable debt. In the instant case law, though the notice has been
concept to different interpretation ಬಂದಿದೆ ನಂತರವೂ ಕೂಡ ಅದರಲ್ಲಿ ನಂತರದ ಕಾನ್ಸೆಪ್ಟ್ ನಲ್ಲಿ ಲೀಗಲ್ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಮಾಡದೇ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಇಲ್ಲಿಗಲ್ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಮಾಡಲೇಬೇಕು ಅಂತ ಲೆಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ಅಬ್ಲಿಗೇಟರಿ ಆರ್ ನಾಟ್ ಮ್ಯಾಂಡೇಟರಿ ಅಂತ ಬಂದಿದೆ. ಹಾಗಾಗಿ ಯಾವ್ದೋ ಒಂದು ಹಳೆ ಜಜ್ಮೆಂಟ್ ಅದು ರೀಫೈನ್ ಆಗಿರೋದನ್ನ ನೀವು ಹಳೆದನ್ನ ತರಬೇಡಿ.
Next one, Lord. This is the 2015-17 Supreme Court cases 368. Really, that financial and mandatory monetary loss. Negotiable Instrument Act 1881, Section 138, dishonor of check. Conviction, therefore, adequate sentence under Section 138. Necessity for imposition of awarding of compensation in such cases.
Not necessary.
So next is the decision of our own High Court. This decision has been passed by this Honorable Justice P.S. Patil, B.A. Patil Sahib. Literally, citation 2019 Karnataka 1489.
Principal
dishonor of check. Presumption in favor of holder. Accused allegedly issued check to dishonor discharge loan given by complainant. Accused stating that accused misused the check issued from his account bearing his signature for security purpose to another person. Once checks relates to the account of accused and he accepts and admits signature on it, court requests to draw in the presumption under Section 139. Burden of proof that the complainant misused the check issued for security purpose lies on accused. Accused was neither replied to notice, not filed any complaint alleging misuse of check. Failure of trial court to draw presumption in favor of the complainant and accused to rebut same. Evidence showing that the complainant is having capacity to lead loan amount. Order of trial court acquitting accused for reasons of incapacity of complainant to lend loan erroneous. But in the cross examination of this PW1, he has clearly admitted that he has furnished the income tax returns. In that has shown that 4 lakh rupees is income. And also it is not in dispute that both the husband and the wife are the bank employees. The respondent herein was working as a manager in the bank. So because of that accused being a relative, he mobilized that amount and he has paid that. Hence, the transaction taken place between this complainant and the accused has been proved, and the signatures on the receipt as well as the check, he has admitted the signatures, and she has in the evidence she has stated that the check has been lost and lodged the complaint. For that, the jurisdictional police has issued an endorsement, that is Exhibit P10, stating that no such complaint has been registered and no action has been taken. And considering all these facts and circumstances of the case law, the courts below has concurrently held that the accused is liable to pay the legally dischargeable debt. Hence, the court has passed the orders of conviction. The petition filed by this petitioner is devoid of merits, and the same is not sustainable under law, and they is liable to be.
They issued a legal notice. My humble, I have not even received the legal notice. In the cross-examination of the complainant, he specifically admits that is the Exhibit P3, and you may kindly turn to the acknowledgement card, Exhibit P9. I have not even received. My signature is not at all there. Exhibit P9. I have not even received the legal notice. And you may kindly turn to Exhibit P2, the legal notice. They themselves are not clear as to who was running the business. You may kindly turn to para 1. My client stated that Fascination Beauty Parlor for both men and women, which was running at the above state address, was not clear about its constitution, whether it is a proprietary concern or a partnership concern, as the service tax and the PAN number for the said organization is on Srimati Madhavi Lata's name, but the contracts enclosed hereby are signed by Srimati Dakshayani Jayanti. She is none other than the complainant's wife. They themselves are not clear in their notice who is running the business. As the authorized signatory, please clarify with a copy of the partnership agreement duly signed by both of them. So this is that legal notice. And my humble submission is, as I already submitted, as on the date, hand loan, he gave to me on 5/1/2007. I got married in the year 2006 and I was away at Germany. I was not at all in India. I came to India only in February 2007. I produced the Exhibit D3 passport. It clearly reveals that I was not at all in India. The complainant says he gave the hand loan to his wife, and in wife in turn she gave. But in the evidence of DW2, she clearly says I have not given any loan because she was not at all in India. My humble submission is, as I was residing at Vidyaranyapura, and the place of business is Indranagar, place from where to there is almost 25 kilometers. I was still studying whether it is humanly possible to go and look, as the complainant and his wife were employees of the State Bank of India. One may kindly turn to the cross-examination of the respondent complainant. He clearly says he retired in the month of January 2007. In the cross-examination, he admits. Turn to para.
Repeat your argument in chief. Argument in chief
regarding income tax assessee. He admits specifically, you all may kindly see, in the month of January, I gave rupees 3 lakhs to the accused. I am an income tax assessee. I am submitting returns to the IT department every year. My annual income for the year 2007 was around 4 lakhs, he says. He was getting a monthly salary of only rupees 25,000 per month before retirement. What was the necessity for him to keep 3 lakhs in his house? When he could have deposited it, got interest. Being a bank manager, he is fully aware of those things.
because there was marital discord between the complainant and his wife DW2, in order to make me a scapegoat, I have been cornered. For no fault of mine, by means in criminal appeal 70 of 2016, I have been acquitted before the trial court. Same dispute, that is also. I have produced there and here also to show that all the contract stands in the name of Dakshinayani Jayanti. Nowhere I was concerned with the business. Since they were bank employees, I was simply assisting whenever they requested me. I was simply assisting. Merely admission of signature, as you all may kindly see the check. No, all the except the signature and this one, I have not written anything. Everything is manipulated by the government. Last date of hearing, I relied on 3 judgments. One more judgment reported in 2019 of the Supreme Court. It says, Section 139, dishonor of check. Required, with accused need not step into the witness box. He may discharge his burden on basis of materials already brought on record. Question whether statutory, sorry, this one I have already last occasion. The 4th judgment is reported in 2019 5 SCC, page 418, the case of Basvalingappa versus Moody Basappa. Debts, financial and monetary laws, negotiable instrument, section 118, 138, 139, drawing of presumption and have said presumption can be rebutted, standard of proof, while presumption may establish it can be beyond reasonable doubt. Accused to prove a defense must only to prove standard of preponderance and probabilities. So principles has been enumerated. They have relied on the earlier judgment of the Supreme Court. I'm submitting this judgment
from both sides present. Heard the argument of respondent and reply by the 11th counsel for the petitioner. Orders result is ಅದೆಲ್ಲ ಹಳೆ ಪ್ರಿನ್ಸಿಪಲ್ ಇದೆ.
The 2019 later they are relied on the earlier judgments of
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು, ಹಳೆ ಪ್ರಿನ್ಸಿಪಲ್ ರೀಟ್ರೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದೆಲ್ಲ ಸೆಟಲ್ಡ್ ಪ್ರಿನ್ಸಿಪಲ್. It is a settled principle that to rebut the presumption, accused need not step into witness box.
In this case, I have examined myself and the burden heavily lies on the complainant.
ನೀವು 2 witness ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಿ.
And burden lies on the examine ಮಾಡಿ merely production of signed check is not enough. He has to prove the burden is heavily on the complainant.
ಹೇಳಿದ್ದೀರಿ ನೀವು.
Not the accused has herself has examined. That examination, she is alleging that his aunt is also doing, but the DW is telling that respondent only doing that business. Reserved. Madam, reserve. Order ready ಆದ್ಮೇಲೆ minor ಅನ್ನೋದಕ್ಕೆ ನಾನು ನಡೀತಿದೆ ತಗೊಂಡ್ಬಂದಿದ್ದೀನಿ. At that time she was there. ಅದನ್ನ ನಾವು ಅದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಅದು ಅಡ್ಮಿಟ್ ಆಗಿ ನೋಟಿಸ್ ಆಗಿದೆ. ಅದಕ್ಕೊಂದು ಪೇಪರ್ ಬುಕ್ ಕಾಪಿ ಕೊಡಬೇಕು. ಅಲ್ಲಿ 20 ಇಯರ್ಸ್ ಆಕ್ಚುಲಿ ನಂದು 4 ಲೀಟರ್ ಇದು ರೀಚ್ ಆಗ್ತಾ ಇದಕ್ಕೆ ಹೋಗಕ್ ಆಗಿಲ್ಲ. ಅದೇ ಎಲ್ಲಾರು 4 ಲಾರಿ 30 ಬಂದಿದ್ದಾರೆ. ಇದು ಮಾಡಿರ್ತಾರೆ 20% ಮಾಡಿರ್ತಾರೆ ಅದು ಸೇರಿಸಿ ಸೊ ಅದು ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಟ್ ಅಂತ ಮಾಡಿ ಒಂದು 2-3 ದಿನದಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ. ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಸೇರ್ಸ್ ಜನರಲ್ ಆಗಿ ಸಾಹೇಬ್ರು ಅದೇ ಮಾಡೋದು, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ಸ್ ಬಿಲ್. ನೋಡೋಣ ಏನ್ ಸಾಲ್ವ್ ಮಾಡ್ತಾರೆ ಮಾಡಿ ಡಿಸ್ಕಷನ್ ಕೊಡ್ತೀವಿ ಗೊತ್ತಾಗೋದು ಇಲ್ಲ. ವಾಟ್ ಇಸ್ ದ ಫೇಟ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್ ಅಂತ. ಯಾಕೆ ಅಲ್ಲ ಈಗ ಯಾವ್ದು ಸಾಹೇಬ್ರು ಇಟ್ಕೊಳ್ತಿರ್ಲಿಲ್ಲ ಔಟಮ್ ಕೋರ್ಟಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಮಾಡ್ಬಿಡೋದು. ಈ ಕೇಸ್ಗೆ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು
ಪೋಕರ್ ಏನಾದ್ರು ಇದೆಯಾ ಸರ್?
Ships permit. Ships permit. Serial number 51, my lord. Mr. A. N. Radhakrishna was there this morning. Due to personal inconvenience, he is now absent. He thought of mentioning at 1:30 that did not happen. Any short accommodation, my lord, your lordship might even have it this week itself or next week, any short accommodation. 51 minutes.
Probably he is following the steps of Mr. Bhagwan, I believe. Being present in the court only in the morning session and in the afternoon not available.
Lord, no, my lord. My senior Mr. Bhagwan was never absent from the court.
At the request of the counsel for the petitioner. Final opportunity, a week's time as paid is granted.
Grateful. Grateful.
50 continue to be here.
I'm ready.
Responding straight, my lord.
C. Raju.
Responding.
Accused activity.
Hearing witness, seal number 45, Pradeep Casey.
Petitioner, my lord.
Yes, Mr. CG.
Petition for the offence punishable under section 369 for a period of 2 years. And the same was confirmed by.
Right away go to the merits.
Please, minister.
No need to read the
Yes.
complaint, no need to repeat the facts,
Yes, minister.
no need to read the entire deposition.
It's a case of theft of MO1.
Yes.
MO1 is lecture.
Yes.
That's
The petitioner has raised two grounds, my lords. Has raised petitioner, counsel for the petitioner has raised two grounds. First ground is that, my lords, none of the prosecution witnesses speak about the age of the victim, that the child who says she was below the age of 10 years, to attract the provision of section 369. Nextly, my lords, the Mazar witnesses, my lords, are turned hostile. Therefore, recovery is not proved, and nobody has identified the accused on these grounds, on these three grounds, my lord, they sought for acquittal. So my respective submission to my lord is that, my lords, through exhibit P3, my lords, spot Mazar, exhibit P3 is the spot Mazar, my lord, the kidnapping of victim girl, my lords, is proved. Firstly, my lords, kidnapping of victim girl, my lords, has to be established by the prosecution. My lord. That is the first point for consideration. My lord, the exhibit P3 Mazar, spot Mazar witness, spot Mazar, my lord, the PW 4 and 5, my lord, speaks about the kidnapping of the victim girl. That's a PW 4. My lord, spot Mazar witness, my lord. ಅಂಗಡಿಯ ಮುಂದೆ ನಿಶಾನೆ P3ರಲ್ಲಿ ನನ್ನ ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಮಗು ಕಿಡ್ನಾಪ್ ಮಾಡಿದ ಬಗ್ಗೆ ಮಾಜರ್ ಮಾಡಿದ್ದರು. ನಿಶಾನೆ P3 ಅನ್ನು ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆಗೆ ಮಾಡಿದ್ದಾರೆ. ಮಾಜರ್ಗೆ ನನ್ನ ಜೊತೆ ಅಣ್ಣಪ್ಪ ಗೌಡ ಮತ್ತು ಗಿರೀಶ ಸಹಿ ಮಾಡಿದ್ದಾರೆ.
Whether a punch of or scene of offense Panchanama can prove the manner of occurrence of the offense. You are relying upon a scene of offense Panchanama and the evidence of witnesses to the scene of offense Panchanama and repeatedly telling kidnap is true, kidnap is true.
The case of the prosecution is that, my lord, the victim girl was kidnapped and thereafter, my lord, theft of MO chain is committed. That is, my lord, to establish the chain of link, my lord, I am relying upon first kidnapping and thereafter theft and thereafter recovery, identification, my lords. May I continue, my lords? Please,
continue.
Please.
Convince me.
Yes, my lords. It's a recovery, my lords, kidnapping, my lords. First, my lord, the case of the prosecution itself is that, my lord, the victim girl was kidnapped and thereafter.
You are repeating it fourth time. What is case of prosecution? I know better than you.
Please, my lord.
Tell me how the prosecution has proved its case.
Yes, my lord. By examining PW, my lords, 4 and 5, my lords, kidnapping is proved. Yes, my lord, the next point for consideration, my lords, through exhibit
PW 4 and 5 are only panchas to the alleged scene of offense Panchanama. How can anybody telling that it is in this place the accident is said to have been happened and a Mahajar was done, I have signed in that place, would prove the alleged rash and negligent driving of the driver?
PW 4 specifically says, kindly permit me to read one sentence. Magu kidnap madida bagge.
ಕಿಡ್ನಾಪ್ ಮಾಡಿದ ಬಗ್ಗೆ ಮಹಜರ್ ಅವ್ರು ಕಿಡ್ನಾಪ್ ಆಯ್ತು, ಕಿಡ್ನಾಪ್ ಆಗಿದ್ದು ನಾನು ನೋಡಿದೆ, ಇಂಥವ್ರು ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ರು, ಏನು ಹೇಳಲ್ಲ. HCGP ಇದ್ದೀರಿ, ಏನಿದೆ ಅಂತ ಹೇಳಿ ಕನ್ನಡದಲ್ಲಿ ಏನು ಎವಿಡೆನ್ಸ್ ಇದೆ ಓದಿ, ಕರೆಕ್ಟ್ ಆಗಿ ಓದಿ ಹೇಳಿ. ಕಿಡ್ನಾಪ್ ಮಾಡಿದ ಬಗ್ಗೆ ಮಹಜರ್ ಆಯ್ತು.
ಕಿಡ್ನಾಪ್ ಮಾಡಿದ ಬಗ್ಗೆ
ಕಿಡ್ನಾಪ್ ಬಗ್ಗೆ ಆತ ಹೇಳಲ್ಲ. ಕಿಡ್ನಾಪ್ ಎಲ್ಲಿ ಆಯ್ತು, ಹೇಗಾಯ್ತು, ಯಾರು ಮಾಡಿದ್ರು, ಅದ್ ಯಾವ್ದು ಆತ ಹೇಳಿಲ್ಲ.
ಮಾಡಿದ ಬಗ್ಗೆ ಮಹಜರ್,
ಕಿಡ್ನಾಪ್ ಆದ ಬಗ್ಗೆ ಮಹಜರ್ ಅಷ್ಟೇ. ಆತ ಹೇಳೋದು ಮಹಜರ್ ಕುರಿತು, ಆ ಮಹಜರ್ಗೆ ನಾನು ಸೈನ್ ಮಾಡಿ ಅಷ್ಟೇ ಹೇಳ್ತಾನು. ಅದು ಕಿಡ್ನಾಪ್ ಹೇಗೆ ಪ್ರೂವ್ ಮಾಡುತ್ತೆ? ಲೊಕೇಶನ್ ಆಫ್ ದ ಅಲಿಜೆಡ್ ಕಿಡ್ನಾಪ್ ಪ್ರೂವ್ ಮಾಡಬಹುದು.
That is the place of kidnappment.
ನಿಮ್ಮ ಪ್ರಕಾರ ಪ್ಲೇಸ್ ಆಫ್ ಕಿಡ್ನಾಪ್ ಯಾವುದು?
In front of the shop of that is PW PW2 Mellors, sorry, Satish.
PW2 ಸತೀಶನ
ಇಲ್ಲ PW2 Manju. It is
ಓದಲ್ಲ
Satish,
ಓದಲ್ಲ
Satish ಅಂಗಡಿ ಮುಂದೆನೆ. Satish is PW4. ಸತೀಶನ ಅಂಗಡಿ ಮುಂದೆ ಕಿಡ್ನಾಪ್ ಆಗಿತ್ತು. ಸತೀಶ is the Mellors. He witnessed the incident, Mellors.
ಅವನ ಅಂಗಡಿ ಮುಂದೆ ಕಿಡ್ನಾಪ್ ಆಗಿದೆ ಅಂತ ಅವನೆಲ್ಲರೂ ನಾನು ಕಿಡ್ನಾಪ್ ಆಗಿದ್ದು ನೋಡಿದೆ ಹೇಳಿದಾನ.
ಸ್ಕೂಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಸತೀಶ್ ಅಂಗಡಿ ಮುಂದೆ ಡ್ರಾಪ್ ಪಿಕಪ್ ಮಾಡ್ತಾ ಇದ್ವಿ.
ಪ್ರಶ್ನೆ, ಸತೀಶ್ ಅದನ್ನ ಹೇಳಿದಾನ?
ಸತೀಶ ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ ನೀವು ಸತೀಶನ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ಕಿಡ್ನಾಪ್ ಪ್ರೂವ್ ಆಯ್ತು ಅಂತಿದ್ದೀರಿ. ಸತೀಶ ಹೇಳ್ದೆ ಎಲ್ಲದನ್ನು ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಸತೀಶ ಹೇಳಿರೋದು ಎರಡೇ ಸೆಂಟೆನ್ಸ್.
ಎಸ್, both PW4 and 5
ಇಬ್ರು ಹೇಳಿರೋದು ಎರಡೇ
sentence. Only with regard to
ಕಿಡ್ನಾಪ್ ಬಗ್ಗೆ ಅವ್ರು ಏನು ಹೇಳಿಲ್ಲ. ಕಿಡ್ನಾಪ್ ಆಯ್ತು, ನಮ್ಮ ಸಮಕ್ಷ ಆಯ್ತು, ನಾವು ನೋಡಿದ್ವಿ ಅಥವಾ ಹೀಗಾಯ್ತು ಏನು ಹೇಳಿಲ್ಲ.
ಮಾಡಿದ ಬಗ್ಗೆ
ಮಹಾಜರ್ ಆಯ್ತು, ನಾವು ಸೈನ್ ಮಾಡಿದ್ದೇವೆ ಅಷ್ಟೇ ಹೇಳಿರೋದು.
ಮತ್ತೆ ನೀವು ಆ ಮಹಾಜರ್ ವಿಟ್ನೆಸ್ ಎದುರುಗಡೆಗೆ ಇಟ್ಕೊಂಡು
ಅವರಿಬ್ರು ಎವಿಡೆನ್ಸ್ ಕಿಡ್ನಾಪ್ ಪ್ರೂವ್ ಮಾಡಿದೆ ಅನ್ನೋದು 5 ಸತ್ಯ ಹೇಳ್ತಿರಲ್ಲ.
ನಿಮ್ಮ
ಸಬ್ಮಿಷನ್ ತಗೊಳ್ತೇನೆ ನಾನು, ಬರ್ಕೊಳ್ರಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದನ್ನ ಸೆಪರೇಟ್ ಬರ್ಕೊಂಡಿದ್ದೀನಿ, ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. HCGP in his argument repeatedly submitted that the evidence of PW4 and PW5 proves the alleged offense of kidnapping by the accused. Despite the court repeatedly bringing to his notice that they are only the panchas for the alleged scene of offense Panchanama and have not whispered anything about the alleged act of alleged kidnapping of Harshita. Still, the prosecution, still the learned HCGP insisted that his submission that their evidence, that is of PW4 and PW5, proves the offense of kidnapping against the accused be taken. Accordingly, this is such submission is recorded in verbatim and taken on record.
Insisted minutes, it may be taken as my submission minutes. That's my request.
ಹೌದ್ರಿ, ಇರೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ ನೀವ್ ಏನ್ ಹೇಳಿದಿರೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ would be in the form of submission. ನಾನು ನಿಮ್ಮನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡಿದೆ. PW4 PW5 ಅನ್ನೋರು ಅಫೆನ್ಸ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ, ಅವರು ಬರೀ ಸೀನ್ ಆಫ್ ಅಫೆನ್ಸ್ ಪಂಚನಾಮ ಬಗ್ಗೆ ಮಾತ್ರ ಹೇಳಿದ್ದಾರೆ. ಇಲ್ಲಿ ಎದುರುಗಡೆ ಏನೋ ಒಂದು ಮರ್ಡರ್ ಆಯ್ತು, ಯಾರದ್ದು ಮರ್ಡರ್ ಮಾಡಿದ್ದನ್ನು ನೋಡಿರೋರು ಬೇರೆ ಇದ್ದಾರೆ. ಇನ್ನೊಬ್ಬ ಯಾರೋ ಅವ್ನು ಹೋಗೋದು ಇರ್ಬೇಕಾದ್ರೆ ಅವ್ನು ಬಂದು ಏನು ಕುತೂಹಲದಿಂದ ನೋಡ್ಬೇಕಾದ್ರೆ ಪೊಲೀಸ್ನವ್ರು ಇದ್ದವರು ಇರ್ರಿ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ರಿ, ನಿಮ್ಮ ಹೆಸರು ಸ್ವಲ್ಪ ಎಜುಕೇಟೆಡ್ ಕಾಣ್ತಿರೋ ಒಂದು ಪಂಚನಾಮ ಮಾಡ್ತೀವಿ, ಸೈನ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿ ನೋಡ್ರಿ ಇದೇ ತೋರಿಸಿದಾರ ನೋಡ್ರಿ ಜಾಗ, ಇಲ್ಲೇ ಮರ್ಡರ್ ಆಗಿದ್ರಿ ನೋಡ್ರಿ, ರಕ್ತ ಕಾಣುತ್ತೇನ್ರಿ, ಕಾಣುತ್ತೇನೆ, ಚಾಕು ಬಿದ್ದಿದೇನ್ರಿ, ಬಿದ್ದಿದೆ ನೋಡ್ರಿ, ತಗೊಳ್ತಿದೀವಿ ಹಾಕ್ರಿ ಸೈನು ಅಂತ ಹೇಳಿದ್ರು ಒಂದು ಸೈನ್ ಹಾಕ್ತಾನೆ. ಅವ್ನಿಗೆ ಪಂಚನಾಮ ನನ್ ಸಮಕ್ಷಮ ಮಾಡಿದ್ರು, ನಂಗೆ ರಕ್ತ ಬಿದ್ದಿ ತೋರಿಸಿದ್ರು, ಚಾಕು ತೋರಿಸಿದ್ರು ಅಂತಾನೆ. ಅದು ಮರ್ಡರ್ ಪ್ರೂವ್ ಆಗಲ್ಲ, ಅದು ಪ್ಲೇಸ್ ಆಫ್ ದಿ ಅಫೆನ್ಸ್ ಇದು ಅನ್ನೋದಷ್ಟೇ ತೋರಿಸುತ್ತೆ. ಇದು ಅದು ಮರ್ಡರ್ ಹೌದೋ ಅಲ್ವೋ, ಮರ್ಡರ್ ಯಾರು ಮಾಡಿದ್ರು ಆಗಲ್ಲ. ಇದರಲ್ಲಿ ಸತೀಶ ಮತ್ತು ಗಿರೀಶ ಹೇಳೋದು ಈ ಸ್ಥಳದಲ್ಲಿ ಹುಡುಗಿಯರು ಕಿಡ್ನಾಪ್ ಆಗಿದೆ ಅನ್ನೋ ಜಾಗ ಕುರಿತಂತ ಪಂಚನಾಮೆ ಮಾಡಿದ್ರು, ಅಲ್ಲಿ ನಾವು ಸಹಿ ಮಾಡಿದ್ದೇವೆ. ಅವ್ರು ಅಷ್ಟು ವಿವರವಾಗಿ ಹೇಳಲಿಲ್ಲ. ಅವ್ರು ಹೇಳಿದ್ದೆ ಪಂಚನಾಮ ರಿಗಾರ್ಡಿಂಗ್ ಸ್ಪಾಟ್ ಆಫ್ ದ ಅಫೆನ್ಸ್ ವಾಸ್ ಡ್ರಾನ್ ಇನ್ ಅವರ್ ಪ್ರೆಸೆನ್ಸ್ ಆಸ್ ಪರ್ ಎಕ್ಸಿಬಿಟ್ P3, ಇಟ್ ಬಿಯರ್ಸ್ ಮೈ ಸಿಗ್ನೇಚರ್ ಅಷ್ಟೇ, ಇಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ ಅವರು. ನೀವು ಅವರಿಬ್ಬರದನ್ನೇ ಪದೇ ಪದೇ ಹೇಳಿ ಅವರಿಬ್ಬರು ಎವಿಡೆನ್ಸ್ ಕಿಡ್ನಾಪ್ ಪ್ರೂವ್ ಮಾಡುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನಾನ್ ನಿಮ್ಮನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋದ್ರು ಕೂಡ ನೀವು ಅದು ಒಪ್ತಾ ಇಲ್ಲ. ನಾನ್ ನಿಮ್ಮನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕಾದ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಕೇಳ್ಕೊಂಡು ಸುಮ್ಮನೆ ನಗಾಡಿ ಸುಮ್ಮನಾಗ್ಬಹುದು. ನಾನು ಮಾಡ್ಲಿಲ್ಲ, ನಿಮ್ಗೆ ಅಯ್ಯ ಪ್ರಾಸಿಕ್ಯೂಟ್ರೆ ಅದಲ್ಲ ಬೇರೆಯವರು ಇದ್ದಾರೆ ನೋಡಿ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಹೋದೆ, ನೀವು ಅದನ್ನ ತಿಳ್ಕೊಳ್ಳಿಕ್ಕೆ ತಯಾರಿಲ್ಲ. But you are insisting that that is your submission to be taken on record. I have taken it on record. I will add my view on your submission. No problem. Continue.
The next ground, Mellors, with regard to recovery of MO1 Mellors leg chain, Mellors, through exhibit P4,
Milord, the prosecution has examined PW 6, 8 and 13. Milord, to prove the recovery, Milord, the evidence of PW 6, Milord, both these witnesses, master witnesses, Milord, they have partly supported the case of the prosecution. But through the evidence of IO, Milord, PW 13, Milord, recovery is proved. Milord, the evidence of PW 13, Milord,
He's an investigating officer.
yes,
PW 13.
both these witnesses, Milord, they are only partly supported. But therefore, Milord, the evidence of PW 13 in this regard, Milord, is to be appreciated. So
Evidence of PW 6, PW 13 proves the recovery of MO1.
PW 13 మంచిగా
Yes.
PW 13 మంచిగా plus in the evidence of PW 13, Milord, second para, Milord, the evidence, Milord, regarding exhibit P for recovery, Milord, the IO speaks about this, Milord, there is no doubt, Milord. The before, Milord, recovery, Milord, from the possession of accused, Milord, it is proved by the prosecution. Milord, next point for consideration, Milord, who identified the accused, Milord, is the point for consideration, Milord. PW 1, 3, 10 and 13, Milord, PW 1, 3, 10 and 13 have identified the accused, Milord. PW 1 and 3, both of them have identified the accused, Milord, in this part. The evidence of PW1, Milord, first page, Milord, last sentence, Milord, ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತ ಇದ್ದರು. Milord, both accused and Milord, the victim girl was present. Therefore, Milord, PW1 has seen the Milord, and next PW3 also, Milord, speaks about this. Last sentence, Milord, in the same ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತಾ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಇಬ್ರು ಇದ್ರು, ನಾನು ನೋಡಿದೆ. Therefore, I have identified the accused. 10 and 13.
ಒಂದು ನಿಮಿಷ. ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತಾ ಸ್ಪಾಟ್ ನಲ್ಲಿ ಇದ್ರು, ಸರಿ. ನಾನು ನೋಡಿದೆ ಅಂತ ಆಕೆ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾಳೆ? ತೋರಿಸಿ ನೋಡಿ.
ಅಲ್ಲ, ಹಿಂಗೆ
ನೀವು ಎವಿಡೆನ್ಸ್ ಇರೋದನ್ನ ಓದಬೇಕು. ಯು ಕ್ಯಾನಾಟ್ ಆಡ್ ಯುವರ್ ಅಸಂಪ್ಷನ್ಸ್ ಟು ದೆಮ್.
ಇರೋದನ್ನೇ ಓದ್ತೀನಿ.
ವೆದರ್ PW3 is an eyewitness.
ಇಲ್ಲ, after the receipt of information, they go to the spot, both PW1 and 3. ನಾವು ಹೋದಾಗ ಅಲ್ಲಿದ್ರು ಅಕ್ಯೂಸ್ಡ್, ವಿಕ್ಟಿಮ್ ಗರ್ಲ್ ಇಬ್ರು ಅಲ್ಲಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ತೋರಿಸಿ. Read that particular portion where she says, I also accompanying my brother and I saw the accused girl.
ನಂತರ ನಾನು ಎರಡನೇ ಲೈನ್, ಬಾಟಮ್ ಇಂದ ಎರಡನೇ ಲೈನ್, ನಂತರ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತಾ ಇದ್ದರು. PW1.
ಅದು ಯಾರದ್ದು ನಾವು ಹೇಳುದು? ತಾವು ಎವಿಡೆನ್ಸ್ ನ ಇಡೀ ಓದಬೇಕು ಅಥವಾ ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಮಾತ್ರ ಎತ್ಕೊಳ್ಬೇಕು? ಓದಿ. ಯಾಕೋ ನೀವು ಪೂರ್ತಿ ತಯಾರಾಗ್ಲಿಲ್ಲ. ಯು ಆರ್ ಶೋಯಿಂಗ್ ಸೇ ಯು ಆರ್ ನಾಟ್ ಪ್ರಾಪರ್ ಪ್ರಿಪರೇಷನ್. ಓದಿ.
ನಾನು ಹೊಸಡಿಯ ರಸ್ತೆಯಲ್ಲಿ ಸುಮಾರು 6-7 ಕಿಲೋಮೀಟರ್
ಎಸ್ ಎವಿಡೆನ್ಸ್ ಬಿಗಿನಿಂಗ್ ಇಂದ ಓದಿ. ಯಾಕಿದು?
Yes, Milord. PW1, Milord, evidence, Milord.
PW3.
PW3. ಚಾಸಮೂರು ಗೊತ್ತು. ನಾನು ಮೊದಲು ಆಟೋವನ್ನು ಹಿರೇಸಾವೆಯಿಂದ ಶ್ರವಣ ಬೆಳಗೊಳದ ಕಡೆಗೆ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದೆ.
ನೀವು ಹೇಳಿದ್ದು PW1, PW3, PW10, PW13 have identified the accused. PW1 ಹೇಳಿದ್ರಿ, ನಾನು ಹೋದಾಗ ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತಾ ಇದ್ದರು ಅಂತ ಹೇಳಿದ್ರಿ.
PW1 ಆಯ್ತು. ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ PW1 ನಂತರ PW3 who has identified the accused. PW3 ಎವಿಡೆನ್ಸ್ ಓದಿ ಪ್ಲೀಸ್. PW3 ಆಟೋ ಓಡಿಸೋಳಲ್ಲ, ಆಕೆ ಮದರ್ ಆಫ್ ದಿ ಕಿಡ್ನಾಪ್ಡ್ ಗರ್ಲ್.
ಚಾಸ ಮೂರು ಗೊತ್ತು. ನಾನು ಮೊದಲು ಆಟೋವನ್ನು ಇರೋ ಸಾವಿಯಿಂದ
PW3 ಸರ್.
PW3 ಸರ್. ಎಸ್ ಮೇಡಮ್.
ನೀವು ಹೇಳಿ PW3.
ಎಸ್.
PW3 ತೋರಿಸಿ.
ಚಾಸ ಒಂದು ನನ್ನ ಅಣ್ಣ, ಹರ್ಷಿತಾ ನನ್ನ ಮಗಳು. ಅಡಿಗನಹಳ್ಳಿಯ ಗುಡ್ ಸಿಟಿಸನ್ ಶಾಲೆಯ ಬೇಬಿ ಸಿಟ್ಟಿಂಗ್ ಓದುತ್ತಿದ್ದಳು. ನನ್ನ ಅಣ್ಣ ಪ್ರತಿನಿತ್ಯ ಹೊಸಹಳ್ಳಿಯ ನನ್ನ ಮನೆಯಿಂದ ಸತೀಶ್ ಅಂಗಡಿಯ ಹತ್ತಿರ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಶಾಲಾ ವಾಹನಕ್ಕೆ ಹತ್ತಿಸುತ್ತಿದ್ದ. ಮತ್ತು ಸಂಜೆ ಸತೀಶ್ ಅಂಗಡಿಯ ಹತ್ತಿರದಿಂದ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ಮನೆಗೆ ವಾಪಸ್ ಸಂಜೆ 5 ಗಂಟೆಯೊಳಗೆ ಕರೆದುಕೊಂಡು ಬರುತ್ತಿದ್ದರು. ದಿನಾಂಕ 30/10/2009 ಸಂಜೆ 5:30 ವೇಳೆ ಆದರೂ ನನ್ನ ಮಗಳನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದಿರಲಿಲ್ಲ. ಆಗ 5:30 ವೇಳೆಯಲ್ಲಿ ನಾನು ಚಾಸಾರವರಿಗೆ ನನ್ನ ಮಗಳು ಮನೆಗೆ ಬಂದಿಲ್ಲ ಎಂದು ಫೋನ್ ಮೂಲಕ ತಿಳಿಸಿದನು. ಚಾಸ 1 ರವರು ಮನೆಗೆ ಬಂದು ನೋಡಿ ನನ್ನ ಮಗಳು ಇಲ್ಲದ ಕಾರಣ ಪುನಃ ಸತೀಶ್ ಅಂಗಡಿಯ ಬಳಿ ಹೋಗಿ ಬಂದು ವಿಚಾರಿಸಲಾಗಿ ಸತೀಶ್ ರವರು ಬೇರೆ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ ಹರ್ಷಿತಾಳಿಗೆ ಚಾಕ್ಲೇಟ್ ಕೊಡಿಸಿ ಹೊಸಹಳ್ಳಿ ರಸ್ತೆಯ ಕಡೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದ ಬಗ್ಗೆ ತಿಳಿಸಿರುವುದಾಗಿ ತಿಳಿಸಿದರು. ನಂತರ ಚಾಸ 1 ರವರು ಹೊಸಹಳ್ಳಿಯ ರಸ್ತೆ ಸುಮಾರು 6-7 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ ಇರುವ ಕೊರಕಲಪ್ಪನ ಮಠದ ಹತ್ತಿರ ಹೋಗಿ ವಿಚಾರಿಸಲಾಗಿ ಒಬ್ಬ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ ಹರ್ಷಿತಾಳನ್ನು ಕರೆದುಕೊಂಡು ಬಂದಿರುವುದಾಗಿ ಮತ್ತು ಆರೋಪಿ ಚಾಸ 2 ರವರು ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದ ಆಟೋದಲ್ಲಿ ಬಂದಿರುವುದಾಗಿ ಮತ್ತು ಅನುಮಾನಾಸ್ಪದವಾಗಿ ಕಂಡು ಬಂದಿದ್ದು ಹರ್ಷಿತಾ ಮೈ ಮೇಲೆ ಇದ್ದ ಒಡವೆಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳುತ್ತಿದ್ದು ಮತ್ತು ಕಿವಿಯ ಓಲೆಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳುವ ವೇಳೆಯಲ್ಲಿ ಆತನನ್ನು ಹಿಡಿದು ಇಟ್ಟಿರುವುದಾಗಿ. ನಂತರ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ.
ಇನ್ನೊಮ್ಮೆ ಓದಿ, ನನ್ನ ಕನ್ನಡ ಸರಿ ಇಲ್ಲ.
ನಂತರ ನಾನು
ಇನ್ನೊಮ್ಮೆ ಓದಿ ಆ ಪದ.
ಆ ವೇಳೆಯಲ್ಲಿ ಆತನನ್ನು ಹಿಡಿದಿಟ್ಟಿರುವುದಾಗಿ. ನಂತರ ನಾನು ಸ್ಥಳಕ್ಕೆ
ಇನ್ನೊಮ್ಮೆ ಓದಿ 5ನೇ ಸರ್ತಿ. ನಂತರ
ನಾನು ಸ್ಥಳಕ್ಕೆ
6ನೇ ಸರ್ತಿ ಕೊಡಿ ಒರಿಜಿನಲ್.
ಓದಿ ಈಗ 7ನೇ ಸರ್ತಿ ಅದು. ನಂತರ
ಒಡವೆಯನ್ನು ತೆಗೆದುಕೊಳ್ಳುವ ವೇಳೆಯಲ್ಲಿ ಆತನನ್ನು ಹಿಡಿದು ಇಟ್ಟಿರುವುದಾಗಿ. ನಂತರ ನಾನು ಸ್ಥಳಕ್ಕೆ
ನಂತರ 8ನೇ ಸರ್ತಿ.
ಅದು ನಾನು ಅನ್ನೋದು ತಾನು, ಅದು ಮೇ ಬಿ ನಾನು ಅಂತ ಬರ್ಬೇಕು ಅಥವಾ ತಾನು ಅಂತಾನೆ.
ಅಲ್ಲಿ ಏನ್ ಬಂದಿದೆ ಅದು ಓದಿ. ನಿಮ್ಮನ್ನು ಓದ್ಲಿಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಮೇಲೆ ಮಾಡಿ.
ತಾನು ಅಂದ್ರೆ
ಅಲ್ಲಿ ಏನಂತ ಇದೆ? ತಾನು ಅಂತಿದೆ. ಮತ್ತೆ ನೀವು 7 ಸರ್ತಿ ನಾನು ಅಂತ ಯಾಕೆ ಓದ್ತಿದ್ದೀರಿ?
ತಾನು ಅಂದ್ರೆ she refers to her. ತಾನು ಅಂದ್ರೆ ನಾನು ಅಂತ. she refers to her only. That is that it has to be read in that.
ನಾನು ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್ ನಾದ್ರೆ ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿಗೆ ರೆಫರ್ ಮಾಡಬಹುದು.
ನಿಮ್ಮನ್ನು ನಾನು ಫಸ್ಟ್ ಕನ್ನಡ ಸಾಹಿತ್ಯ ಪರಿಷತ್ಗೆ ಕಳಿಸಿದೆ.
ಪ್ರೊವೈಡೆಡ್ ಮಹೇಶ್ ಜೋಶಿಯ ಕನ್ನಡ ಸರಿ ಇದೆ. ಏನ್ ಹೇಳಿದ್ದಾಳೆ ಹಿಂದಿನ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಓದಿದ್ರಿ ನಾವು?
ತಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಲಾಗಿ.
ನಂತರ
ನಾನು
ಚಾಸ 1 ರವರಿಗೆ ನನ್ನ ಮಗಳು ಮನೆಗೆ ಬಂದಿಲ್ಲ ಎಂದು ಫೋನ್ ಮೂಲಕ ತಿಳಿಸಿದೆನು. ನಂತರ ಚಾಸ 1 ರವರು ಮನೆಗೆ ಬಂದು ನೋಡಿ ನನ್ನ ಮಗಳು ಇಲ್ಲದ ಕಾರಣ ಪುನಃ ಸತೀಶ್ ಅಂಗಡಿಯ ಬಳಿ ಬಂದು ವಿಚಾರಿಸಲಾಗಿ ಸತೀಶ್ ರವರು ಬೇರೆ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ ಹರ್ಷಿತಾಳಿಗೆ ಚಾಕ್ಲೇಟ್ ಕೊಡಿಸಿ ಹೊಸಳ್ಳಿ ರಸ್ತೆ ಕಡೆ ಕರೆದುಕೊಂಡು ಹೋದ ಬಗ್ಗೆ ತಿಳಿಸಿರುವುದಾಗಿ ತಿಳಿಸಿದರು. ನಂತರ ಚಾಸ 1 ರವರು ಹೊಸಹಳ್ಳಿಯ ರಸ್ತೆಯಲ್ಲಿ, ಅಂದರೆ ಚಾಸ 1 ಈಕೆಯ ತಮ್ಮ ಏನೇನು ಮಾಡಿದ ಅನ್ನೋದನ್ನ ಹೇಳ್ತಿದ್ದಾಳೆ.
ನಂತರ ತಾನು ಹೋಗಿ ನೋಡಲಾಗಿ ಆರೋಪಿ ಹರ್ಷಿತಾಳ ಜೊತೆ ಇದ್ದ. ಅಂದ್ರೆ ತಮ್ಮ ಹೋಗಿ ನೋಡಲಾಗಿ, ತಾನು ಹೋಗಿ ನೋಡಲಾಗಿ. ಇವಳು ಹೋಗ್ಲೇ ಇಲ್ಲ. ಇವಳು ಕಂಪ್ಲೀಟ್ ಹಿಯರ್ ಸೇ.
She is an ARC, my lord. She was not present.
ಮತ್ತೆ ನೀವು ಅಕ್ಯೂಸ್ಡ್ ಅವಳು ಐಡೆಂಟಿಫೈ ಮಾಡಿದಾಳೆ, ಅವಳು ಹೋಗಿ ನೋಡ್ಬೇಕಾದ್ರೆ ಅಕ್ಯೂಸ್ಡ್ ಹರ್ಷಿತಾ ಜೊತೆಗೆ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ದೀರಿ. ಹಾಗಾಗಿನೇ ನಾನು ಹೋಗಿ ನೋಡಲಾಗಿ ಯಾಕೆ ತಮ್ಮ ಚಾಸ ಒಂದು ನಾನು ಹೋಗಿ ನೋಡಲಾಗಿ ಅವರಿಬ್ರು ಜೊತೆಗೆ ಇದ್ರು, ಆಗ ಇಷ್ಟು ಗಂಟೆ ಆಗಿತ್ತು ಅಂತ ತಿಳಿಸಿದ. ನಂತರ ತಾನು ವಿಚಾರಿಸಲಾಗಿ ಹೀಗೀಗಾಯ್ತು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ತೆಗಿರಿ, ಪೇಜ್ ನಂಬರ್ 3 ಲೈನ್ ನಂಬರ್ 4. ಲೈನ್ ನಂಬರ್ 3 ಇಂದಲೇ ಓದಿ.
ಚಾಸ ಒಂದರವರು ಕರೆದುಕೊಂಡು ಅಲ್ಲಿಂದ ಚಾಸ ಒಂದರವರು ಕರೆದುಕೊಂಡು ಬರುತ್ತಿದ್ದ ಕಾರಣ ನಾನು ಕರೆಯಲು ಹೋಗಿಲ್ಲ.
ಪೇಜ್ ನಂಬರ್ 3.
ಪೇಜ್ ನಂಬರ್ 3 ಅಂಗಡಿ ಸತೀಶ್ ಸರ್ ಅವರಿಗೆ ತಿಳಿಸುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ. ನನ್ನ ಮಗಳನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದ ನಂತರ ನಾನು ನೋಡಿದ್ದೇನೆ.
ಮುಂದೆ
ನನ್ನ ಮಗಳನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬರುವ ಪೂರ್ವದಲ್ಲಿ ಆದ ಘಟನೆಯನ್ನು ನಾನು ಪ್ರತ್ಯಕ್ಷವಾಗಿ ನೋಡಿಲ್ಲ.
ಈಗ ನಿಮ್ಗೆ ಇದು ಜಾಸ್ತಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಸಿಕ್ಕಿತೆ. ಅವಳು ಮಗಳನ್ನ ನೋಡಿದ್ದೆ ಮನೆಗೆ ಕರ್ಕೊಂಡು ಬಂದ್ರ ಮೇಲೆ. ಮಗಳನ್ನ ಮನೆಗೆ ಕರ್ಕೊಂಡು ಬರುವ ಮುಂಚೆ ಏನಾಗಿದೆ ಇವಳು ನೋಡ್ಲಿಲ್ಲ. ಅಲ್ಲಿ ತಮ್ಮ ಏನ್ ಹೇಳಿದ ಅದನ್ನ ಹೇಳಿದಾಳೆ. ತಮ್ಮನಿಗೆ ಫೋನ್ ಮಾಡಿ ವಿಚಾರಿಸಿದೆ, ಯಾಕಪ್ಪ ಇನ್ನು ಮಗಳನ್ನ ನಿನ್ ಮನೆ ಕರ್ಕೊಂಡ್ ಬಂದಿಲ್ಲ ಅಂತ. ದಿವಸ ಅವನೇ ಕರ್ಕೊಂಡ್ ಬರ್ತಾ ಇದ್ದ ಮಗಳನ್ನ ಮನೆಗೆ. ಇವತ್ತಾದ್ರೂ ನಿನ್ ಮನೆ ಕರ್ಕೊಂಡ್ ಬಂದಿಲ್ಲ ಯಾಕೆ ವಿಚಾರಿಸಿದೆ. ಅವನು ಹೋಗಿ ಸತೀಶ್ನ ಹತ್ರ ಕೇಳಿದ. ಸತೀಶ ಹೀಗೆ ಹೇಳಿದ. ಅಲ್ಲಿಂದ ಅವನು ಸತೀಶ ಹೇಳಿ ಜಾಗಕ್ಕೆ ಹೋದ. ದಾರಿಯಲ್ಲಿ ಇನ್ನೊಬ್ಬರು ಕೇಳಿದ. ಕೊರಕಲ್ ಮಠದ ಹತ್ರ ಹೋದ್ರು ನೋಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರು. ಕೊರಕಲ್ ಮಠದ ಹತ್ರ ಹೋಗಿ ನೋಡಿದಾಗ ತನ್ನ ತಮ್ಮ ತಾನು ಹೋಗಿ ನೋಡಿದಾಗ ಅಲ್ಲಿ ಆರೋಪಿ ಮತ್ತು ಹರ್ಷಿತಾ ಇದ್ದರು. ಅದು ತಮ್ಮ ಹೇಳ್ತಾಳೆ. ಹಾಗಾಗಿ ಅವಳು ಅದು ಮತ್ತೆ ಫರ್ದರ್ ಕ್ಲಾರಿಫೈ ಮಾಡಿದಾಳೆ. ಮಗಳನ್ನ ನಾನು ನೋಡಿದ್ದೆ ಅವತ್ತಿನ ದಿವಸ ಅವಳು ಮನೆಗೆ ವಾಪಸ್ ಬಂದ್ರ ಮೇಲೆ. ಅವಳು ವಾಪಸ್ ಬರುವ ಮುಂಚೆ ನಡೆದ ಘಟನೆಯನ್ನು ನಾನು ನೋಡಿಲ್ಲ. ಇನ್ನು ಅವಳು ಹೇಗೆ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾಳೆ ಅಕ್ಯೂಸ್ ನ?
The evidence of PW1 alone, my lords, stick on to the evidence of PW1, my lords, on this aspect, my lords. The remaining part, my lords, that is through the evidence of IO, my lords, identification, my lords, that is proved with the evidence of PW1 and 13 IO. The next point, my lords, urged by the petitioner is that, my lords, nobody speaks about the age of the victim girl, my lords, to show that she is below 10 years of age to attract the provisions of section 316. My lords, in this regard, my lords, prosecution has examined PW1, 2, and 3, my lords, who speaks about the age of the victim girl. PW1, my lords, in the second sentence, my lords, from the top. ಚಾಸನಾಕ ಪ್ರತಿಭಾ ನನ್ನ ತಂಗಿ, ಹರ್ಷಿತಾ ನನ್ನ ತಂಗಿ ಅಡೆನಾಳಿ ಸಿಟಿಸನ್ ಶಾಲೆಯಲ್ಲಿ ಬೇಬಿ ಸಿಟ್ಟಿಂಗ್ ಓದುತ್ತಿದ್ದಳು. ನೆಕ್ಸ್ಟ್ PW2 ಆಲ್ಸೋ ಮಲರ್ಸ್ So PW3 evidence, my lords, I will go to PW3 evidence. PW2 sorry ಇಲ್ಲ ಅದರಲ್ಲಿ PW2
ಹೇಳಿಲ್ಲ ಅಲ್ವೇ?
PW3 evidence
PW1 PW3 ಮಾತ್ರ ಹೇಳಿರೋದಲ್ವೇ?
babysitting means, my lords, babysitting, my lords, Millards, parents admit their children to the school, Millards, at the age of 6 years for first standard. Millards, this first standard, Millards, before admitting to the first standard, Millards, the student has to complete Millards LKG and UKG. Before LKG and UKG, Millards, babysitting starts. LKG and UKG starts at the age of 4 years and 5 years. Well, this babysitting comes at the age of 3 years. The prosecution beyond reasonable doubt, the proves the age of the victim girl, that she is below the age of 3 years. Therefore, it attracts the section of provisions of section 369. The PW1 has also identified the chain at page 4 of the PW1 evidence. In the chief examination, yes, Muddam Muddyamal Vanda in the Gutsalagide. With this, the prosecution has proved its case. When the accused was examined under 313 statement, when the incriminating circumstances arising against him, as to how he came in possession of MO1, he failed to offer his explanation. Failing to offer explanation for possession of MO1 under 313 statement, presumption has to be drawn that he has committed the offense. Reported in 2019-14 Supreme Court, page 438 minutes. Not admit minutes, I will read it. Shall I mark it and pass it on? Yes. Yeah, head note B, yes, please. Criminal Procedure Code 1973, Section 313. Examination of accused under silence of accused, what it indicates, it leads to adverse influence against the accused. Evidence Act 1972, Section 144, 3G, Para 11. That's a short judgment. No, Para 11, it is at page 4. 11. No explanation is forthcoming from the statement of the accused under section 313 CRPC as to when he parted the company of the victim, and also no explanation is there as to what happened after getting the chocolates for the victim. The silence on part of the accused in such a matter wherein he is expected to come out with an explanation leads to adverse influence against the accused. Yes. So therefore, my lords, failing to offer explanation, my lords, about position of MO1, my lords, adverse inference has to be drawn against the accused, and request my lord to hold that the accused has committed the offence. Any reply? Not as far as not the prosecutors not sufficient concern. But since not the PW, not 1 and 3, not who stated not she was studying babysitting. So therefore, not there cannot be a presumption assumption. They have to place not cogent material. Not since not the incident of the year not 2009. They must have placed not some material with regard to not date of birth. Instead of that, not merely saying that not she was not studying babysitting, that cannot be hold that not she is not the law requires not she must be less than 10 years. The law requires she must be less than. There must be place some material. Without which there cannot be an assumption presumption. Law requires precision. That there must be some evidence. That regard. Not even the IO doesn't say not anything with regard to that. He recovered not some material. Since not she was school going child according to the prosecution. If that is the case, not they would have secured the documents from the school authority. If that is the case. So therefore, when the law requires not within less than 10 years of old, not when they are not placed any material, the ingredients of section 399 is not approved. That is not challenged in the cross-examination, my lord, by denying that the Arshita was not below the age of 10 years. No, not necessary, because ultimately it's burden upon the prosecution.
They make a submission, my lord.
Yes, please.
Yes, with regard to minutes, of PW minutes, with regard to start minutes, made a submission minutes, stand by my correct minutes, therefore minutes. Stand corrected, my lords.
The guide need to add 1.5 page extra in the judgment, despite giving you this sufficient clues and hints. I give you one more clue. Have you gone through the evidence of PW2? Have you ascertained the role of PW2? You did not wish for anything about the evidence of PW2 in your argument. Counsel from both sides. Heard the argument of respondent, reply by the learned counsel for the petitioner. Orders reserved. Yes.
46. Gonna be Tumbagi.
This is 480 minutes.
Yes. 380. 380.
Just been heard sometimes.
Yes. T5 ಮೇಲೆ ಸರ ಕಾಣೆ.
The IO has not been examined in this matter.
What it says? First, tell me the principle and then pass it on.
The information received from the accused, delivery of facts. Not in this matter, not what happened. The accused was PW5 brought the not the accused before the not the PSI. Not the he has explained the not the wherever he has committed the theft and all. Subsequently, my lord, this IO has not been examined before the court. Not that is the matter, not in this matter. Not the in that respect, not the section 27 of not the Evidence Act. Not the clear not.
So before whom the is it according to you the recovery was made based upon the alleged voluntary statement of the accused?
Yes, yes, yes.
Is it your argument that the investigating officer who recorded the voluntary statement was not examined?
Not examined. He is the person, he is supposed to not the explain what he has given statement before him, or which related to the not the recovery of not all those not the articles. He has not been examined in this matter.
The person who recorded voluntary statement has not been examined.
Yes.
Whether the person who recorded the alleged voluntary statement was the investigating officer in this case,
yes,
or was an investigating officer in some other crime?
In this case also not he is the investigating officer. In this case also not he is
Not
the,
also I'm asking. Voluntary statement according to you has been recorded by one police officer,
yes,
right?
Yes.
Whether that police officer was the investigating officer in this crime, or was he an investigating officer in some other crime?
In this crime, Lord, he is the investigating officer.
PW?
PW not he has not been examined. But,
then who has spoken about the voluntary statement?
only not the other not the Caesar major witnesses, not who are not the PW3, my lords, and PW3.
PW 2 and 4 are the not the spot major witnesses. Not PW 5 is not one Manjunath police constable whom lot of the arrested this person and brought before the not the PSI and not this accused not alleged to have stated before him stating that not he has committed the theft of article. But the date of alleged incident is on 6/6/2006. The date of complaint is 17/8/2006. The PW5 Munoz, who has arrested Munoz this accused and brought before the Munoz the PSI and Munoz wherein Munoz he had disclosed Munoz he committed the theft in Munoz theft. Munoz that led into Munoz the recovery of the articles. Subsequently, this complainant hearing, in this informant hearing, had given a complaint on 17/8/2006, the missing of his chain, the theft of his chain in his the house. Hearing on 6/6/2006, this PW1, the Govindraj, alleged that in his complaint kept his gold chain over the teapot. He went to the take bath. When he coming back, the chain was not there. And subsequently, he saw the recovery of chain and the arrest of accused in the print media. And subsequently, went to the police station and they identified the chain and all.
Whether he identified the chain on the same day of his complaint or on subsequent day.
The complaint is on 6/6/2000. The complaint is on 17/8/2006. The alleged incident was taken place on 6/6/2006.
When he identified the chain in the police station.
He stated that on the identification was done on 17/8/2006 on the date of complaint. On the same day.
So according to you, on the very same date of complaint, he has identified the chain in the police station, right? If that were to be the case, where is the question of the investigating officer in this crime recording the voluntary statement of accused which has led to recovery of the chain arises?
Voluntary statement also. The number 16, the voluntary statement, they have not mentioned the date also. Voluntary statement.
You are not answering to my question. If according to you, on the very same date of complaint, if he has seen the golden alleged stolen article in the police station and identified it, then where the question of investigating officer in this case recording the voluntary statement of the accused which allegedly have led for the recovery of the chain arises?
This matter, what happened? PW5 he has brought this person to before the PSI. That day, he has recorded the statement of voluntary statement of this accused, and subsequently, some recovery has been made on the same day, and subsequently, he stated we have committed the theft in some other houses also. He recorded the statement, and this the sub inspector, the statement.
Yes.
Check not of this on examination of not of this investigating officer.
Still you remain not answering my question.
Not of the voluntary statement of accused also not of the date not been mentioned.
Anything else? ಯಾವ ಜಜ್ಮೆಂಟ್ ಬೇಡ, ನೀವು ಫ್ಯಾಕ್ಟ್ ಸರಿ ಹೇಳಿ ಬಿಟ್ರೆ ಸಾಕು. ಆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿರೋದೆಲ್ಲದು ನಮ್ಗೆ ಗೊತ್ತಿರ್ತದೆ, ಸುಮಾರಷ್ಟು ಅದನ್ನು ಬರೀತೇವೆ. ಅದಕ್ಕೆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೋಟ್ ಮಾಡಿನೇ ಬರಿಬೇಕಂತಿಲ್ಲ, ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಬರೆದ್ರೆ ಸಾಕು.
ತಮ್ಮದೇ ಒಂದು ಜಜ್ಮೆಂಟ್
ಇರ್ಲಿ. ಏನ್ ಹೇಳಿದ್ರೆ ಏನ್ ಪಾಯಿಂಟ್ ಇದೆ ಹೇಳಿ.
ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಲ್ಸೋ ಮಾಡುತ್ತೆ ನಾನ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ಮಾಡುತ್ತೆ ಅಯ್ಯೋ.
ಇದರಲ್ಲಿ ನಿಮಗೆ ಯಾವ ಅಯ್ಯೋ ವಾರಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ನೋದೇ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಪದೇ ಪದೇ ನಿಮ್ಗೆ ಪ್ರಶ್ನೆ ಶುರುವಾದಲ್ಲಿಂದ ಕೇಳ್ತಾ ಇದ್ದೇನೆ, ಹಾಕಿದ ಪ್ರಶ್ನೆ ಉತ್ತರ ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲದನ್ನೂ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಬೆಳಗ್ಗೆಯಿಂದ ಸಂಜೆ ಒಳಗೆ ನಾನು ಸರಿಸುಮಾರು 40 ಪ್ರಶ್ನೆ ಕೇಳಿದೆ ಅಂದ್ರೆ 2 ಅಥವಾ 3ರಲ್ಲಿ ಮಾತ್ರ ಸ್ಪಷ್ಟ ಉತ್ತರ ಬರ್ತದೆ. ಇನ್ನು ಉಳಿದಿರೋ 37-38 ಪ್ರಶ್ನೆಗಳಿಗೆ ಪ್ರಶ್ನೆ ಬಿಟ್ಟು ಬೇರೆದನ್ನೇ ಹೇಳ್ತಾರೆ, ವಿಷಯಾಧಾರ ಮಾಡ್ತಾರೆ. ಮೊದಲನೇ ಪ್ರಶ್ನೆ, ಯಾರು ವಾರಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಹೇಳ್ತೀರಿ. ಅದೇ ವ್ಯಕ್ತಿ ಈ ಪ್ರಕರಣದ ಐಒನ, ನೀವು ಅದ್ರ ಬಗ್ಗೆ ಇನ್ನೂ ಹೇಳಲಿಲ್ಲ. ಅದಕ್ಕೆ ನಿಮ್ಗೊಂದು ಕ್ಲೂ ಕೊಟ್ಟೆ ನಾನು. ಕಂಪ್ಲೇಂಟ್ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಕಂಪ್ಲೇಂಟ್ ನ ಚೈನ್ ಅನ್ನ ನೋಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಂಪ್ಲೇಂಟ್ ನೋಡಿ ಚೈನ್ ಅನ್ನ ನೋಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಈ ಕೇಸಿನ ಐಒ ರಿಕವರಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಹೇಗೆ ಬರ್ತದೆ? ನೀವು ಅದಕ್ಕೂ ಏನು ಹೇಳಲಿಲ್ಲ. Yes, Mr. HCGP.
It is raised, 3-4 grounds,
ಒಂದೇ ಮೇಜರ್ ಗ್ರೌಂಡ್ ರಿಕವರಿ ನಾಟ್ ಪ್ರೂವ್ ಹೇಳಿ ಆ ಪಾಯಿಂಟ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ.
No eyewitness. ಆಮೇಲೆ IO is not examined and delay.
IO not examined. Recovery not proved. IO not examined is the path.
Delay in lodging complaint is not examined. Is not offered.
Yes.
With regard to delay, my lords, PW1 in his chief examination, my lords, he has offered explanation for the delay, my lords, from the fourth line.
Is it a convincing explanation?
That is the my lords have to accept.
Then how can you say that is the explanation which court is required to accept it?
That is my lord, that is the explanation offered by the complainant, my lords. I can't go beyond the pleadings. Lord, that is the explanation.
Cannot go beyond the pleading, cannot go beyond evidence. I have told you on the very first day that
No advocate in any appeal revision.
Yes. Cannot.
Or you cannot say that I cannot improve the case.
Yes.
Which is already there before me in the trial court.
Sir, that nobody can improve.
But the knack and the intelligence lies, how do they understand, read and make the court to understand the existing evidence, existing material? That is advocacy. It is advocacy. Yes.
Yes, he has to offer explanation for not lodging the complaint at the earliest point of time immediately after the theft. ಹುಡುಕಾಡ್ದೆ ನನಗೆ ಆಮೇಲೆ ಸಿಕ್ಲಿಲ್ಲ, ಸುಮ್ಮನೆ ಆದೆ. ಆಮೇಲೆ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದು ರಿಕವರಿ ಆಗಿದೆ, ಥೆಫ್ಟ್ ಆಗಿದೆ, ಕಳ್ಳ ಸಿಕ್ಕಿದೆ ಅಂತ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಾಗ ಇಮಿಡಿಯೇಟ್ಲಿ ಐ ವೆಂಟ್ ಅಂಡ್ ಲಾಡ್ಜ್ ದಿ ಕಂಪ್ಲೇಂಟ್. ದೇರ್ಫೋರ್ ಮೈ ಲಾರ್ಡ್ಸ್, that is the explanation offered for delay.
Yes.
No eyewitness, my lords. No eyewitness andre my lords in case of theft, robbery, dacoity. My lords knows, my lord, absolutely there will not be any eyewitness, my lords, in these type of cases, my lords. My lords, only on the based on the circumstantial level, that is recovery, my lords, identification, my lords, on the basis of voluntary statement, my lord, the prosecution, my lords, proves its case and connecting the crime to the accused. My lord, the next point, my lords, delay that is considered, my lords, IO is not examined. IO, my lords, that aspect, my lords, both the courts below, my lords, have considered this aspect. And held that the non-examination of IO, my lords, is not a factor to the case of the prosecution, my lords. My lord, the trial court says that this non-examination is not a factor, and the appellate court, my lords, completely agrees with the findings of the trial court. Directly, I will take my lord to the
So does it mean that I too should agree?
Does it mean that their reasoning that I should necessarily agree?
That's when the other corroborating evidences are necessary, are available. That's only merely because that, my lords, non-examination of IO, my lords, we will not take away the entire case of the prosecution. That's the other aspect.
What are the, ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದ್ರೆ ನೀವೆಲ್ಲ ಒಂದು ಸೆಟ್ ಆಫ್
ಡಿಫೆನ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಟ್ಕೊಂಡಿರ್ತೀರಿ. ಅದನ್ನ A4 ಶೀಟ್ ನಲ್ಲಿ 3/4 ಪೇಜ್ ನಲ್ಲಿ ಬರೀಬಹುದು. 9 ರಿಂದ 11 ಪಾಯಿಂಟ್ಗಳು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ವಾರೆಂಟ್ ಕೇಸಲ್ಲಿ ಆದ್ರೆ ಹೀಗೆ, ಸಮನ್ಸ್ ಕೇಸಲ್ಲಿ ಆದ್ರೆ ಹೀಗೆ. ಸೆಷನ್ಸ್ ಬಂದು 376, 395, 302 ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ ಅಂದ್ರೆ ಅದ್ರಲ್ಲಿ 2 ಪಾಯಿಂಟ್ ಎಕ್ಸ್ಟ್ರಾ ಬರ್ತದೆ. ಅಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವರೆಗೂ ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಉಲ್ಟಾ ಪಲ್ಟಾ ಮಾಡಿ ಅದನ್ನೇ ಇಡ್ತೀವಿ. When there are other corroborative materials and evidences to prove the recovery, the non-examination of the IO is not fatal to the case of prosecution. Fine. That is one of the principle. Show me here in the instant case, in the absence of any appearance of the IO before the court, how can the recovery has stood proved?
In spite of the, my lords, efforts made by the prosecution, my lords, to examine the, my lords, IO, my lords, the para 13 of the session date explains, my lords, the reasons for not examining.
Non-examined, reason for non-examination is different.
Yes, yes.
The fact that he has not been examined
is another aspect.
He is not examined.
The excuses for non-examination of the witnesses evidence act ಇದೆ 32 ರಲ್ಲಿ ಹೇಳುತ್ತೆ. In the inside case won't fall in that section. You said that reason for non-examination was not your argument. Your argument was that since the aspect of recovery has stood proof, the non-examination of the investigating officer is not fatal to the case of prosecution. You convince me on that point. Please elaborate that point.
Recovery point, please. Yes. Recovery mallards exhibit before mallards recovery is proved the evidence of mallards PW 2 and 5 minutes. 2 and 5 the master witness for recovery of chain mallards. He supported mallards so far as recovery of master is concerned.
ಏನು ಹೇಳಿದ್ದಾರೆ ರಿಕವರಿಯಲ್ಲಿ ಅವರು?
ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು. ಅಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಮೂರನೇ ಆರೋಪಿ ಇದ್ದು ನಾನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ನನ್ನ ಚೈನ್ ಸಹ ಕಳವಾಗಿತ್ತು. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನಗೆ ಪೊಲೀಸರು ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಯನ್ನು ತೋರಿಸಿರುತ್ತಾರೆ. ಆಗ ಆರೋಪಿ ನನ್ನ ಕಳುವಾದ ಚೈನನ್ನು ಸಹ ಆತನೇ ಕಳುವು ಮಾಡಿದ್ದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಆರೋಪಿ ಬೇರೆಡೆ ಹಲವಾರು ವಸ್ತುಗಳನ್ನು ಕಳುವು ಮಾಡಿದ್ದ ಬಗ್ಗೆ ತಿಳಿಸಿರ್ತಾನೆ. ಮತ್ತು
ಅದರಿಂದ ಏನ್ ಅರ್ಥ ಆಗುತ್ತೆ? ಈಗ ಓದಿದ್ರಲ್ಲ ಒಂದೊಂದೇ ಸೆಂಟೆನ್ಸ್ ನನಗೆ ವಿವರಿಸಿ.
ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ರಿಕವರಿ ಶಾಲ್ ಐ ರೀಡ್ ಓನ್ಲಿ ರಿಕವರಿ ಮೆಲರ್ಸ್ ಲಾಸ್ಟ್ ಪೂರ್ತಿ ಓದ್ತೀನಿ. ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು. ಅಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ ಆರೋಪಿ ಇದ್ದು ನಾನು ಪೊಲೀಸರಿಗೆ ನನ್ನ ಚೈನ್ ಸಹ ಕಳವಾಗಿತ್ತು, ಇವನ್ ಚೈನು ಕಳವಾಗಿತ್ತು PW2. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನಗೆ ಪೊಲೀಸರು ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಯನ್ನು ತೋರಿಸಿರುತ್ತಾರೆ. ಆಗ ಆರೋಪಿ ನನ್ನ ಕಳವಾದ ಚೈನ್ ಅನ್ನು ಸಹ ಆತನೇ ಕಳವು ಮಾಡಿದ್ದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾನೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಆರೋಪಿ ಬೇರೆಡೆ ಹಲವಾರು ವಸ್ತುಗಳನ್ನು ಕಳವು ಮಾಡಿದ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಮತ್ತು ತಾನು ಕಳವು ಮಾಡಿದ ವಸ್ತುಗಳನ್ನು ಪೊಲೀಸ್ ಕಾಲೋನಿಯ ನನ್ನ ಮನೆಯಲ್ಲಿ ಇಟ್ಟಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು ಕರೆದುಕೊಂಡು ಹೋದರೆ ತೋರಿಸುತ್ತೇನೆಂದು ಹೇಳಿ ಆತನ ಮನೆಗೆ ನಮ್ಮನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾನೆ. ಮತ್ತು ಆತನ ಮನೆಯೊಳಗಿನಿಂದ ಟೈಪ್ ರೆಕಾರ್ಡರ್, ಬ್ಯಾಟರಿಗಳು ಮತ್ತು ಚಿನ್ನದ ಚೈನ್ಗಳನ್ನು ನಮ್ಮ ಸಮಕ್ಷ ಹಾಜರುಪಡಿಸಿದ್ದು ಅವುಗಳನ್ನು ಪೊಲೀಸರು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಆ ಬಗ್ಗೆ ಅಮಾನತು ಪಂಚನಾಮೆ ಸಹ ಬರೆದಿರುತ್ತಾರೆ. ಅದಕ್ಕೆ ನಾನು ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ಸಾಕ್ಷಿ ತನ್ನ ಸಹಿಯನ್ನು ಮಾಜರ್ನಲ್ಲಿ ಗುರುತಿಸಿದ್ದು ನಿಶಾನೆ P4 ಮತ್ತು ಸಾಕ್ಷಿ ಸಹಿಯನ್ನು 4A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅಸಲು ಮಾಜರನ್ನು 46ರಲ್ಲಿ ಇರುತ್ತದೆ. ವಸ್ತುಗಳನ್ನು ನೋಡಿದ್ರೆ ಗುರುತಿಸುತ್ತೇನೆ. ಆರೋಪಿ ಠಾಣೆಯಲ್ಲಿ MO1 ಅನ್ನು ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಗುರುತಿಸುತ್ತೇನೆ. ಸಪೋರ್ಟೆಡ್ ರಿಕವರಿ So for recovery is concerned, prosecution has proved the recovery.
No, conclusion ಹೇಳ್ಬೇಡ್ರಿ. Conclusion leave it to me.
Yes, Malak.
That is my domain. I hold whether prosecution has proved or not.
Yes. Through PW2
Convince me that say in your argument you could be able to convince me that I should necessarily come to a conclusion that prosecution has proved its case. That concluding name that I have to hammer, not you.
Yes.
According to evidence of PW2, read with exhibit P4 proves the recovery, right?
Yes.
Yes.
Along with PW5 minutes.
But then PW5 ಬರುವ first PW4, PW2 ನೀವು ಹೇಳಿದ್ರಿ.
Yes.
PW2 ನಲ್ಲಿ ಅವನು ಏನು ಹೇಳಿದ್ದಾನೆ ನೋಡಿ. ಈಗ ಓದಿದ್ದನ್ನೇ ಇನ್ನೊಮ್ಮೆ ಓದಿ ಮೇಲ್ಗಡೆಯಿಂದನೇ.
ಹೀಗೆ 1.5 ವರ್ಷದ ಹಿಂದೆ ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು.
ನೀವು ಪೂರ್ತಿ ಓದ್ಬೇಕ್ರಿ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ನೀವು ಸರಿ ಓದ್ಲಿಲ್ಲ. ಎಸ್ ಓದಿ.
ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು. ಅಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 3ನೇ ಆರೋಪಿ ಇದ್ದು, ನಾನು ಪೊಲೀಸರಿಗೆ ನನ್ನ ಚೈನ್ ಸಹ ಕಳವಾಗಿತ್ತು. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನಗೆ ಪೊಲೀಸರು ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಯನ್ನು ತೋರಿಸಿರುತ್ತಾರೆ. ಆಗ ಆರೋಪಿ ನನ್ನ ಕಳವಾದ ಚೈನ್ ಅನ್ನು ಸಹ ಆತನೇ ಕಳವು ಮಾಡಿದ್ದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾನೆ.
ಒಂದು ನಿಮಿಷ ಅಲ್ಲಿಗೆ ನಿಲ್ಲಿ. ನಿಲ್ಲಿ. PW2 went to the police station. Why? For what purpose he went to the police station?
Yes, ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಪೊಲೀಸರು ಆರೋಪಿಯನ್ನು ತೋರಿಸಿದರು. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ.
ಹಿಂದಿನ ಸೆಂಟೆನ್ಸ್ ಓದಿ.
ಎಸ್ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 3ನೇ ಆರೋಪಿ ಇದ್ದು, ನಾನು ಪೊಲೀಸರಿಗೆ ನನ್ನ ಚೈನ್ ಸಹ ಕಳವಾಗಿತ್ತು. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ.
ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ.
ಹೀಗೆ 1.5 ವರ್ಷದ ಹಿಂದೆ ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ದರು.
ಫುಲ್ ಸ್ಟಾಪ್. ಏನ್ ಹೇಳಿದಾನ ಅದರಲ್ಲಿ? ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ರು. ಹಿ ವಾಸ್ ಸಮನ್ಡ್ ಬೈ ದಿ ಪೊಲೀಸ್. ಹಿ ವಾಸ್ ಸಮನ್ಡ್ ಬೈ ದಿ ಪೊಲೀಸ್. ನಂತರ ಏನ್ ಹೇಳಿದಾನೆ?
ಅಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವ 3ನೇ ಆರೋಪಿ ಇದ್ದು, ನಾನು ಪೊಲೀಸರಿಗೆ ನನ್ನ ಚೈನ್ ಸಹ ಕಳವು ಆಗಿತ್ತು. ನಾನು ಫಿರ್ಯಾದನ್ನು ನೀಡಲು ಹೋಗಿದ್ದೆ.
ಪೊಲೀಸರು ನನ್ನನ್ನು ಕರೆಸಿದ್ರು ಅನ್ನೋದು, ನಾನು ಫಿರ್ಯಾದು ನೀಡಲು ಹೋಗಿದ್ದೆ ಅನ್ನೋದು ಒಟ್ಟೊಟ್ಟಿಗೆ ಬರುವ ಸಾಧ್ಯತೆ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಇದೆಯಾ? ಒಂದೋ ಪೊಲೀಸರನ್ನು ಕರೆಸಿರ್ಬೇಕು, ಅಥವಾ ಇವನು ಚೈನ್ ಕಳ್ತನ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗಿರ್ಬೇಕು. ಅದೆರಡರಲ್ಲಿ ಯಾವ್ದನ್ನ ನಾನು ತಗೊಳ್ಬೇಕು ಮತ್ತು ಯಾಕೆ?
Here, my lord, the purpose of examining PW2, my lords, is to prove the recovery, my lords.
ರಿಕವರಿ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಈ ಸಾಕ್ಷಿ ಹೇಳೋದನ್ನ ನಂಬಲು ಅರ್ಹ ಅನ್ನೋದು ಗೊತ್ತಾಗ್ಬೇಕಲ್ವೇ? ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಅದನ್ನೇ. ಪೊಲೀಸರು ಕರ್ಸಿದ್ರು ಅಂತ ಹೇಳ್ತಾನೆ, ನಾನೇ ಹೋಗಿದ್ದೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತಾನೆ. ಇವನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬಾರಯ್ಯ ಅಂತ ಪೊಲೀಸರು ಕರ್ಸಿದ್ರು ಅಂತ ಇವನು ಹೇಳಲಿಲ್ಲ, ಅಥವಾ ಪೊಲೀಸರು ಕರೆದು ಕಂಪ್ಲೇಂಟ್ ತಗೊಂಡ್ರು ಅಂತ ಇವನು ಹೇಳಲಿಲ್ಲ. ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದೆ ಅಂತ ಒಂದ್ ಕಡೆ, ಪೊಲೀಸರು ಕರ್ಸಿದ್ರು ಅಂತ ಇನ್ನೊಂದ್ ಕಡೆ. ಅವ್ರ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ.
ಆ ಸಂದರ್ಭದಲ್ಲಿ ನನಗೆ ಪೊಲೀಸರು ನ್ಯಾಯಾಲಯದ ಮುಂದಿರುವ ಆರೋಪಿಯನ್ನು ತೋರಿಸಿರುತ್ತಾರೆ. ಆಗ ಆರೋಪಿ ನನ್ನ ಕಳವಾದ ಚೈನ್ ಅನ್ನು ಸಹ ಆತನೇ ಕಳವು ಮಾಡಿದ್ದು ಎಂದು ತಿಳಿಸಿರುತ್ತಾನೆ.
ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋದಾಗ್ಲೇ ಪೊಲೀಸ್ನವರು ಕಳ್ಳನ್ನು ಹಿಡ್ಕೊಂಡು ಬಂದು ಕಳ್ಳನ ಹತ್ರನೂ ಏನಾದ್ರೆ ಹೇಳಿಸ್ತಾರೆ, ನಿಮ್ಮನೆ ಸರನು ನಾನೇ ಕದ್ದಿದ್ದೇನೆ.
ಪೊಲೀಸರು ನನ್ನ ಕರೆಸಿದ್ರು ಅಂತ ಹೇಳ್ತಾನೆ, ಕಂಪ್ಲೇಂಟ್ ಕೊಡಕ್ಕೆ ಹೋಗಿದ್ದೆ ಅಂತಾನೆ ಹೇಳ್ತಾನೆ.
ಆದ್ರೆ ಇವನ್ ಚೈನ್ ಕಳ್ತನ ಆಗಿದ್ದ ಕೇಸ್ ಇದಲ್ಲ. ದಿಸ್ ಕ್ರೈಮ್ ಇಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಥೆಫ್ಟ್ ಆಫ್ ಗೋಲ್ಡನ್ ಚೈನ್ ಆಫ್ ಅನದರ್ ಪಾರ್ಟಿ, ಅನದರ್ ಪರ್ಸನ್. ಸೊ ಆ ಪರ್ಸನ್ ಇದ್ದು ಬೇರೆ ಕಥೆ ಆಯ್ತು. ಈಗ ಆ ಪರ್ಸನ್ ಕೇಸಿನಲ್ಲಿ ಈ ಪರ್ಸನ್ ಬಂದು ನನ್ ಚೈನ್ ಕಳ್ತನ ಆಯಿತು, ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ದೆ, ಪೊಲೀಸ್ನವ್ರು ನನ್ನ ಕರೆಸಿದ್ರು. ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋದಾಗ ಕಳ್ಳನೂ ಇದ್ದ, ನಿಮ್ ಚೈನ್ ನಾನೇ ಸರ್ ಕಳ್ತನ ಮಾಡಿತ್ತು ಅಂತ ಕಳ್ಳ ಹೇಳಿದ ಇವನಿಗೆ, ಅಲ್ವೇ? ಒಂದ್ ಫೇಸ್. ಮುಂದೆ ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ ಈ MO1 ರಿಕವರಿ ಆಗಿದೆ ಯಾವ ಪಂಚನಾಮೆ ಅಡಿಯಲ್ಲಿ? ನಿಶಾನೆ P4. ನಿಶಾನೆ P4 ತೆಗಿರಿ. ಕೊಡಿ ನೋಡಿ.
ನಿಶಾನೆ P4 ಯಾವ ಡೇಟ್?
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಮೇಲೆ ಇದೆ ನೋಡಿ.
21/8/2006.
21/8/2006. 21/8/2006. ನಿಮ್ಮ ಪ್ರಕಾರ MO1 ರಿಕವರಿ ಆಗಿರೋದು 21/8/2006 ಡ್ರಾ ಮಾಡಿರೋ ಪಂಚನಾಮೆ ಅಡಿಯಲ್ಲಿ ಅಲ್ವೇ? ಎಸ್. PW1 ಕಂಪ್ಲೇನೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಓದಿ.
ಸಾವಿರದ 6ನೇ ಇಸ್ವಿಯಲ್ಲಿ ನಮ್ಮ ಮನೆ ಸದಾಶಿವನಗರ 6ನೇ ತಿರುವಿನಲ್ಲಿತ್ತು. ದಿನಾಂಕ 6/6/2006 ನಾನು ನನ್ನ ಕೊರಳು ಚೈನ್ ತೆಗೆದು ಟೀಪಾಯಿ ಮೇಲೆ ಇಟ್ಟು ಸ್ನಾನ ಮಾಡಲು ಬಚ್ಚಲ ಮನೆಗೆ ಹೋಗಿದ್ದೆ. ವಾಪಸ್ ಬಂದು ನೋಡಲಾಗಿ ನಾನು ಇಟ್ಟಿದ್ದ ಚೈನ್ ಇರಲಿಲ್ಲ. ನಾನು ಇಲ್ಲಿ ಹುಡುಕಾಡಿ ಸುಮ್ಮನೆ ಆಗಿದ್ದೆ. ಪೇಪರ್ ಮೂಲಕ ನೋಡಿ ನನ್ನ ಚೈನ್ ಸಿಕ್ಕಿದೆ ಎಂಬುದಾಗಿ ಮತ್ತು ಸುಮಾರು ಕಳುವಾದ ಮಾಲುಗಳು ದೊರಕಿವೆ ಎಂದು ಹೇಳಿದ ಕಾರಣ ನಾನು ತಿಲಕ್ ಪಾರ್ಕ್ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದಿ. ಅಲ್ಲಿ ನನ್ನ ಚೈನ್ ಅನ್ನು ಗುರುತಿಸಿ ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ.
ಒಂದ್ ನಿಮಿಷ. ನಾನು ತಿಲಕ್ ಪಾರ್ಕ್ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ಅಲ್ಲಿ ನನ್ನ ಚೈನ್ ಅನ್ನು ಗುರುತಿಸಿ ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡುವ ಮುಂಚೆ ಇವನ ಚೈನ್ ರಿಕವರಿ ಆಗಿದೆ, ಅದನ್ನ ಇವನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾನೆ. ಆ ಕಂಪ್ಲೇಂಟ್ ಯಾವ ತಾರೀಕು ಕೊಟ್ಟಿದ್ದಾನೆ? ಕೊಡಿ ಆ ಎಕ್ಸಿಬಿಟ್ ಕೊಡಿ.
ಕಂಪ್ಲೇಂಟ್ Complaint
17/8/2006 ಅವನು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಅವನ ಕಳ್ಳತನ ಆಗಿರೋ ಚೈನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇದೆ. ಆ ಚೈನ್ ನೋಡಿ ಗುರುತಿಸಿ ಇವನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾನೆ. ನಿಮ್ಮ ಪ್ರಕಾರ ಎಕ್ಸಿಬಿಟ್ P4 21/8/2006 ಅಂದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಆಗಿ 4 ದಿವಸದ ನಂತರ ಸೀಸರ್. ಕಂಪ್ಲೇಂಟ್ ಆಗಿ 4 ದಿವಸದ ನಂತರ ರಿಕವರಿ ಸೀಸರ್ ಆಗಿದೆ ಅಂತ ಆದ್ರೆ ಇವನು 4 ದಿವಸ ಮುಂಚೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋದಾಗ ಆ ಕಳ್ಳತನ ಆಗಿದ್ದ ಚೈನ್ ಅನ್ನ ನಾನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ನೋಡಿ ಗುರುತಿಸಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳೋದು ಹೇಗೆ ಸಾಧ್ಯ?
was registered on 17th itself.
That on 17/8. So recovery is on 21/8.
ಹೇಳಿದ್ವಿ ಈಗಷ್ಟೇ ಹೇಳಿದೆ ದಿವಸಕ್ಕೆ ನಾನು 40 ಪ್ರಶ್ನೆ ಹಾಕಿದ್ರೆ 37 ಪ್ರಶ್ನೆಗಳಿಗೆ ನೇರವಾದ ಸ್ಪಷ್ಟವಾದ ಉತ್ತರ ನಿಮ್ಮಗಳಿಂದ ಬರಲ್ಲ. ಇದು ಅದರ 38ನೇ ಪ್ರಶ್ನೆ. ನೇರ ಉತ್ತರ ಇಲ್ಲ, ಸ್ಪಷ್ಟ ಉತ್ತರ ಇಲ್ಲ. ಮತ್ತು ಆ 4 ಇದ್ರೂ ಕೂಡ ನೀವು ರಿಕವರಿ ಇಸ್ ಪ್ರೂವ್ಡ್ ಬೈ ಎಕ್ಸಿಬಿಟ್ P4, ರಿಕವರಿ ಇಸ್ ಪ್ರೂವ್ಡ್ ಬೈ ದಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2 ಅನ್ನೋದನ್ನ ಹೇಗೆ ಅಷ್ಟು ಜೋರಿನಿಂದ ಹೇಳಿದ್ರಿ ವಿತ್ ಗ್ರೇಟರ್ ಫೋರ್ಸ್? ಯುವರ್ ಓನ್ ಎವಿಡೆನ್ಸ್, ಯುವರ್ ಓನ್ ಡಾಕ್ಯುಮೆಂಟ್.
The evidence only minutes. Recovery measure is proved. Therefore, I submitted minutes. Recovery minutes it is proved.
The recovery measure is proved. Therefore, I submitted recovery measure is proved. Andre, you should convince me that recovery measure is proved. Merely because the trial court has said that recovery measure is proved, I need not.
Yes. Your lordship can take independent minutes.
That is why the revision is clear
Yes,
before
yes,
me.
yes.
Take down. ಕೂತ್ಕೊಳ್ಳಿ. Permission of conviction PC. Summary of the case of the prosecution. The trial court was that on the date 6/6/2006, when PW1 bracket CW1 had kept his golden chain in his house at Sadashivanagara within the limits of complainant police station and had gone to his bath, he noticed that the said chain was found missing when he finished his bath and saw to it. Thereafter, he kept quiet for some time without proceeding further in the matter. After some time, through newspaper, he came to know that the complaint police had recovered some quantity of the stolen articles, including the golden chains. As such, he went to the police station on the date 17/8/2006, finding his stolen chain also in the police station and identifying the same, he lodged a complaint. According to him, after registering the complaint, the police visited the spot and drew a scene of offense Panchanama. After completing the investigation, the police filed charge sheet against the accused for the offense punishable under section 380 of Indian Penal Code. ಮೇಲ್ಗಡೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿಯನ್ನು ಬರಬೇಕು. Learned. Amicus curiae for the petitioner in his brief argument submitted that there is an inordinate delay in lodging the complaint which has not been satisfactorily explained by the complainant. With more emphasis, he submitted that the investigating officer who is said to have conducted investigation in this matter has not been examined by the prosecution, which is fatal to the case of prosecution. He submitted due to non-examination of the investigating officer, the alleged recovery of this alleged stolen article or the alleged instance of the accused also has not been proved. However, both the trial court and the session judges court have
erroneously held the accused as guilty of the alleged offense. Learned HCGP in his argument submitted that the delay for lodging the complaint has been satisfactorily explained by the complainant in his complaint itself. He also submitted that the non-examination of the investigating officer is not fatal to the case of prosecution in all the cases. He submitted, since the recovery at the instance of the accused has been proved by the other material witnesses examined by the prosecution, the non-examination of the investigating officer would not in any manner weaken the case of prosecution. As such, since both the trial court and the session judges court have appreciated the evidence placed before them in their proper perspective and rightly convicted the accused for the alleged guilt, the interference in those judgments is not warranted. In order to prove the alleged guilt against the accused, the prosecution examined five witnesses from PW1 to PW5. I got marked 4 documents from exhibit P1 to P4 and a material object at MO1. Among the 5 witnesses examined by the prosecution, PW1 is the complainant who in his examination chief has stated that reiterated the contention taken up by him in his complaint, which complaint he has identified and got marked as exhibit P1. He has stated that though his chain was found lost on the date 6/6/2006, however, he kept quiet. Subsequently, based upon a newspaper report about the recovery of some quantity of the stolen ornaments, he went to the complainant police station. There, after seeing his chain and after seeing his lost chain and identifying the same, he lodged the complaint. It also stated that the police had drawn a scene of offense Panchanama on spot shown by him as per exhibit P2. Further, the witness has stated that some days afterwards, the police had brought the accused to his house, who stated before the police that he had stolen the golden chain from the said house, in which regard also a Panchanama was drawn, which this witness has identified at exhibit P3. Thus, according to the evidence of PW1, before he could lodge his complaint on 17/8/2006, there was already the alleged recovery of the golden chain, which according to the prosecution was at the instance of the accused. Therefore, it is not the case of the prosecution that after the complaint of the complainant on 17/8/2006, police proceeded to. Therefore, it is not the case of prosecution. Therefore, it could not be the case of prosecution that it is after the complaint dated 17/8/2006. They apprehended the accused and recovered the stolen MO1 at the instance of the accused under a Panchanama. However, according to learned HCGP, the seizure of the article was not only at the instance of the accused, but also It was under a Caesar Panchanama as per exhibit P4. With great emphasis, the learned HCGP submitted that the recovery of the stolen article, that is MO1, was made on 21/8/2006 at the instance of the accused, to which Act PW2 was present as a pancha and has signed the witnessed the incident by subscribing his signature as a witness to the Caesar Panchanama at exhibit P4. Yeah. A reading of the evidence of PW2 would go to show that he has stated that about 1.5 years prior to the date of his evidence, which was on 24/1/2008, the police had summoned him to police station. In the police station, accused number 3 was present. In the very next breath, the said witness has stated that since his chain was also stolen, he had been to the police station to lodge a complaint. Thus, in the very opening statement itself, he has made a contradictory statement, initially by stating that the police had summoned him, and subsequently stating that he himself had been to the police station to lodge a complaint. He has further stated that at that time, the accused number 3, who was present in the court, the accused number 3, who according to him was the accused present in the court, was present. Whether the accused in the instant case was the accused number 3 or was he a sole accused?
This case is the sole accused.
In this case,
he
is a single accused.
Sole accused.
Sole accused.
Sole accused. Yes.
Thus, this witness calling the present accused as the third accused is also not the case of prosecution, as the case of prosecution is that the present petitioner was the sole accused in the commission of crime, in the alleged commission of crime. The said witness, that is PW2, has further stated that after he seeing the accused in the police station, the accused stated that it was him who had stolen the chain of PW2 also, of PW2. That means PW2, and he also revealed about he committing theft of several other articles at different places, and that he would show those articles if he is taken to his house at Maran Colony. Accordingly, he led them to his house at Maran Colony. By stating as above, PW2 has given more emphasis about accused producing the alleged stolen chain of this witness rather than the alleged stolen chain of PW1, the complainant. PW2 has further stated that accused led them to his house, and from inside of his house he brought and produced tape recorder, batteries, and golden chains. The police drew a Caesar Panchanama as per Exhibit PA in his presence. The witness has identified the said Panchanama and the signature therein at Exhibit PA and P4A respectively. Sapyara. It is relying upon the said evidence of PW2 and alleged Caesar Panchanama at Exhibit P4, the learned HCGP vehemently submitted that the recovery at the instance of the accused has been proved beyond reasonable doubt, and the same has, and the recovery has been established by the evidence of PW2 coupled with Exhibit P4. Sapyara. A careful perusal of Exhibit P4 would go to show that the said Mahajar is shown to have been drawn on the date of 21/8/2006. Even according to PW1, the complainant, by the time he went to the police station on the date 17/8/2006, his alleged stolen article was already there in the police station. As such, it is after identifying his lost chain in the police station, he proceeded to lodge a complaint. That means, at least 4 days prior to the alleged Caesar Panchanama at Exhibit P4, the alleged stolen article of the complainant, which is at MO1, was already there before the police in the police station. Therefore, it cannot be deduced that the stolen article at MO1, as identified by PW1, was seized under a Panchanama at Exhibit P4. In addition to the above, a careful reading of Exhibit P4 also would go to show that nowhere in the said Panchanama it is mentioned that the golden chains alleged to have been stolen from the house of PW1 was also one among the items said to have been produced by the accused under the said Panchanama at Exhibit P4. On the other hand, a combined reading of the evidence of PW2 with Exhibit P4 would go to show that PW2 was intended to say and has stated that since his chain also was stolen and accused was alleged to have revealed in the police station before him that he would produce the stolen article, the accused led them to his house and produced certain articles, which appears to have been included the alleged stolen chain of PW2, but not of PW1, which is the subject matter of the present case. Therefore, Exhibit P4 is in no way connected to the alleged Caesar Panchanama or recovery said to have been made in the instant case. Sabupyara. This is furthermore supported by none else than the PW2 himself in his very same evidence, who has further stated that the accused produced the chain at MO1 in the police station itself. Stating so, PW2 has identified the said chain at MO1. The categorical statement made by none else than PW2, who is said to be the Pancha to Exhibit P4, would further make it clear that the alleged seizure shown to have been made under Exhibit P2 was with respect to some other articles, but not with MO1, and that if at all MO1 was secured by the police, that was in their police station, not anywhere outside. Further, PW2 also has not stated that even in the police station also, it was the elaborate act. Therefore, the argument of the learned HCGP that
Evidence of PW2 corroborated by Exhibit P4 would establish the alleged recovery establishes the recovery made at the instance of the accused is not at all acceptable. Not at all acceptable. Yeah. The above evidence, the above finding further gets corroboration in the evidence of PW3 and PW5. According to PW3, he is one more bunch of to the alleged Caesar Panchanama at Exhibit P4. The said witness has stated that accuser led them to his house at Maran Colony and from his house produced golden chain, tape recorder and batteries, which the police seized by drawing a Caesar Panchanama as per Exhibit P4. Yet of stating that this witness has not stated that the said golden chain alleged to have been produced by the accused in his house was the very same golden chain which was at MO1. Therefore, the golden chain said to have been produced by the accused from his house can't be and said to have been seized under Exhibit P4 cannot be the chain at MO1. This I am repeating for one more reason, that the evidence of PW5 also gives the very same inference. Admittedly, PW5 is a police constable working in the complainant police station. He has stated that on the date of 21/8/2006, which is admittedly 4 days after registration of complaint in the instant case, the accused led them, that is i.e. his police inspector, accompanied by this witness and Panchas, to his house, who has stated that on 21/8/2006, which is admittedly 4 days after the registration of the complaint in this case, based on suspicion, he apprehended the accused who was moving near Caltex petrol bunk on BH Road. After apprehending him, he produced him before his police sub-inspector in the police station. There in the police station, at the inquiry of the police inspector, the accused produced a chain in front of the police inspector. And then he led them to his house, and from the house produced 6 tape recorder, 2 chains, which the police inspector seized by drawing a Caesar Panchanama as per Exhibit P4. Thus, according to PW5, the first chain said to have been seized at the recorded instance of the accused was not at his house but in the police station. But the said recovery was not on 17/8/2006, that is, when the complainant went to the police station and identified his lost chain in the station, but it was 4 days thereafter, that was on 21/8/2006. As such, the chain alleged to have been produced by the accused in the police station cannot be the one at MO1. Further, it is also not the evidence of PW5, the police constable, that the remaining 2 chains said to have been produced by the accused from his house was included the chain at MO1. Therefore, the alleged production of the articles from the house of the accused, which were said to have been seized under Exhibit P4, cannot include the chain at MO1. For this reason also, the alleged recovery of the chain at MO1, which according to learned HCGP was under Panchanama Exhibit P4, has not stood to prove. However, for the trial court, not stood to prove. It is in this circumstance, it is in the above circumstance, there was very much necessary of examining the investigating officer, who is said to have recorded the voluntary statement of the accused, and is said to have seized, if any, of golden chain, more particularly MO1, at the instance of or from the possession of the accused. Therefore, though it cannot be held that in all cases necessarily the investigating officer must be examined, however, in those cases where in order to prove the alleged guilt of the accused beyond reasonable doubt, there is circumstances warrants that the investigating officer should necessarily be examined. In such a case, he has to be necessarily examined. In the instant case is one such case where, since the evidence of other prosecution witnesses, including the alleged Panchanama, Caesar Panchanama, could not able to establish the alleged seizure of the article or alleged recovery at the instance of the accused, it was very much necessitated for the prosecution to examine the investigating officer. As such, the investigating officer, admittedly, in the instant case, the investigating officer has not been examined. Further, as analyzed above, the evidence of neither PW2 nor PW3 in any manner inspires confidence to believe their version as true, since the evidence of PW2 is completely is full of major contradiction within itself, and the evidence of PW4 and PW5 also gives a different picture than what prosecution case is. However, whereas both the trial court as well as the session judges court, without appreciating the evidence placed before them in their proper perspective, have merely embraced the statement of PW2 that at the instance of accused, seizure was made as per Exhibit P4, and after seeing that complainant has identified the chain at MO1, have hastily jumped to a conclusion that the prosecution has proved the alleged guilt against the accused beyond reasonable doubt. Since the said finding of the trial court now proved to be a perverse, erroneous, the same warrants interference at the hands of this court. Accordingly, I proceed to pass the following order. The criminal revision petition allowed, set aside Madi, accused is acquitted of the offense punishable so. Acknowledge the assistance extended by the learned amicus curiae. Direct the registry to pay him an honorarium of not less than a sum of ₹4,000 at the earliest. Visitor to transmit copies. The records. Pass over is next matter ನಲ್ಲಿ ಇಬ್ರು ರೆಡಿ ಇದ್ದೀರೇನ್ರಿ? ಇಬ್ರು ರೆಡಿ ಇದ್ದೀರಿ? ಎಷ್ಟೊತ್ತು ತಗೊಳ್ತೀರಿ? 138 ಅದು
138 ಮಾಡಿಸ್ತೀನಿ
ಕೊಡ್ರಿ. ಹಾ,
supported the not the case of the complainant.
ಒಂದು ಸಪೋರ್ಟ್ ಇದೆಲ್ಲ ಶಬ್ದ ಉಳಿದಿದ್ದೆಲ್ಲದನ್ನು ಹೇಳ್ಬೇಕು.
Reply ಇಲ್ಲಿ not he has given check for the discounting and stated.
ಮಾಡುವ. So other matter except the first door matter would not be taken up today. They will be taken up, say, if slot is available someday during this course of the this week. Yes.
will be taken up next week.
Yes. Serial number 50.
Yes.
Learned counsel for petitioner present since the court time is over. This matter in the next week. Yes.
Great.
Seal number 47. Petitioner is Javi.
Check amount is not 1,50,000. Date of the check is not 11/2008. Printed on the same plate. 16/11/2008. Document issued on 18/11/2008. But insufficient. Legal notice.
D1. D1. Yes, please.
Date of check is 16/11/2008.
No, those dates you said.
Yes.
So, friendship not denied, issuance of check not denied, signature not denied, returned not denied, issuance of notice not denied. Only difference is that check was collected by the complainant on the pretext of discounting.
Later on, he did not return the check amount. It is the only defense they have taken. The issuance of check has been admitted.
There were two different views taken by the accused, my lord. In the affidavit and the reply notice, they have stated that the check has been issued for the discount.
Yes.
And in cross-examination of PW1, they have suggested that the check has been given for the purchase of a site.
Right.
These are the two different contradicting statements given by the accused.
The summary of the case of the prosecution, the summary of the case of the complainant in the trial court was that the accused, who was a person known to him, was borrowing money now and then from him. Accordingly, as on 10/1/2008, the accused was paid with a total sum of rupees 1,50,000 by him. All the amounts were paid in cash only. Though the accused had assured to repay the entire debt within few months, he did not repay them. As such, when the repayment was insisted, the accused gave him a check bearing number 720175 dated 16/11/2008, drawn on Canara Bank, Gokula branch, Bengaluru, in favor of the complainant for a sum of rupees 1,50,000. It was a discharge of his liability. The said check, when presented for its realization by the complainant through his banker, returned unpaid with the banker's endorsement as funds insufficient. Thereafter, the complainant got issued a legal notice to the accused demanding the payment of the check amount. In spite of the receipt of the legal notice, the complainant did not pay the check amount, rather sent an untenable reply. This constrained the complainant to institute a criminal case against him in the trial court for the offence punishable under section 138 of NI Act. ಬನ್ನಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಎರಡು ಸೈಡ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಹಾಕಿ ಪಾಯಿಂಟ್ ಹಾಕಿ. The amicus curiae for the petitioner in his argument submitted that though he would not though it remains as admitted fact that the accused was the drawer of the check at exhibit P1 and the same returned unpaid as per banker's endorsement at exhibit P3 and P2, and the complainant thereafter issued a legal notice as per exhibit P3 demanding the check amount. But the true fact is that the complainant, for his business purposes, has obtained the said check on a temporary measure for its discounting, assuring that he would return the said check to the said fact at the earliest point of time has been brought to the notice of the complainant by the accused in his reply, which is at exhibit P5, which is at exhibit P3. However, the trial court, without noticing the same, have not considered the defense of the accused, which was sufficient to rebut the presumption formed in favor of the complainant. Per contra, learned amicus curiae for the complainant, his argument submitted that mere taking a defense which is untenable and contradictory within itself cannot be considered as a successful rebuttal of the presumption that was already formed and crystallized in favor of the complainant. He submitted that the accused has taken two different stands, one in his reply statement and another in the cross-examination of PW1. As such, both the trial court and the session judges court have rightly held the accused guilty of the alleged offence. The complainant, who got himself examined as PW1, has reiterated the contention taken up by him in his complaint. To show that the accused has issued a check to him for a sum of ₹1,50,000 and the same came to be returned unpaid when presented for its realization, with the banker's share as funds insufficient, the witness has produced the return check at exhibit P1 and the banker's endorsement at exhibit P2. The accused, who got himself examined as DW1 in his cross-examination, has admitted that he is the drawer of the said check at exhibit P1 and exhibit P1A, which is the drawer's signature, is his signature. Thus, the issuance of the check by the accused to the complainant has stood proof. Sapyara. The complainant as PW1 has further stated that after dishonor of the check, he got issued a legal notice to the accused as per exhibit P3 and received a reply by the accused as per exhibit P4. The accused has not denied the receipt of the legal notice at exhibit P3 by him. Rather, he himself has stated in his evidence as DW1 that to the notice at exhibit P3, he has sent a reply, which he has got produced and a copy of which he has got produced and marked at exhibit D1. The original copy of the said reply notice is also at exhibit P4, which is produced by the complainant himself.
Thus, the issuance of check, it's a dishonor. Service of statutory notice has also remained as undisputed fact, which forms a presumption about the existence of legally enforceable debt in favor of the complainant under section 139 of NI Act. However, the said presumption is rebuttable. In order to rebut the presumption, the accused has taken two defenses, one in the cross-examination of PW1 and other in his evidence as a PW1. In the cross-examination of PW1, the accused has taken a defense in the form of suggestion made to the complainant that in order to secure a site, in order to purchase a site for accused, the said check at Exhibit P1 was collected by the complainant. However, the complainant has not admitted the said suggestion as a proof. On the other hand, by making such suggestion, the second defense taken by the accused is in his evidence as DW1, where he has stated that the complainant, for the purpose of his business, in order to discount a check, has collected his check on friendship basis, however, duly assuring him, duly promising him of returning the said check immediately after accomplishment of the purpose. Stating so, DW1 has further stated that, however, the accused has misappropriated the said check and thus has caused a criminal breach of trust. DW1 has denied the said defense taken by the accused in his cross-examination. The accused who has taken these two defenses, except his self-serving oral statements, has not produced any other corroborative evidence, including any documents in support of his defense. His sole serving statement has been categorically and specifically denied by the complainant. Thus, a mere taking a contention in the form of a defense by itself is not sufficient to hold that the presumption which has already formed in the favor of the complainant has successfully rebutted. On the other hand, by taking these two defenses, the accused has himself admitted that the check at Exhibit P1 was drawn by him and he himself has handed over the said check to the complainant. Admittedly, the said check has come to be dishonored after its presentation for realization by the complainant. Though the accused in his evidence has stated that the complainant had collected the said check for the purpose of discounting the same with a promise to return the said check after accomplishment of purpose, the said defense, even if it is taken on its facial value, becomes hard to believe for the simple reason that once the check is discounted, the question of it, the same check being returning to the drawer would not arise unless the said check, when presented for its realization by collecting banker, stands dishonored. Therefore, the complainant stating that he wants the check for discounting and that you return the very same check to the accused after accomplishment of purpose also appears to be a namesake defense and an afterthought of the accused. The same could not be afterthought of the accused. Thus, both the defenses taken by the accused could not come nearer to the truth, at least in making some probability in favor of the accused so as to rebut the presumption formed in favor of the complainant. It is analyzing this evidence led by both parties in their proper perspective. The trial court has convicted the accused for the alleged guilt and has prescribed sentence and has ordered a sentence proportionate to the proven guilt, which was further confirmed in the appeal filed by the accused before the session judges court in its improved judgment. Hence, I do not find any perversity or legality warranting any interference at the hands of this court. Accordingly, I proceed to pass the following order. Dismiss ಮಾಡಿ ಇಬ್ರು ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಅಕ್ನಾಲೇಜ್ ಮಾಡಿ honorarium of 4,000 rupees each in each case and register to transfer copies. ನಿಮ್ಮದು ಇನ್ನೂ ಒಂದಿದೆ ಏನ್ರಿ? ಜಾವೇದ್ ಅವ್ರದ್ದು ಇನ್ನೂ 2 ಇದೆ. ಯಾವಾಗ ಮಾಡ್ತೀರಿ ಅದು? ಹನ್ನೆರಡು 13 2 ಮ್ಯಾಟ್ರ್ ಇದೆ ಆಲ್ರೆಡಿ ನಿಮ್ಮದು. ಇದು ಒಂದು ಅಷ್ಟು ಒಳಗೆ ಅಥವಾ ಅಷ್ಟು ನಂತರ? 14. Yes. Serial number 48. Let the counsel from both sides present. Since the court time is over, list this matter on 14/7. 49 ಕೂಸರಿ.
Number 49 is Jalil.
ಅದರಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ 14/7. 2 14/7 ಇರ್ತದೆ. ಅದೆರಡು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಬರ್ಬೇಕ್ರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇರೋದೆಲ್ಲದು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಿಯರಿಂಗ್. ಎಸ್, ಪಾಸ್ಡ್ ಓವರ್ ಮ್ಯಾಟರ್ ಕರೀರಿ. ಬೇರೆದು ಯಾವ್ದಿದೆ ಮ್ಯಾಟ್ರು? 52 ಇದೆ, 53 ಇದೆ. 52 53 ಅದೆರಡು ಸ್ವಲ್ಪ ಲಾಂಗ್ ಡೇಟ್ ಕೊಡಿ. 52 ತಗೊಳ್ರಿ. ನನ್ನ ಪೇರ್ ಲಿಸ್ಟ್ 52 53 ನನ್ನ ಕಾಲ್ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ 3 weeks. 54 ಒಂದಿದೆ ಅಲ್ವಾ? 54
petitioner, my lord.
54 you are for the petitioner.
Yes, my lord.
ಅದರಲ್ಲಿ ನಿಮ್ಮದೇನ್ರಿ ಸಬ್ಮಿಷನ್? SCGP ನಾಗೇಶ್ ಅರ್ಧ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಮಾಡ್ಬೇಕು. ಅವ್ರ ಡಿಸ್ಕಸ್ ನಡೀತಾ ಇದೆ ಅದ್ರ ಬಗ್ಗೆ. ಮೀಟಿಂಗ್ಸ್ ನಡೀತಾ ಇದೆ.
ಮೀಟಿಂಗ್ ನಡೀತಾ ಇದೆ ಅಂತ ನಾನು ಕಾಯ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಅದಕ್ಕೆ 2 days ಕೊಟ್ರೆ ಅವರು ಸರಿ ಇದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. 2 days ಟೈಮ್ ಕೊಟ್ರೆ ಏನು ಎಕ್ಸಾಕ್ಟ್ ಆಗಿದೆ ಅಂತ ನಾವು 2 days ಅವರು ನಮ್ಮ ಕಲೀಗ್ ಇದ್ದಾರೆ ರೆಡಿ. ಅವ್ರು ಏನ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ತಗೊಳ್ಳಲ್ಲ ಅಂತಾರಲ್ಲ, ಅವ್ರು ಯಾವ್ದೋ ಬೇರೆ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ
from both sides. And SCGP prays for 2 days accommodation. The matter. List this matter on 13/7. It is made clear to the SCGP that no further time would be granted in this matter. Yes.
Please, my lord.
55 ಇದೆಯಾ? ಅದೆಷ್ಟಿದೆ ರೀ? ಉದ್ದ ಅಷ್ಟು ಆ ಪಾಟಿ ಉದ್ದ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಹೇಗ್ರಿ?
Number 55
ಒಂದು ತಗೊಳ್ಳಲ್ಲ ಅಂತ ನಾವು ಕೂಗಿಸಿ ಹೋಗಿರ್ತಾರೆ ಅವರು. ಪಾಟಿನ ಕೂಗಿಸ್ರಿ.
Number 55 Padmanabad. Petitioner. From PC petitioner. Padmanabad.
ತಗಳೆಲ್ಲ ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದಾಗ ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ರೆ ಹೇಳ್ಬೇಕು, ಸರ್ ಅದ್ರಲ್ಲಿ ಒಂದೆರಡು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇದೆ, ಒಂದೊಂದು ವಾರೆಂಟ್ ಇದೆ, ಅವಾಗ ನಾನು ಅದನ್ನ ಕೆಪ್ಪ ಅಂತ ಮಾಡ್ತೇನೆ. ಏನಿಲ್ಲ, ಗೋಡೆ ಕೂತಾಗಿ ಕೂತಿರ್ತೀರಿ ನೀವು, ಏನು ಮಾಡದೇ ಇದ್ದಾಗ. ನೀವು ಮಾಡೋದು ಒಂದೇ ಕೆಲಸ, ರೆಕಾರ್ಡ್ ಇಲ್ಲಿ ಪಾಸ್ ಆಗ್ಲಿಕ್ಕೆ ಮುಂಚೆ ಅದೆಲ್ಲದನ್ನು ಫಸ್ಟ್ ಬಂಡ್ಲು ಕಟ್ಟಿ ಇಟ್ಕೊಳ್ಳೋದು. ಅದೊಂದು ನಿಮ್ ತಲೆಯಲ್ಲಿ ಕೂತ್ ಬಿಟ್ಟಿರ್ತದೆ. ರೆಕಾರ್ಡ್ ಕೊಟ್ಟಾಗ ಅದನ್ನ ಜೋಪಾನ ಇಟ್ಕೊಂಡು ಬಿಡ್ರಪ್ಪ, ಅದು ಒಂದೊಂದೇ ಮಾಡೋದು. ನೀವು ಉಳಿದಿದ್ ಯಾವುದೂ ಮಾಡೋದು. ಮಕ್ಕಳಿಗೆ ಪ್ರೈಮರಿ ಸ್ಕೂಲ್ ಮಕ್ಕಳಿಗೆ ಹೇಳಿದ್ರೆ ಸಂಕೋಚ ಆಗುತ್ತೆ, ನಾಚಿಕೆ ಆಗುತ್ತೆ. 2 ಸರ್ತಿ ಹೇಳಿಸ್ಕೊಂಡ್ರೆ 3ನೇ ಸರ್ತಿ ತಲೆ ತಗ್ಗಿಸ್ಕೊಂಡು ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ಮಾಡ್ತಾರೆ. ಏನ್ ಮಾಡ್ತೀರಾ? ನಾಚಿಕೆ ಸಂಕೋಚ ಅನ್ನೋದು ನಮ್ಮ ಸಿಬ್ಬಂದಿಗಳು ಇಲ್ವೇ ಇಲ್ಲ. ಇಲ್ವೇ ಇಲ್ಲ, ಬಿಲ್ಕುಲ್ ಇಲ್ಲ. ಹೇಳಿ ಹೇಳಿ ಹೇಳಿ, ನನಗ್ ಸಾಕಾಗತ್ರಿ. ಕೊಡಿ, ಅದೇನು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪೊಲೀಸ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್, ಅವ್ರದ್ದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬಂದಿದೆಯಾ? ಬಂದಿದ್ರೆ ಎಲ್ಲಿದೆ? ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ರಿಗಾರ್ಡಿಂಗ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಟು ದಿ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸ್ DK, ಅದು ಎಲ್ಲಿದೆ? ಅವೈಲಬಲ್ ವಾರೆಂಟ್ ಯಾವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಕೊಡಿ. Available warrant returned to this court on 1/7/2022.
None appear for petition. There are CGP for the respondent alone present. Peruse the explanation submitted by the Superintendent of Police, Dakshina Kannada District, Mangalore. By this submission dated 5/7/2020. He said the Superintendent of Police has submitted in writing that the available warrant ordered against the petitioner herein bracket accused was executed within a day by the jurisdictional police in his district. So within a day of the receipt of the available warrant by the jurisdictional police, and the available warrant was returned to this court on 1/7/2022. Next line. A perusal of the court record goes to show that registry has received the acknowledgement submission. The registry has received the execution report of the available warrant along with bond executed by the petitioner bracket accused on 1/7/2022 at 10:30 a.m. This matter was listed on the very same day. As such, on the said day, in view of the fact that the returning of the available warrant was not shown in the proceeding sheet by the registry, the court proceeded to order for issuance of show cause notice to the Superintendent of Police, Dakshina Kannada. It is repeatedly being brought to the notice of the registry, including the learned Registrar General and concerned registrars, that whenever the warrants are ordered by this court and the same are returned to the court on the very same date of hearing, immediately they have to be brought to the notice of the court without any delay, so that the court can consider them and pass appropriate order. In the instant case, though, that was listed at serial number 12 on 1/7/2022. As such, the matter came up before the court at a later time than the receipt of executed available warrant and bond by the registry could have brought the same to the notice of the court. Or at least before issuing show cause notice as per the order dated 1/7/2022, the registry could have brought to the notice of the court about receipt of executed available warrant with the bond. The registry has a dispatch. The registry has sent the show cause notice and dispatched the same only on 4/7/2022. Thus, even after receipt of the available warrant, it had available warrant before passing the order on 1/7/2022, it had 3 more days time to bring the same to the notice of the court as to issuance of show cause notice still exists. Whether as to the order of issuance of show cause notice is still to be complied with. They said inaction on the part of the registry has made this work in issuing a show cause notice to a senior police officer like the Superintendent of Police Dakshina Kannada and invited a reply from him that on 1/7/2022, when the order of bailable warrant was ordered by this court, inviting a reply from him that when Allah, by that time, the bailable order, by the time the show cause notice was ordered on 1/7/2022, the bailable warrant, the executed report of the bailable warrant was already submitted in the registry. Thus, it has put the said superintendent, office of the superintendent of police to some inconvenience and resulted in some unnecessary correspondence. Therefore, I am imposing a cost of ₹1,000 payable by the registry to the office of the superintendent of police Dakshina Kannada district, Mangaluru, which amount should reach them within 10 days from today. 10 days from today. And an acknowledgement to that effect to be placed in this matter within 2 weeks from today. The registry is at liberty to recover the said amount from the erring officials at whose dereliction of duty the execution report of the bailable warrant was not brought to the notice of the court within time. List this matter on ಇವತ್ತಿಗೆ 15 ದಿವಸ, ಇವತ್ತು 6 ಅಲ್ವಾ, ಅದನ್ನ ವಿತಿನ್ 10 days ನ ವಿತಿನ್ ಎ ವೀಕ್ ಅಂತ ಮಾಡಿ. ವಿತಿನ್ ಎ ವೀಕ್ ಫ್ರಮ್ ಟುಡೇ ಅದು ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ರೆಸೀಟ್ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಅಂತಿದೆಯಲ್ಲ, ಅದು ವಿತಿನ್ 9 days ಅಂತ ಮಾಡಿ. This matter on 18/7. ನೋಡಿ, ಈ ಪಾರ್ಟಿ ಹೈಕೋರ್ಟ್ ಅವ್ರು ಮಾಡೋ ತಪ್ಪಿಗೆ ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ಪ್ರಾಬಬ್ಲಿ ಹೈಕೋರ್ಟ್ ಈಸ್ ಪೇಯಿಂಗ್ ಕಾಸ್ಟ್ ಟು ದಿ, ನಿಮಗೆ ಹೇಳ್ತಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ, ಹೈಕೋರ್ಟ್ ಈಸ್ ಪೇಯಿಂಗ್ ಕಾಸ್ಟ್ ಟು ದಿ ಪೊಲೀಸ್, ನಾಟ್ ಇಂಪೋಸಿಂಗ್ ಫೈನ್ ಆನ್ ದಿ ಪೊಲೀಸ್. Why I do say everything has to be done meticulously, discipline must be there, orderly manner must be there ಅನ್ನೋದಕ್ಕಿಂತದ್ದು. ಏನ್ ಅನ್ಕೊಳ್ತಾರ ಪೊಲೀಸ್ನವರು, ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಆಫ್ ಪೊಲೀಸು, ನಾವೆಲ್ಲ ಹೇಳಿ ಮಾಡಿ ಕೊಟ್ಟು ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಕೈಲಿ ಇಟ್ಕೊಂಡ್ರು ನಮಗೆ ಪುಕ್ಸಟ್ಟೆ ಕೋರ್ಟ್ ಫಾಲ್ಸ್ ನೋಟಿಸ್ಗಳನ್ನ ಕೊಡುತ್ತೆ, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡುತ್ತೆ ಅಂತ ಮಾಡ್ತಾರೆ. ಇಲ್ಲಿ ನಮ್ಮವ್ರು ನಿದ್ದೆ ಮಾಡಿರ್ತಾರೆ. ಯಾವ್ದಿದೆ ಕೂಗ್ಸಿ ವಿಡಿಯೋ?
Scene number 56, Feroz Nizam, location ke
None appear for the petitioner. Learned counsel for the respondent alone present. List this matter. ಇದನ್ನ ಯಾರು ರಿಮೂವ್ ಮಾಡಿದ್ದು? You don't know. List this matter in the week after next.
for matter.
For appellate. Petitioner in this case.
JT Girisha.
Both the parties are present. It was being settled.
Serial number?
Yes, yes, yes.
ಕರೆಯೋದೆಲ್ಲ ಇವ್ರು ಮಾಡ್ತಾರೆ. ಬೆಳಗ್ಗೆ ನೀವು ಕೂತ ನೀವು ಮಾಡಿರ್ತೀರಿ ಅಲ್ವಾ? ಈ ಮಧ್ಯಾಹ್ನ ಇವ್ರು ನಾನು ಕೂರ್ಸೋ ಉದ್ದೇಶನೇ ಇವರು ಕೆಲಸ ಮಾಡ್ಲಿ ಅಂತ. ಅವ್ರನ್ನ ನಲ್ಲಿ ಕೂರ್ಸಿ ನೀವೆಲ್ಲಿ ಮಾಡ್ತಾ ಕೂತ್ರೆ ಅರ್ಥ ಇಲ್ಲ. ಅವರು ಮಾಡ್ಬೇಕು, ಗೊತ್ತಿಲ್ಲದೆ ಹೋದ್ರೆ ಕಲಿಬೇಕು. ಅದ್ರ ಹುಡುಕಿ ಅಂತ ಕೂಡ್ಲೆ ಅವ್ರು ಸುಮ್ಮನೆ ನಿಲ್ಲೋದು, ಒಂದ್ ಪೇಜ್ ನೋಡ್ತಾ ನೀವು ಹುಡುಕೋದು, ಯಾರನ್ನಾರು ಕರಿಬೇಕು ಅನ್ನೋದು ನೀವು ಮಾಡೋದು, ಇಬ್ರು ಸೇರಿ ಮಾಡ್ಬೇಕು. ಆದ್ರೆ ಬೆಳಗ್ಗೆ ಕಂಟಿನ್ಯೂಸ್ಲಿ ನೀವು ಒಬ್ಬರೇ ಮಾಡೋದ್ರಿಂದ, ಅವ್ರು ಸುಮ್ಮನೆ ಕೂತಿರೋದ್ರಿಂದ ಮಧ್ಯಾಹ್ನ ಅವ್ರು ಮಾಡ್ತಾರೆ, ನೀವು ಕೂತ್ಕೊಳ್ಳಿ. ಎಲ್ಲಿವರೆಗೆ ತುತ್ತನ್ನ ಕಲಿಸಿ ಬಾಯಿಗಿಡೋರು ಇರ್ತಾರೆ, ಮಗು ಜಗಿಯೋದನ್ನ ಕಲಿಯಲ್ಲ. ಎಲ್ಲಿವರೆಗೆ ಮಗುನ ಎತ್ಕೊಂಡೇ ಓಡಾಡ್ತೇವೆ, ದಂಬೆಗಾಲಿಡೋದು ಕಲಿಯಲ್ಲ. ಅವ್ರಿಗೊಂದು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಇದೆ ಅಂದ್ರ ಮೇಲೆ, ಆಸ್ ಎ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರು ಸಂಬಳ ತಗೊಳ್ತಿದ್ದಾರೆ ಅಂದ್ರ ಮೇಲೆ ಆ ಸಂಬಳಕ್ಕೆ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಅದನ್ನ ಅವ್ರನ್ನ ಉತ್ಸವ ಮೂರ್ತಿ ತರ ನಿಲ್ಸಿ ನೀವು ಮಾಡೋದಲ್ಲ. I am rejecting the application for the one simple reason that the petitioner appears to be in the habit of making different types of signature on different occasions. Probably that is the reason why he is accused. It is a criminal offense. A person making different signature in the same proceeding at a different point of time would be a criminal offense. Even I have got power to order for proceeding against criminal action against him. ಇದನ್ನು ಕೊಡಿ ಅವರಿಗೆ, ಇದನ್ನು ವಾಪಸ್ ಇಸ್ಕೊಳ್ಳಿ. ಬೇರೆ ಮಾಡಬೇಡಿ. ವಿತೌಟ್ ದಿ ಪರ್ಮಿಷನ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಹೌ ಆರ್ ಗಿವಿಂಗ್ ಪೆನ್? ನೀವು ವಕೀಲರ ಏನ್ ನೀವು? ಪೆನ್ ತೆಗಿತಾ ಇದ್ರಲ್ಲ ನೀವು, ತಾವು ವಕೀಲರಿದ್ದೀರಿ, ಸ್ವಲ್ಪ ಜವಾಬ್ದಾರಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಸ್ಕೊಳ್ಳಿ, ಇದನ್ನ ಕೊಡಿ. ಅದನ್ನ ಕೊಡಿ. ಸಿಗ್ನೇಚರ್ ಅಂದ್ರೆ ಹುಡುಗಾಟಿಕೆ ಏನಯ್ಯ? ಇಷ್ಟ ಬಂದಿದ್ದಕ್ಕೆ ಸೈನ್ ಮಾಡೋದು ಏನದು? Why don't I take action against him? ನಿನ್ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಯಾಕೆ ಹಾಕಬಾರ್ದು?
Learned counsel from both sides present. Both the parties to the litigations are said to have been present in the court. The learned counsel from both sides identify them as the petitioner and respondent respectively. The respective learned counsels identify their clients as petitioner and respondent respectively. To further ascertain their identity, the court obtained the signatures of the petitioner and respondent separately on 2 pieces of paper and compared the same with their signature on IA 1/22 and the wakalat filed by them. Though the signature of learned counsel for the petitioner as well, though the signature of learned counsel for the respondent as well the signature of the respondent tallies both in the wakalat as well in the application under section 147 NI Act, but the signature of the petitioner is at 3 different style with great variations to his wakalat and to the application under section 147 NI Act and to the specimen signature obtained now in the open court on a piece of paper. ಇದರಲ್ಲಿ ಪೆಟಿಷನರ್ ಅಂತ ಬರೀರಿ ಮೇಲೆ ಕೇಸ್ ನಂಬರ್ ಹಾಕಿ ಪೆಟಿಷನರ್, ಇದರಲ್ಲಿ CRP ನಂಬರ್ ಹಾಕಿ ರೆಡ್ಡಿಂಗ್ ರೆಸ್ಪಾಂಡಿಂಗ್ ಅಂತ ಬರೀ. Hence, in view of the fact that the very identity of the petitioner is not established, rather the person who is present is depicting differently through his signature in 3 different ways in the same proceeding. And also in view of the fact that the signature put in IA 1/22 by the petitioner greatly varies from the one in his wakalat in the matter. IA 1/22 stands dismissed, however, imposing a cost of rupees 5,000 payable by the petitioner to the Legal Services Committee of this court within a week from today. It is made clear that non-payment of the said cost and filing a complaint memo along with receipt to that effect in the registry would lead this court to continue its observation made today, including initiation of appropriate criminal action against the petition. Is the matter wrong?
I apologize.
Is the matter wrong?
Agriculturist.
14. 14:7. ನಮ್ಮ ದೇಶ ಇವತ್ತಿನವರೆಗೂ ಹಿಂದುಳಿತಾ ಇರೋದು ಅದಕ್ಕೆ ಅಷ್ಟೇ ಕಾರಣ. ಇವ್ರು ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಇವ್ರ ಹೆಣ್ಮಗಳು, ಇವ್ರ ಮುದುಕರು, ಇವ್ರಿಗೆ ಡಯಾಬಿಟಿಸ್, ಇವ್ರಿಗೆ ಹಾರ್ಟ್ ಪೇಷಂಟ್, ಇವರು ಈ ಜಾತಿಗೆ ಸೇರಿದ್ದಾರೆ, ಇವರು ಮೈನಾರಿಟಿ ಕಮ್ಯುನಿಟಿಗೆ ಸೇರಿದ್ದಾರೆ. ಎಕ್ಸ್ಕ್ಯೂಸ್ಗಳು ಕೊಟ್ಟು 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 ಯಾವತ್ತೂ ನಾವು ದೇಶ ಮುಂದುವರಿಬಾರ್ದು. ಹೇಳೋರ ರೀತಿ ಕುಂಟಿ ಬಿದ್ದಲ್ಲೇ ಬಿದ್ದಿರ್ಬೇಕು. ಅದನ್ನೇ ನಾವು ಹೇಳಿ ಅದರದ್ದನ್ನೇ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ನಮ್ ಬೇಳೆ ನಾವು ಬಯಸ್ಕೊಳ್ಬೇಕು. ಹಾಗೆ ಆಗಿದೆ. ವಕೀಲ್ರೆ, ನಮ್ಮ ಲಾ ಕಾಲೇಜ್ಗಳನ್ನ ಹಾರ್ವರ್ಡ್ ಯೂನಿವರ್ಸಿಟಿ ಮಾಡಿ ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ಗಳನ್ನ, ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಗಳನ್ನ ಫಾರಿನ್ ಕಂಟ್ರಿಗಳು, ಇಂಡಿಯನ್ ಹೈಕೋರ್ಟ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ಹೈಕೋರ್ಟ್ ಆಫ್ ಆಂಧ್ರ ಪ್ರದೇಶ್, ಹೈಕೋರ್ಟ್ ಆಫ್ ಡೆಲ್ಲಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಹ್ಯಾಸ್ ಹೆಲ್ಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಅಂತ ಹೇಳಿ ಅಮೆರಿಕನ್ ಕೋರ್ಟು, ಕೆನಡಾ ಕೋರ್ಟು, ಆಸ್ಟ್ರೇಲಿಯಾ ಕೋರ್ಟು, ಇಂಗ್ಲೆಂಡ್ ಕೋರ್ಟು ರೆಫರ್ ಮಾಡಬೇಕು. ಆ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಗೆ ತನ್ನಿ. ಹಾಗೆ ತರಬೇಕಂತ ಹೇಳಿದ್ರೆ ನಮ್ಮ ಕ್ಲೈಂಟ್ಗಳನ್ನ ನಾವು ಎಜುಕೇಟ್ ಮಾಡಬೇಕು. ಫಾಲ್ಸ್ ಪ್ರಿಟೆಕ್ಸ್ಟ್ಗಳನ್ನ ಕೊಡೋದನ್ನ ನಾವು ನಿಲ್ಲಿಸಬೇಕು. ಬಿಡಿ, ಕಕ್ಷಿದಾರದ್ ಬಿಡಿ. ನಿಮ್ ಕಕ್ಷಿದಾರ ಇದ್ರೆ ನಾನು ನಿಮ್ಮನ್ನ ಕೇಳ್ತೇನೆ. ಈಗ ನಿಮ್ಮ ಕಕ್ಷಿದಾರರು ಈ ರೀತಿ 3 ಬಹಿರಂಗ ಬೇರೆ ಬೇರೆ ಸಿಗ್ನೇಚರ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ವಕೀಲರ ಕಣ್ಮುಚ್ಕೊಂಡು ಕೂತಿದ್ರೇನ್ರಿ?
ಹೇಳಿ, ಅವನು ಇಲ್ಲಿಟ್ರೇಟು, ಅವನು ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟು, ನೀವು BA LLB, BSc LLB. ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ ಮುಂಚೆ ಇಲ್ಲಿ ಹಾಕ್ಬೇಕಾದ್ರೆ ಈ ಪಾರ್ಟಿ ವೇರಿಯನ್ಸ್ ಇದೆ. ವಕಾಲತ್ತಲ್ಲಿ ನೋಡಿದ್ರೆ ಬ್ರಹ್ಮನು ಒಪ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಆ ಪಾರ್ಟಿ ವೇರಿಯೇಷನ್ ಇದೆ. ಇಲ್ಲಿ ಈ ಪಾರ್ಟಿ ಬ್ಲಾಂಕ್ ಇದೆ, ವೈಟರ್ ಹಾಕಿದ್ದೀರಿ, ತೆಗೆದಿದ್ದೀರಿ, ಯಾವ ಕರೆಕ್ಷನ್ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ, ಯಾವ್ದಕ್ಕೂ ವೈಟರ್ ಹಾಕಬಾರ್ದು. ಅದರಲ್ಲಂತೂ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ವೈಟರ್ ಹಾಕಲೇಬಾರ್ದು. ವೈಟರ್ ಹಾಕಿದ್ದೀರಿ, ಸೆಂಟೆನ್ಸ್ ಇನ್ಕಂಪ್ಲೀಟ್. ಏನಿದೆ? The petitioner has paid a sum of rupees 75,000 to the respondent, and the remaining amount of rupees 1 lakh is paid him. He is paid dash ಅದಕ್ಕೆ ವೈಟರ್ him. ಏನ್ ಅರ್ಥ ಕೊಡ್ತದೆ ಇದು? He is paid by him, he is paid to him, will be paid to him. ಏನಿದು? ಇವರು ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಿದವರು ಮತ್ತೆ ಓಪನ್ ಕೋರ್ಟರ್ ಸಿಗ್ನೇಚರ್ ವೇರಿ ಇದೆ ಅಂದ್ರೆ ಪೆನ್ ತೆಗೆದು ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗ್ತೀರಿ. ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ನೆಸ್, ಒಂದು ಪ್ರೊಫೆಷನ್ ಅಂದ್ರೆ ಏನು, ವಕೀಲಗಿರಿ ಅಂದ್ರೆ ಏನು, ಗಾಂಭೀರ್ಯ ಬೇಡವೇನ್ರಿ? ಇದು ನಾನು ಹೇಳಬಾರ್ದಿತ್ತು, ಸುಮ್ಮನೆ ಇಲ್ಲಿಗೆ ನಿಲ್ಲಿಸ್ತಿದ್ದೆ ಆರ್ಡರ್ ನಾನು, ನೀವು ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರಿ. ಆ ವ್ಯಕ್ತಿಗೆಲ್ಲ ಮಾಡಿರೋ ತಪ್ಪಿಗೆ ತಪ್ಪು ಅನ್ನೋದನ್ನ ತಿಳ್ಕೊಳ್ತಕ್ಕಂಥ ಕೆಪಾಸಿಟಿ ಆತನಿಗಿಲ್ಲ. ಇನ್ನು ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ರಿ ಇನ್ನು ಹಾಗೆ ದರ್ಪದಲ್ಲಿ ನಿಲ್ತಾನೆ. ಕಟ್ಸಿ 5,000 ರೂಪಾಯಿ ಕಟ್ಸಿ, ಇಲ್ಲರೂ ಹೋಗ್ಲಿ ಜೈಲಿಗೆ. ಒಂದ್ ವಾರದೊಳಗೆ 5,000 ರೂಪಾಯಿ ಕಟ್ಟ ಹೋದ್ರೆ ಐ ಇನಿಷಿಯೇಟ್ ಕ್ರಿಮಿನಲ್ ಆಕ್ಷನ್, ಇಂಪರ್ಸೋನೇಷನ್ 199, 198, 192 IPC ಕಾಗ್ನಿಸಿಬಲ್ ಅಫೆನ್ಸ್. ಹೋಗ್ತಾನೆ ಅವಾಗ ಜೈಲಿಗೆ ಹೋಗ್ತಾನೆ. ನಾನು ಎಷ್ಟು ಲಿಬರಲ್ ಆಗಿರ್ತೇನೆ ಶಿಸ್ತಿನ ವಿಷಯ ಬಂದಾಗ ನಾನು ಅಷ್ಟೇ ಸ್ಟ್ರಿಕ್ಟ್, ಅದಂತೂ ವಕೀಲರ ವಿಷಯ ಬಂದಾಗ ನಾನು ಒಂದು ಡಿಸಿಪ್ಲಿನ್ ಮೇಂಟೈನ್ ಮಾಡ್ತೇನೆ. ನಾನು ಸುಮ್ಮನೆ ಇದ್ದಾಗ ನೀವಿಬ್ರು ಸುಮ್ಮನೆ ಇರ್ಬೇಕಿತ್ತು. ಬರೀ ಪಾರ್ಟಿ ಮೇಲೆ ಮಾತ್ರ ಹೇಳ್ತಿದ್ದಾರೆ ಸಾಹೇಬ್ರು, ನಮ್ಮನ್ನ ಸ್ಪೇರ್ ಮಾಡಿದ್ದಾರೆ, ಸುಮ್ಮನೆ ಬಿಡ್ಬೇಕಿತ್ತು ಇಬ್ರು ನೀವು. ಬೇಸಿಕಲಿ ಐ ಶುಡ್ ಹ್ಯಾವ್ ಪ್ರೊಸೀಡೆಡ್ ಇನ್ ಮೇಕಿಂಗ್ ಅಬ್ಸರ್ವೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ಯು, though not particularly against the respondent counsel, against the petitioner counsel, because you have obtained the signature of the petitioner, you have filed it. I did not make even a single word observation against the learned counsels. ₹5,000 ಕಟ್ಸಿ, ಮತ್ತೇನಾದ್ರು ಬಾರ್ಗೇನಿಂಗು ಚೌಕಾಸಿ ಕಡಿಮೆ ಮಾಡ್ಕೊಳ್ರಿ, ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಐ ವಿಲ್ ಇನಿಷಿಯೇಟ್ ಆಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಐ ವಿಲ್ ಆರ್ಡರ್ ಫಾರ್ ಇಶ್ಯೂಯನ್ಸ್ ಆಫ್ ನಾನ್ ಬೈಲಬಲ್ ವಾರೆಂಟ್. ಜನ್ಮದಲ್ಲಿ ಒಂದು ಪಾಠ ಕಲೀಲಿ, ಆತನಿಗೆ ಜೀವನದಲ್ಲಿ ಒಂದಂತೂ ಪಾಠ ಗೊತ್ತಾಗ್ತದೆ. ಇನ್ನು ಜೀವನದಲ್ಲಿ ಹೆಂಡತಿನ ಬೇಕಾದ್ರೂ ಬದಲಾಯಿಸಬಹುದು, ಸಿಗ್ನೇಚರ್ ಬದಲಾಯಿಸಬಾರ್ದು. ದಟ್ ಈಸ್ ಇಟ್. Several of the people, the known learned people also, they keep changing their signature, which they cannot do. Aadhaar card ಬೇಕಾದ್ರೆ ಬದಲಾಯಿಸಲಿ, ನೀವು ಪ್ರಾವಿಷನ್ ಇದೆ. Signature you cannot change without a due process of law. Hardly there can be any instances of changing the signature. It cannot be done. ಅಂತದ್ದು ಇಲ್ಲಿ ನಿಮ್ಮ ಸಮಕ್ಷಮೇ ಗಳಿಗೆಗೆ ಒಂದೊಂದು ಸಿಗ್ನೇಚರ್ಗಳು, ಅಷ್ಟು ವೆರೈಟಿನ ಎಷ್ಟು ಈಸಿಯಾಗಿ ಹಾಕ್ತಾರೆ. Ascertain from him in how many cases he is a criminal. I suspect ಈ ರೀತಿ ಸಿಗ್ನೇಚರ್ಗಳನ್ನ ಗಳಿಗೆಗೆ ಒಂದೊಂದು ನ್ಯಾಯಾಲಯದ ಎದುರೇ ಅಷ್ಟು ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ಬದಲಾವಣೆ ಮಾಡ್ತಕ್ಕಂಥ ವ್ಯಕ್ತಿ ಇದು ಒಂದೇ ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ, ಇನ್ನು ಬಹಳಷ್ಟು ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಇರ್ಬೋದು. ಅಸರ್ಟೈನ್ ದಟ್ ಅಂತವ್ರು ನಾಳೆ ವಕೀಲರು ಮರ್ಯಾದೆ ತೆಗಿತಾರೆ. ಕಟ್ಸಿ ಇಲ್ದ ಹೋದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಬ್ಲಾಕ್ ಮಾರ್ಕ್ ಇನ್ ಯುವರ್ ಸಿಸ್ಟಮ್. ಸೇ ಯು ಹ್ಯಾವ್ ಐಡೆಂಟಿಫೈಡ್ ಇಟ್. ನಾಳೆ ದಿವಸ ಯಾರ್ದಾದ್ರೂ ಅದ್ರದ್ದೊಂದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ನೋಡಪ್ಪ ಈ ವಕೀಲರು ಅನ್ನೋದು ಬರ್ತಾರೆ. ಅವನ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಆಕ್ಷನ್ ಪಕ್ಕ. If you fail to pay 5,000 rupees to the legal services committee within a week from today, I have given the date also. Next date ಯಾವ ಕೊಟ್ಟಿದ್ದೇನೆ? 14 ಕೊಟ್ಟಿದ್ದೇನೆ. ಇವತ್ತಿನ ಒಂದು ವಾರದೊಳಗೆ ಅಂದ್ರೆ 12ನೇ ತಾರೀಕು ಒಳಗೆ ಕಟ್ಟಬೇಕು. 12ನೇ ತಾರೀಕು ಒಳಗೆ ಕಟ್ಟಿ ಮೆಮೋ ಹಾಕ್ಬೇಕು. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಆತನಿಗೆ ನಾನ್ ಬೈಲಬಲ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತೇನೆ. ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಕೋರ್ಟ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಗಂಭೀರತೆ ಕಲಿಸಿ. ಅಪ್ಲಿಕೇಶನ್ 7 ಅಪ್ಲಿಕೇಶನ್ ಅದನ್ನ ಕಳಿಬೇಡಿ, ಅದನ್ನ ಜೋಪಾನ ಇಟ್ಟುಕೊಳ್ಳಿ. ಅದು ಪಾರ್ಟ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ. ಅದರಲ್ಲಿ ಇದೊಂದು ಸೇರಿಸಿ. Signature obtained in the blank slip which have been placed in the record as the part of the record.